Thank you. Tuesday morning, everyone. I'm Tyler Lopez. We're here for a special day now. This is closing arguments in the Aurora movie theater shooting trial. We want to make sure you're ready for what's happening next. We have a series of events that will start with jury instructions. That's expected to begin at 8:40 this morning. The latest we've been hearing from the court is that possibly as early as 10:15, we could start the actual closing arguments between the attorneys. We're going to start with the prosecution. They've got a 2-hour block to work with. They can save some time for later. The defense also gets 2 hours. And potentially by the end of the day, the jury could have the case and then start deliberations. Now, of course, this case has been marked by conflicting testimony from experts, psychiatrists in the field dealing with schizophrenia. That's the claim that the defense team has continued to say that he has schizophrenia, that he was delusional at the time, nearly 3 years ago, when the shooting did take place. Here now is some of the testimony from those doctors that clearly mark this entire case.
I want to start where Mr. King left off last night, okay?
Okay.
Do you remember the question that was posed to you was, but for the defendant's mental illness, whatever that may be, this crime wouldn't have been committed and we wouldn't have been in this room. Do you remember that?
I remember that.
The question is not, did the mental illness affect Mr. Holmes' thinking on July 20th, but to what extent did it affect his thinking and functioning, correct?
That's fair to say, yes.
And it's your opinion, sir, that absent his mental condition, we wouldn't be here at all, would we?
That's a true statement.
This crime would never have taken place without this mental illness.
That's true, in my opinion, yes.
Thank you. I have no questions today. This is a good place to break, Judge.
Yeah. Tell us, are you saying that this mental illness caused the crime and caused us to be in this room?
Without the mental illness, we wouldn't be here, just as without his moving to Colorado, we wouldn't be here, or without his being accepted for the grad school, we wouldn't be here.
Well, let me go a little bit further. But for his girlfriend dumping him, and maybe had she still been in a nurturing, long-lasting relationship through May, June, and July, could we say that this wouldn't have happened?
I wouldn't go so far. He was planning pretty carefully. Anything's possible. Certain things may have changed, but I don't think that was a big part of why he did this.
But for his conclusion that he had no career in science.
It's part of the overall picture. I don't believe, once I say anything's possible, I don't believe that his ending up with that thought, particularly as of June, that would have stopped what was already started.
In terms of there is nothing else that would have stopped this.
I'm not sure I understand.
Well, I guess I'm asking, look, if his girlfriend's with him and they're in a long-term nurturing relationship through May, June, and July, is he able to pull this off?
Objection calls for speculation.
Sustained. And forgive me, Your Honor, I'm asking in the context of his but-for analysis.
Rephrase the question.
In terms of this but-for analysis, had but-for his girlfriend not being close to him and in a nurturing relationship through May and June and July as he planned for this massacre, it might not have happened, right?
Objection. Asked and answered. Leading.
No, it's not asked and answered. It's a little different than the question that was asked and answered. So that objection is overruled. It is leading, so I'll sustain it on leading, but you can rephrase the question.
I get it. I think I know where we're going. In your report, the one that the question got asked from yesterday, talk to us about whether or not you think there's a direct causality between the mental illness and the voluntariness of the defendant's actions on July 19th and July 20th.
I do not believe there is a direct connection between the mental illness and the voluntariness. I believe there is a substantial relationship between the presence of the mental illness and the eventual carrying out of the event.
And in part, it's because his desire to murder was something that we've determined was delusional.
Objection. Leading.
Sustained.
Is it because part of his, or a big part of his motivation to want to murder was something that we've determined was, or you've determined was delusional?
Some part of it was, and if I'm understanding your question right, that's related.
Understood.
But my main thing that I think goes to this is that the mental disorder that I believe he has affected the course of events. It did not affect, in my opinion, his capacity to voluntarily or knowingly, the capacity to do those things.
And when you say capacity, are you talking about the capacity to know right from wrong based on societal standards of morality?
Yes.
And the capacity to form the intent to murder after deliberation and to act knowingly in setting up the booby traps in his apartment?
Yes.
The mental illness didn't impact that.
It
Didn't
did.
interfere with it.
Objection leading.
It's a follow-up to the question that has already been answered, overruled. Go ahead.
It did not interfere with that, in my opinion.
How confident are you, in your opinion, that on July 19th and 20th, 2012, the defendant had the capacity to know right from wrong based on societal standards of morality?
Extremely confident.
How confident are you that on those same 2 days, as the defendant went into the theater to pull the trigger more than 70 times, that the defendant had the capacity to form the intent to murder after deliberation and to act knowingly with regards to setting up the booby traps in his apartment?
Extremely confident.
And finally, Doctor, how confident are you that on July 19th and 20th, 2012, the defendant was legally sane?
Extremely confident.
I have nothing further. Dr. Messer, in light of all of the stuff that Mr. King just went through with you and all the different possibilities from suggesting that something else was to blame for it or something else could have caused it or all these different scenarios, including the drunk driving one, has your opinion changed one whit that this guy right here had the capacity to know right from wrong based on societal standards of morality when he walked into that theater on the 19th and 20th and tried to murder the theater full of people?
It has not changed.
You still extremely confident in it?
Yes.
How about the other prong? Anything about what Mr. King brought up to you or threw out as possibilities that changes your extreme confidence in your previously stated opinion that this guy had the capacity to form the intent to murder after deliberation and to act knowingly with regard to all the other alleged criminal conduct?
My opinion hasn't changed, and my degree of confidence hasn't changed.
In fact, had you considered all of the things that Mr. King had just brought up in cross-examination in formulating your expert opinion on the matter of sanity?
I believe so.
There was another portion of the exchange here towards the end where you were confronted with other hypothetical facts from this. For instance, had the defendant actually made an assessment that he could get away and had driven away, how would that impact? Do you recall that exchange?
Yes.
I want to give you a different hypothetical that touches upon that. If you had had a hypothetical where the defendant on the same day goes to a gun store, purchases an AR-15, buys ammunition, carries it out in broad daylight, walks across the parking lot to, let's say, a theater, walks in broad daylight, does nothing to be surreptitious or cover up what his plans are, goes and even gets a Coke to drink, walks into the theater and starts shooting folks from that regard. Are those facts distinguishable enough from these that they begin to suggest that maybe this guy doesn't know right from wrong on a societal standard of morality?
They would be.
When you are considering this crime, are you focused on one, two, or three things? Or do you look at a global perspective of all the decisions that were made by that guy right there?
You look at the totality of the circumstances, so it's not based on just one factor.
And I want to make sure that I'm clear on this too. We keep saying psychotic and psychosis, and those are the right terms, I get that. But they all flow from the delusion, is that right?
Yes.
And I want to make sure I know what the delusion is. Is the delusion that he thought he would feel better and his value would increase the more people he killed?
The delusion was that he would increase his self-worth by killing people. And a secondary thought he had about that is that this would help him become less depressed. So there are really two aspects of it.
Is it accurate or fair to conclude that the defendant then made a decision to substitute human lives for his increased self-worth and feeling better?
Objection. Calls for an improper opinion.
Overruled.
Go ahead, sir.
I think that's accurate.
Describe this anxiety and this inability to communicate with other people. Did he describe it as something that he enjoyed or something that was difficult and troubling to him?
It was very difficult and troubling to him. Yes, and here he also noted that it had impacted his social relationships. So that was a distressing thing to him too.
Did he indicate whether or not the anxiety increased when he went to high school from middle school?
Yes, he indicated that it continued to increase basically throughout all this time through middle school, high school, and then he indicated it increased again during his graduate school program.
Any details on how it affected his graduate school program?
Yes, he used the words, he said, reading from my notes, social atmosphere magnified, and he felt barraged. And that had to do with the ongoing interactions that were part of the graduate school curriculum. So he felt barraged by the anxiety.
We were also talking about these homicidal, intrusive thoughts that he described that started occurring back when he was a schoolboy. And you were describing what the nature of that ideation is. Did he talk about a attempted suicide or something that happened regarding suicide?
Yes, he mentioned that at one point he had used cardboard to cut his wrists. He called that a parasuicide, and he identified that as a cry for help. And he said that the homicidal ideation had increased when he couldn't kill himself.
I apologize for that. What did you make of, well, first of all, what do you make of somebody at that age even thinking about suicide? Is that psychiatrically significant?
It's very significant, yes. It's very unusual as well.
How so?
Well, it doesn't happen a lot, and when it happens, it indicates that there's a significant thing wrong. Looking back at the information that I had about that, I would have trouble coming up with a specific diagnosis for that. I think usually schizotypal personality disorder, for instance, might cover it, but we usually don't apply personality disorder diagnoses at that age. So it's a fairly unusual kind of thing, but it certainly can be characterized as social anxiety with difficulty with socialization, poor social skills, and associated intrusive suicidal and homicidal ideation. So that's really the characterization of it, and it probably would be considered by some people even at that age and with those degree of symptoms to represent a schizophrenia spectrum disorder, even at that age.
In describing these intrusive homicidal thoughts that were unwanted, did he talk about whether they were directed at specific individuals? Like, was it somebody that was around him in his life or at the time, or was it more of a generalized thing?
Yes, he again volunteered information about that. Reading from my notes, homicide against everybody or else the world, never against specific people, always impersonal. Standard teen nuclear bomb, unrealistic. he's talking about, those are from my notes, it's not verbatim. He's saying that he didn't have a specific plan to kill anyone, that he felt that this was a general urge or impulse to kill people at large.
Now, is a certain amount of ambivalence, can a certain amount of ambivalence be part of the psychotic process in terms of receiving treatment or help, or?
It's almost always a part of the psychotic process. It's very hard for people with these types of illnesses, usually, to voluntarily seek help and to participate fully in the help process. There's something about the illness that just resists this sort of intervention.
Is then the compulsion or the loss of control to do the mission, meaning the mission has to be carried out exactly the way it's planned? Is that part of the psychotic delusion?
Yes. If the mission is not carried out, it's not mission accomplished.
So is that why we have the planning and wait till July 20th before the shooting takes place? Is that why it doesn't happen earlier?
Yes.
Sustained.
Is that or is that not why it happened earlier?
Yes, it is.
Now this hair plucking and this other focusing on schoolwork and video games, now that doesn't make a lot of sense to me. And so maybe you can explain that, because is that something he thought of, like, oh, I'm having unwanted thoughts of homicide and I'm a sophomore in high school, I know what I'll do, I'll pull my hair out and that will make the thoughts go away. That doesn't make a lot of sense to me.
Overruled. You can answer.
Can you explain that to us?
Yeah, it doesn't happen the way you said it. It's not a deliberate psychosis, is not a deliberate process that somebody brings upon himself or herself and calculates at each step of the way, this is how I'm going to react. The thought comes, it's an intrusive, unwanted thought. I mean, trying to imagine that you're sitting at home, trying to work on your homework, you're not in school, and suddenly the thought, kill yourself. No, kill other, kill yourself, kill other. And he developed his way of coping with it that worked for him. He took it away from him, namely, focus on, do your homework now. And he will notice, when describing it later, that when he was busy doing his homework, the thought will go away. When he was playing computer game, it will go away. When he will pluck his hair, it will go away. And with this, when the thought will come, he was doing what he could do, what within his ability to do, secretively. He will not pluck his hair when other people will look at him. He will do it secretively. He will go to the side and do it, because he did not want other people to see and think that he is crazy. He was checking the different diagnostic. Remember, we are dealing with an individual with high level of intellectual functioning and in the internet available. Somebody was studying biology and wanted to be a neuroscience major. He knew about the brain, and he began to read about it more and more and realized something is really wrong with me. And this is something that he had to hide, and that's not different from other people with schizophrenia. They deny their illness. This is the major difficulty that we have as professionals, not in the criminal setting. It's very similar in the sense that people we see will say, I'd rather die than you tell me that I have schizophrenia. They deny the illness. There's tremendous stigma and fear of it among people. And the people who develop it notice it. They know I'm losing it. I'm different than everybody else. And that's what he was experiencing.
Now, he made a statement to you, did he not, in the course of this first interview, when you asked about a movie. Did you ask him about why a movie theater?
I'm trying to remember if it was in the first.
Jury. Let me run through a few things before we take a break, a short break, and bring the jury in. First of all, I want to make a record about the discrepancies regarding exhibits that were referenced by Ms. Nelson last week. My understanding, Ms. Nelson, is that you discussed the issue with the prosecution, and then the two parties discussed the issue with my staff, and all of the discrepancies or the what the parties believe were discrepancies have been resolved, and we're actually all on the same page in terms of what exhibits were admitted and what exhibits were not. Is that correct?
Yes.
All right. And is that the people's understanding as well?
Yes, it is, Your Honor.
Okay, great. And that's the result of a lot of effort, not only by the parties, but by my staff, and I appreciate that. When you're dealing with thousands of exhibits, to have all three entities, if you will, at the end of the trial, all be on the same page in terms of admitted exhibits and exhibits that were not admitted, is, I think, a reflection on how seriously everyone took the record keeping with respect to exhibits, so I appreciate that. I wanted to make a record about some of the exhibits. As you know, I'm going to be sending back to the jury room during deliberations all of the exhibits that have been admitted, except for live ammunition. And it's my understanding that there were some exhibits that contained live ammunition that were stapled to other exhibits. So what I decided to do was temporarily unstaple those exhibits that had live ammunition and document it. And so my staff has documented that. That way we can send the exhibits that should be sent back to the jury during deliberations. And then the ones that should not be sent to the jury, we can exclude, we can keep out of the deliberations room. So just so that you know, I wanted to let you know, but we were careful to document any time that happened. I think it only happened once. So there was only one case where there was live ammunition that was attached to other exhibits that were admitted. So I wanted to make a record about that to let the parties know about that. The next thing on my list are the jury instructions. The record should reflect that late yesterday, my staff emailed to the parties a final set of the jury instructions. And there were two versions that were emailed. One was in Word, and it did not have the blank spaces filled in. The other one was scanned. That one had all the spaces filled in by hand, and I'm the one who filled all the blank spaces in. So I wanted to make a record of that. Same thing with respect to the verdict forms. Late yesterday, my staff emailed the parties a Word copy of all the verdict forms. I think it's approximately between 600 and 700 pages. I think 658 pages or something along those lines. So it's quite a document. It's very voluminous, and that's because we have 165 verdict forms, and each verdict form has approximately 4 pages. Although I think that there's one that only has 3. So I wanted to make a record about that. Having said that, I want to know whether there's any additional record that the prosecution wants to make with respect to the jury instructions. Mr. Orman?
No, Your Honor, actually, I have a question about the verdict forms, if I may ask.
Yes.
Because each verdict, the second, third, and fourth page of each verdict form does not have that, as I can see it, like a page designator saying this is for count 153 or something like that, and I understand why that is. I was wondering, when we send back the verdict forms, is each individual verdict form going to be stapled? So, because I could see those pages getting mixed up somehow or something like that.
Yes. And we're only gonna do that with respect to the set that we're gonna send back to the jury. And the jury's only gonna get one set. And you may have noticed that on the sample verdict forms, we have watermarked each page with sample so that there's no confusion later. The sample verdict forms are 5 verdict forms that, as the parties know, I chose to go over with the jury when they're here, when I go over the instructions and the verdict forms with them. That way I don't have to read 650 some odd pages. So but they're clearly watermarked samples so that there's no confusion. But we will staple each verdict form, all 4 pages or all 3 pages in one case of each verdict form before we send them back to the jury.
Thank you, Your Honor.
Okay, now back to the instructions, Mr. Orman. You said no other record with respect to instructions. Any other objections that you want to make or any other instructions that you want to tender?
Your Honor, apart from what we said before, I am not requesting any additions, deletions, or modifications of the instructions or verdict forms as they have been provided to us.
And any record with respect to the order of the instructions?
No, Your Honor.
Any other record with respect to the verdict forms?
No, Your Honor, thank you.
All right. Same questions for you, Ms. Nelson. Any other record you want to make with respect to the jury instructions in terms of modifications, additions, deletions, any other objections, anything like that?
Nothing additional, Your Honor. We maintain all of the previous objections that we stated.
That reminds me, I forgot to ask you yesterday. I think I'm confident in the answer to the question, but just so that the record is clear, you are requesting that I instruct the jury about your client's constitutional right not to testify, correct?
Correct.
Okay, thank you. Any other record that you want to make with respect to the order of the instructions, Ms. Nelson?
No, Your Honor.
Any other record that you want to make with respect to the verdict forms?
No, Your Honor. We maintain all of the previous objections that have been stated on the record.
Okay, but nothing additional?
Nothing additional.
Okay, thank you. Next, I want to make a record about D-TR-94. Mr. King, it's my understanding that you've rescued this exhibit?
Approach, Judge?
Yes. And would somebody from the prosecution approach too, please? Was there any other record that either side wanted to make, or is there anything else we need to talk about before we take a short break? On behalf of the people,
Your Honor, thank you.
on behalf of the defense, Mr. King?
No, Your Honor. We've just exchanged PowerPoint slides with Mr. Brockler and I, and we're going through them now to see if there's any objections.
Okay, if there's an issue I need to take up before I bring the jury in, I'll send my staff out before I take the bench so that you can let my staff know. Obviously, I've given you rules throughout this process, at each juncture of the process. You folks have been professional throughout, and I appreciate that. I'm expecting the same professionalism from both of you during the closing arguments. If you have an objection during closing argument, state your objection and the legal grounds for the objection. Please avoid speaking objections. If you need to approach, just say, Judge, can we approach, so that you can explain. Obviously, you can, if it's something that's mild and that's short, you can say it. Something that goes to the legal basis of the objection, that communicates to me what the grounds of the objection is. Same thing with a response. If you have a response to an objection, as long as it's simply stating what the legal grounds of the response are, or simply stating in brief what the response is, you can do it. Otherwise, if you need to explain, I ask that you request to approach the bench, and we'll take it up at the bench at that point. All right? Is there anything else before I take a recess? No? All right, I'll take a recess. Let you folks review the exhibits or the demonstrative exhibits, and then we'll proceed from there. All right, the court will be in recess.
And good Tuesday morning, everyone. I'm Tyler Lopez. It's been nearly 3 years getting to this point, but we are now on the verge of starting with closing arguments in the Aurora movie theater shooting trial. More than 45 days of witness testimony. The judge talking about whether or not there are any objections this morning before they proceed to start to read all the various jury instructions that will be so key to this case, as the jury will hopefully have the case by tomorrow morning. So next up, reading of the jury instructions. But we thought this would be an appropriate time to take a look back at what we've all been through. So many hundreds of people involved in this case in so many different ways, with a case that dates all the way back to April 27th. That's when it all started. Here now is a look at those opening statements. Might provide some insight as to what we can expect to see today in closing arguments.
On a cool July night a few years ago, about 13 miles from where we sit right now, 400 people filed into a box-like theater to be entertained. And one person came there to slaughter them.
Aurora 911, where's your emergency? I can't hear you. What address? Theater, Aurora, Colorado. Yes, but I can't hear you. Give me the address again. There's gunshot. What address? Say it loud.
The man that came there that night, covered head to toe in armor to protect him from any injury. The man who brought with him 4 weapons and hundreds of rounds of ammunition. He's in the courtroom with us today. Now, what I'd like to do is just talk to you about victims in this case. What I'd like to do is to focus us on those who were most affected by this conduct. But here's the thing. He made so many victims that if I were to stand here and merely spend 1 minute per victim telling you about them, about how they got to the theater that night, and about what he did to them, I would be here for almost an hour and a half. I can't do that. But what I can promise you is that before this case is over, you will hear from or about every one of them. Rebecca Wingo. Rebecca is a 32-year-old mother of 2 young girls. She had been in the military, but had hopes of doing something else, becoming a social worker. And on this particular night, she comes to the theater with a friend. Michaela Medic is 24. She's a local girl. Graduated from Gateway High School early, took her GED. She was taking prerequisite classes at college, wasn't sure what she wanted to do yet, but she worked at Subway. And on this particular night, she and her friends decided they wanted to go to this premiere of The Dark Knight Rises. They get there. The only seats that are available to them suck. They're 3 rows off the screen, and they're horrible. But she and another friend out of that group of 5, just as the theater's about to get dark, look back. And they see 2 open seats, about 4 rows from the top, and they take them. He pleaded not guilty by reason of insanity, and there were 2 psychiatrists about a year apart, asked to do independent assessments and evaluations of him. Jeff Metzner and William Reed. Those psychiatrists, those expert forensic psychiatrists, were not picked by the people of the state of Colorado. They were not picked by the defendant or his attorneys. They were picked by the Colorado Mental Health Institute of Pueblo, the state mental hospital, at the direction of the court. And both of them say the same thing, that guy was sane when he tried to murder all those people in that theater back in July of 2012. They each spent a great deal of time evaluating the defendant. Do something that you want to do that's fun. She knows he's been having a tough time. This is what she says here. He says, well, look, what I really want to do, I can't do because it's evil. She says, well, and he says, I can't do that. Well, what do you feel like doing? Video games are the next best thing. They're escapism. What's so evil that you want to do? And you know what he says? Kill people, of course. She thinks this is just theoretical based on all of these other conversations they have, so she engages him. Killing people's too much effort. You'll end up locked up. Most people aren't worth the effort. He says, well, that's why you kill many people. Again, she thinks it's theoretical, and they continue to have a conversation. He invokes justice, saying taking away someone's time or life. And in fact, if you wait to kill to the end of your life, then there's nothing to lose. They begin to have a conversation about the value of life. And he says, what's more valuable than life? If you take that away, you take away everyone's experiences and all of their potential. And she asks about that, and he talks about it being human capital. And she says, what is human capital? What do you do with that human capital from having taken away people's lives? And he says, have a more meaningful life. And she doesn't get it. How does that work? And he can't explain it to her other than saying, this is what he wants to do. She says, it may satisfy you, but it doesn't fulfill your purpose. He says, but it'll still make my life more meaningful. And she still thinks this is just a theoretical conversation. She says, I don't see how it's useful. She confronts him and says, it's not like by killing people, you get the benefit of anything from them. You're not stronger. You're just taking away life. And that seemed like destruction. And he says, look, I don't believe in absolute good or evil. She says, well, if that's the case, why don't you kill me and Ben, their mutual friend, who wronged him, she, by breaking up with him? Why don't you do that? He says, I told you I can't do that. If I did that, I'd get caught, and I couldn't kill more people. I'd also lose the rest of my life. He says that it's a circle, a tautology, saying that the meaning of life is to live. He recognized that long ago. But you know what he's missing? A purpose. A purpose. He says, I'm not inherently evil. My outlook on destroying life is only plan B. I do have a plan for good. And she asks, what's your purpose for good? And he says, are you sure you want to know? You don't just want to find out? And then she says, hey, can we continue talking about this later? Because it's just theory. Ben's coming to pick me up. He responds with, Ait, you want to come play some Dom? That's a board game that they play at his house, that they've all played for a long time now. She says, I got some things to do, but after that we can. And that conversation is left like all the others. By the time he gets into that theater on July the 20th, there is not a millimeter of flesh that isn't covered by some protective armor or piece of clothing. But he also buys some clamps. These clamps that he's going to use for a tablecloth, he manufactures into the device he uses to keep the exit from the theater from locking behind him when he goes out to get dressed in his kill suit with his weapons while the previews are playing. It's like 15 or 20 minutes into the movie. He starts with the shotgun, and he begins to pull the trigger. This shotgun. Boom! A.J. Boyk, who had been sitting with his fiancée, is hit and killed as 14 pellets penetrate his brain. Boom! our Air Force soldier, Jesse Childress, who had come with his friends and purchased their tickets. He too is hit by the shotgun blast, and it rips through his lungs, heart, and organs, and he dies.
When James Holmes stepped into that theater in July of 2012, he was insane. His mind had been overcome by a disease of the brain that had plagued him and pursued him for years. In his words, I have fought for years and years to overcome my biology. But in the end, when florid psychosis erupted in 2012, he lost that struggle. He lost that struggle in his mind to a disease called schizophrenia.
We just want to make sure that your hands are protected. Yeah. Do you know what this is for?
That's what I'm asking.
Huh?
That's what I'm asking.
What do you think it's for?
Popcorn.
For popcorn?
Yeah.
Could be used for popcorn.
For the first time doing anything wrong in 24 years, steps into this movie theater and commits this unspeakable crime for no reason. The reason is that he has a psychotic delusion that he thinks it will somehow increase his self-worth, his human capital. It's nonsense. But to him, it was so real and so powerful that nothing else mattered.
His thinking was diseased. His thoughts were telling him things that weren't true, and his thoughts were telling him that he was in a life struggle that had no basis in reality, didn't exist in reality, but to him, he believed it with every fiber of his being.
And good Tuesday morning, everyone. It's 9 o'clock. We're taking a break now as we anticipate the reading of jury instructions as we've now reached a milestone in the Aurora movie theater shooting trial. We are set for closing arguments today. Catherine Spengler speaking, preceded by Daniel King, lead defense attorney for the defendant. Interesting choice and interesting observations you can take away. These are the openings from April 27th, and you notice a difference in the cadence and the pace with which they made their argument before the jury. Daniel King, much longer pauses, telling the jury that the shooter was pursued for years by psychotic delusions. Schizophrenia was his big problem, that there was no reason for what he wanted to do other than to increase his human capital, which he even just said was nonsense. Preceded then by George Brockler, DA for the 18th Judicial District. A lot of passion in his voice, keying in on the victims and what they've been through. Now we're anticipating the reading of jury instructions soon, but we want to take a look back at what we noticed during the course of this trial, which started way back in April. And that's the way the first responders and the investigators went to that theater to try to collect all of the evidence involved to get us to this point so we could have a trial. Take a listen.
One of my trips back into the theater, following a trip outside for triage, someone had brought Veronica Mosier down to the front of the theater from farther up while they were treating other people. She was just inside the door when I walked in. I bent down, felt for a pulse. There was no pulse. The only wound I could see was a wound in the abdomen on the right-hand side. At that point, I saw Sergeant Hawkins, who was an officer at the time, coming down the stairs. I got his attention, said, I want her triaged, I want her out of here. He picked her up and carried her out. He felt for a pulse. Later had mentioned that he thought he felt one, but he hadn't because his own pulse or something to that line. But
even though, when you first saw her, did you feel that she was still alive?
No.
Given that, why did you choose to not leave her in the theater?
Her age. I wasn't keeping a child in my crime scene. You know, if there was any possibility she needed to go. I didn't want my officer stepping over her. I didn't want her at the scene.
My next recollection is Sergeant John's guard motioned me over, and there was a girl about 6 years old on the floor.
Did he ask you to do something with regard to this little girl?
Yes, he lifted up her shirt and showed me where she had been shot once in the abdomen. And I tried to obtain her pulse, and I could not.
Why not?
At that point, my own hands were really tingling and pulsing, I would guess from adrenaline.
Were you asked to do something with regard to her?
Yes, Sergeant John's guard yelled for me to get her and go.
Did you do that?
Yes, I did.
And you picked her up?
I picked her up and I ran out of the front entrance of the theater.
Were there paramedics around?
Yes, yes there were.
Were you aware of whether or not they transported her?
I was aware of the way they looked at me, that she had probably died, and they did transport her to Children's Hospital.
Did you ever learn who that child was?
Yes.
And who was she?
It was a little girl named Veronica Mosier.
After you had taken Veronica Mosier, and she also known as Veronica Mosier Sullivan,
Yes, ma'am.
after you had taken her outside, what did you do?
After I placed her on the pram of the ambulance, I turned around and went back to the theater, at which point I encountered two girls carrying a teenaged black boy who had been shot in the leg. And I said, "Can I help you girls?" And they gave him to me, and I carried him over to where a fire engine was. And I set him with other wounded people next to the fire engine.
So when you start to place the rods, can you place a rod in every impact or every hole that you find in a seat or in the walls of the theater?
No, ma'am.
Why not?
Well, depending on the size of the holes, depending on how large it creates, as a bullet travels and it starts hitting intervening objects, it actually starts deforming, and as it keeps traveling, it might, depending on the type of material, it might blow out. We call it, or refer to it as blowout. The hole is so large, you can't even use a rod. You could stick a rod in there, but it's not going to provide you a trajectory. Other times, say with an impact into concrete, we know it's where a bullet's impacted itself, but there's no way to actually put a rod in there to basically get an angle off of the rod itself. Nothing will hold it. So normally we need multiple holes, or at least a material that we can stick a rod into and it maintains its directionality.
Does that mean that you can have more holes and impacts in a theater than you will be able to build trajectories from?
Oh, yes, ma'am, most definitely.
And as a result, when you've finished creating trajectories, will you have a trajectory for every bullet that's been fired in the theater, for instance?
No, ma'am, not at all.
How did you determine that some of the holes or impacts that you were seeing were not going to be ones that you could put a rod into?
Depending on the type of material, there was, the seat consisted of fabric, and then it was foam, and then there was a laminate veneered wood that was the back. The bottom portion of the seats themselves it was a molded steel pressed, then there were springs, and then there was actually foam, and then the fabric on top of that. When some of the projectiles were traveling through, they might have penetrated the bottom of the seat if the seat was up, would have hit the spring, ricocheted off into somewhere. There was no exit. So I could put a rod in, but the question is that depending on this big hollow seat bottom, I could rotate the rod every which way. I'm not going to be able to give an accurate reading or trajectory off of that. So that would be one I would have to disregard.
Do you need to have both an entry and an exit in order to successfully plot a trajectory?
Depending on the material, yes, ma'am. If it is, wood is very good for scenarios with drywall. Houses are very good. If you shoot into a stud, you can actually feed in a rod into that stud and it will hold it perfect if it goes deep enough.
Now, with regard to, we've seen pictures of a number of little flags in the theater.
Yes, ma'am.
So do those show any kind of a trajectory?
I had to use those. They were trajectories of the pellets out of a shotgun shell. The holes, pellets are extremely small, so for any of my rods that wouldn't work, we were actually using engineering flags that would actually insert into the fabric, into the foam, and it, depending on how deep it penetrated the wood, we could actually insert it. But the pellets never actually exited out the back of the wood panel, so there was no through and through. So that's why we were actually using flags, so that you could see the directionality of the pattern.
Once you had the rods in place, were photographs taken to show what they looked like in the theater?
Yes, ma'am.
Your Honor, may I approach the witness and hand him what have been marked as People's Exhibits 3622, 3601, 3640, 3643, 3645, 3649, 3702, 3632, 3736, 3734, 3749, 3748, and 3741.
Yes, you may.
Do you recognize all of those photographs?
Yes, ma'am, I do.
Do they fairly and accurately represent your work in the theater in July of 2012?
Yes, ma'am, they do represent my work.
Your Honor, I'd move for the admittance of the photographs I've tendered to the witness.
Ms. Spengler, do you have any objection to those exhibits being admitted?
No.
Without objection, P-TR-3622, 3601, 3640, 3643, 3645, 3649, 3702, 3632, 3736, 3734, 3749, 3748, and 3741 are admitted and may be published.
Could I have 3622 first, please? What are we looking at in this photograph?
This is the a photograph taken from the front of Theater 9, going back toward the projection room. The flags that you see, the rods that you see, and the little white rectangles are the labels of the bullet holes and impacts.
Could I have 3601, please? And in this photograph, do we see predominantly flags as opposed to rods at this point?
That is correct, yes, ma'am.
And what do the flags represent?
The flags were the shotgun patterns that are visible in 4 of the seats and along the right-hand wall that you see up there.
Could I have 3640, please? Now, is this the first row of the stadium seating?
Actually, it's row 8. Yes, ma'am.
First row of the stadium seating. And what are we seeing in this photograph?
This is a side view of the seats with trajectory rods, lasers, and the engineering flag showing a shotgun pattern.
Could you point out a laser to us? The mouse actually works on this screen in front of you, I believe. And
it's a little
it's a little sensitive.
All right, this that you see right here is a red laser. The other one that you see over here is a green laser. Different light amplification.
So we're looking at something that's been attached to a white piece you're pointing to that's been attached to the end of pink rods and...
Yes, ma'am. They're threaded so that you can screw them onto the tip of a rod itself.
Now, you've indicated one is red and one is green. What is the difference in those two colors in terms of what they do?
A green laser, because of the different light amplification, can travel farther and give a stronger beam. For my purposes, there's really no difference. They don't denote anything different.
Why did you use both colors?
I used every laser that I had in order to basically plot and do my job.
Could I have 3643, please? Now, is this the next row up, row 9?
Yes, ma'am, that is correct.
3645. And is this row 10?
Yes, ma'am.
And are we seeing both flags that represent shotgun, and I don't know, am I calling it impacts or holes? To use the right terminology.
Well, there were actually holes. They just, they ended in an impact on the back of the seat, but they are holes in there, into the cushions.
And additionally, there are other rods in that row?
Yes, ma'am.
Could I have 3649? Is this the next row, row
Row 11, yes, ma'am.
3702? What are we looking at in this photograph?
This is from the right-hand side of the theater. I believe we're probably up around, I would say, row between 15 and 18. In the background, you can see, if I can get this to move, this is a shotgun pattern into the left-hand wall of the theater. Here's a better view of a green laser. Again, we also have flags representing a shotgun pattern itself, ma'am.
3632? Where are we in terms of within the theater, looking at this photograph?
This is the hallway on, if you're facing the movie screen, this would be the left-hand side of, it's a ramp walking into the theater itself, and these are trajectories as they come through.
And is this the wall on the right-hand side of this photograph that adjoins Theater 8?
Yes, ma'am, that is correct.
And in the foreground of that picture, I see a green, is that a green laser attached to a rod?
Yes, ma'am. There's 3 green lasers, actually 4 in the picture itself.
3736? And if you could explain what we're looking at in this photograph in the lower on the seat.
In this, you have
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Would counsel please approach so that we can complete the record on D-DR-94? Okay, let's bring the jury in, please. Sure. Please be seated, everyone. The record should reflect that the jury is now present in the courtroom. Good morning, everyone. How are you folks doing? Good. I hope you got some rest over the long weekend that you got. Before I distribute the instructions and the sample verdict forms to you, I want to remind you about a couple of things that I mentioned before opening statements and perhaps before group jury selection because it's been a few months now. I want to remind you that there are 165 charges filed in this case. Each charge is contained in a count in the complaint, and so there are 165 counts. Because count 142 was skipped, the number was skipped, it shows 166 being the last count. And I want to remind you that there are 165, even though the last one's going to say 166. There is a verdict form for each count. Therefore, there are 165 verdict forms. Rather than go through all the verdict forms, I have randomly selected 5 sample verdict forms. And so there is no confusion at any point. We have watermarked each page sample. So it'll be clear that these are sample, and we're going to distribute this to you in a moment. And I'm going to go through those 5 sample verdict forms. The reason I chose 5 sample verdict forms is that there are really 5 types, if you will, of verdict forms. You will remember that I indicated to you that the 165 counts in this case, or charges in this case, include 2 charges for each deceased listed victim. And there's a count of murder in the first degree after deliberation and a charge of murder in the first degree extreme indifference with respect to each deceased individual. You'll remember that I explained to you that the prosecution in this case is pursuing 2 theories with respect to 2 theories of first degree murder with respect to each deceased individual. With respect to each of 70 listed victims who are not deceased, the prosecution is pursuing 2 theories as well. Attempt to commit murder in the first degree after deliberation and attempt to commit murder in the first degree extreme indifference. So you multiply the 12 times 2, that gives you 24. You multiply the 70 times 2, that gives you 140. And then there's 1 count of possession or control of an explosive or incendiary device for a total of 165 counts. Does that make sense to everyone? And everyone's nodding their head yes. And you'll be asked to deliberate with respect to each one of those counts. And so when I indicated to you that I have randomly selected 5 sample verdict forms, 1 is for a charge of murder in the first degree after deliberation. 1 is for a charge of murder in the first degree extreme indifference. 1 is for a charge of attempt to commit murder in the first degree after deliberation. 1 is for attempt to commit murder in the first degree extreme indifference. And 1 is for the count of possession or control of an explosive or incendiary device. Does everybody understand? And everyone's nodding their head yes and saying yes. The other thing that I wanted to remind you about that I mentioned to you about 3 months ago is that, as you know, all of you were given an opportunity to take notes. And each of you has a notebook that has papers, and you've been taking notes if you wanted to throughout the trial. I want to remind you that whether or not you took notes, you should rely on your memory as much as possible. The notes that you took are to refresh your own memory. You should not give additional weight to the comments of any juror based upon the quantity or quality of his or her note-taking. All right, that's just a reminder of an instruction I had given you either right before opening statements or before group jury selection. All right, would counsel please approach for just a moment? Question that was submitted, and I'll let counsel address it during their closing arguments, okay? All right, at this time, let's distribute the jury instructions and the sample verdict forms, please. For the record, my staff, Ms. Gerlings and Ms. Robinson, are about to distribute a copy of the jury instructions and a copy of the 5 sample verdict forms to each juror. Does everyone have a copy? Yes, okay. Folks, I'm going to ask you to follow along as I read the instructions and I go over the verdict forms, okay? Jury instructions. Instruction numbers 1 through 30 given by the court this 14th day of July of 2015. Instruction number 1. Members of the jury, the evidence in this case has been completed. In a moment, I will read to you jury instructions that contain the rules of law you must apply to reach your verdicts. You will have copies of what I read to take with you to the jury room. But first, I want to mention a few things you need to keep in mind when you are discussing this case in the jury room. Until you have returned your verdicts, you must follow all of the admonishments that I will read to you in a moment. Because you will deliberate soon, when I tell you that you may start deliberating, these are similar but not identical to the admonishments I have been giving you throughout the trial with respect to your conduct when you're not in the courtroom. You must decide this case based only on the evidence presented in the courtroom and the instructions of law provided by the court. Do not communicate about the case with anyone else in any way, including in person, by telephone, cell phone, smartphone, iPhone, BlackBerry, computer, the internet, or any internet service. This means that you must not email, text, instant message, tweet, blog, or post information about this case or about your experience as a juror in this case on any website, listserv, chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, or Twitter. You must not communicate in any way with anyone else about this case or this kind of case. This includes your family members and friends. You must not read, review, or accept any communication in any form from anyone regarding this case or a case like this one. All you can tell family members, friends, acquaintances, and strangers is that you're on a jury in Arapahoe County that is anticipated to be completed at the latest by the end of August. If you notice that people are discussing the case, remove yourself from that location immediately. Do not attempt to gather any information on your own about this case. You must not read or conduct any research about this case or this kind of case, using any source, including dictionaries, reference materials, the internet, or any other electronic means. Many of us routinely use the internet to research topics of interest, but you may not do that in relation to this case. You may not use Google, Bing, Yahoo, or any other type of internet search engine to learn about any person, place, or thing that is involved in this case. This includes the defendant, the attorneys, the witnesses, your fellow jurors, court personnel, and me. This applies whether you are here, at home, or anywhere else. Do not read about this case in the newspapers or on the internet. Do not listen to any radio broadcasts about the trial, and do not watch any television news reports regarding the trial. Do not attempt to visit any places mentioned in this case. Do not in any way try to learn about this case or this kind of case outside the courtroom. Do not talk to the witnesses, parties, and attorneys about anything. Do not talk to any members of the media about anything. Do not have any contact through any means, including in person, by telephone, text, or email, with any jurors who have been discharged. You also should not have any contact through any means, including in person, by telephone, text, or email, with any of the alternate jurors. Make sure that you wear your juror badge whenever you are on the courthouse grounds, and that your juror badge is visible to those around you. If you have a cell phone or other electronic device, you must temporarily surrender it to my staff. You're not allowed to have a cell phone or other electronic device in the jury room during your deliberations. You will get your electronic device at the end of the day before you go home. Lastly, although you may start deliberating when I tell you that you may do so, you may discuss this case only when you are all present and only when you are in the jury room. No juror should attempt to discuss this case with another juror or other jurors, except when all the jurors are present in the jury room. All deliberations must occur in the jury room when all 12 jurors are present. It is my job to decide what rules of law apply to the case. While the attorneys may comment on some of these rules, you must follow the instructions that I give you. Even if you disagree with or do not understand the reasons for some of the rules of law, you must follow them. No single instruction describes all the law which must be applied. The instructions must be considered together as a whole. During the trial, you received all of the evidence that you may properly consider in deciding the case. Your decision must be made by applying the rules of law that I give you to the evidence presented at trial. Remember, you must not be influenced by sympathy, bias, or prejudice in reaching your decisions. In making your decisions, you must not consider punishment at all. At times during the trial, the attorneys made objections. Do not draw any conclusions from the objections or from my rulings on the objections. These only related to legal questions that I had to decide and should not influence your thinking. If I told you not to consider a particular statement that was made during the trial, you must not consider it in your deliberations. Similarly, if I sustain an objection to a question after a witness had already provided an answer or partial answer, you must not consider any part of that answer in your deliberations. I have asked questions of witnesses during the trial. That did not mean that I had any opinion about the facts in the case. Finally, you should consider all the evidence in light of your experience in life. Instruction number 2, the charges against the defendant are not evidence. The charges against the defendant are just accusations. The fact that the defendant has been accused is not evidence that the defendant committed any crime. The defendant is charged with 12 counts of murder in the first degree after deliberation, 12 counts of murder in the first degree extreme indifference, 70 counts of attempt to commit murder in the first degree after deliberation, 70 counts of attempt to commit murder in the first degree extreme indifference, and 1 count of possession or control of an explosive or incendiary device in Colorado on or about July 20, 2012. The defendant has pled not guilty by reason of insanity, which includes the plea of not guilty. Instruction number 3. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be given effect by you unless, after considering all of the evidence, you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute each crime charged. Reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element of a crime has been proven beyond a reasonable doubt, you should find the defendant guilty of that crime. If you find from the evidence that the prosecution has failed to prove any one or more of the elements of a crime beyond a reasonable doubt, you should find the defendant not guilty of that crime. Instruction number 4. The number of witnesses testifying for or against a certain fact does not, by itself, prove or disprove that fact. Instruction number 5. You are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. Instruction number 6. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight that you give the testimony is entirely your decision. Instruction number 7. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that he or she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. Instruction number 8. The court admitted certain evidence for a limited purpose. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. Instruction number 9. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. Instruction number 10. In this case, a separate offense is charged against the defendant in each count. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. The fact that you may find the defendant guilty, or not guilty by reason of insanity of one of the charged offenses should not control your verdict as to any other charged offense against the defendant. The defendant may be found guilty, or not guilty by reason of insanity of any one or all of the charged offenses. Instruction number 11. The defendant is charged with murder in the first degree after deliberation in each of the following counts. Count 1, Jonathan Blanc. Count 2, Alexander Boyk. Count 3, Jesse Childress. Count 4, Gordon Cowden. Count 5, Jessica Gowie. Count 6, John Larimer. Count 7, Matthew McQuinn. Count 8, Michaela Medic. Count 9, Veronica Mosher Sullivan. Count 10, Alex Sullivan. Count 11, Alexander Taves. Count 12, Rebecca Wingo. The elements of the crime of murder in the first degree after deliberation as charged in each of these counts are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, after deliberation, and 4, with the intent, 5, to cause the death of a person other than himself, 6, cause the death of that person or of another person, 7, and that the defendant was not insane as defined in Instruction 23. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of that count of murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. Instruction number 12. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in a count listed in Instruction 11, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the charged offense if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of murder in the first degree after deliberation, as charged in each of the counts listed in Instruction 11, necessarily includes the lesser offenses of murder in the second degree and manslaughter. The elements of the crime of murder in the second degree are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. The elements of the crime of manslaughter are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, recklessly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any charged offense. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of a charged offense or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide that the prosecution has failed to prove one or more of the elements of a charged offense and one or more of the elements of each of its lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in Part A of the verdict form for that count. While you may find the defendant not guilty of each charged offense and its lesser included offenses, you may not find the defendant guilty of more than one of the following offenses in the same count: murder in the first degree after deliberation, murder in the second degree, manslaughter. Instruction number 13. The defendant is charged with murder in the first degree, extreme indifference, in each of the following counts. Count 13, Jonathan Blanc. Count 14, Alexander Boyk. Count 15, Jesse Childress. Count 16, Gordon Cowden. Count 17, Jessica Gowie. Count 18, John Larimer. Count 19, Matthew McQuinn. Count 20, Michaela Medic. Count 21, Veronica Mosher Sullivan. Count 22, Alex Sullivan. Count 23, Alexander Taves. Count 24, Rebecca Wingo. The elements of the crime of murder in the first degree extreme indifference as charged in each of these counts are: 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly, 4, under circumstances evidencing an attitude of universal malice, manifesting extreme indifference to the value of human life generally, 5, engaged in conduct which created a great risk of death to a person or persons other than himself, and 6, thereby caused the death of another, 7, and that the defendant was not insane as defined in Instruction 23. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of murder in the first degree extreme indifference, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of the count of murder in the first degree extreme indifference, and you should so state in Part A of the verdict form for that count. Instruction number 14. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in a count listed in Instruction 13, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the charged offense, if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of murder in the first degree extreme indifference, as charged in each of the counts listed in Instruction 13, necessarily includes the lesser offense of murder in the second degree and manslaughter. The elements of the crime of murder in the second degree are: 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. The elements of the crime of manslaughter are: 1, that the defendant, 2, in the state of Colorado are at or about the date and place charged, 3, recklessly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any charged offense. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of a charged offense or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide that the prosecution has failed to prove one or more of the elements of a charged offense and one or more of the elements of each of its lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in Part A of the verdict form for that count. While you may find the defendant not guilty of each charged offense and its lesser included offenses, you may not find the defendant guilty of more than one of the following offenses in the same count: murder in the first degree extreme indifference, murder in the second degree, manslaughter. Instruction number 15. The defendant is charged with attempt to commit murder in the first degree after deliberation in each of the following counts: Count 25, Petra Hogan; Count 26, Aiden Avila Arredondo; Count 27, Brandon Axelrod; Count 28, Tony Bilapando; Count 29, Christina Blash; Count 30, Maria Carbonell, count 31. Alejandra Cardona Lamas, count 32. Luis Duran, count 33. Craig Enlund, count 34. Alex Espinosa, count 35. Jacqueline Fry, count 36. Joseph Garby, count 37. Zachary Golditch, count 38. Munerick Gravely, count 39. Eugene Hahn, count 40. Kristen K.C. Hahn, count 41. Katie Medley, count 42. Jasmine Kennedy, count 43. Marcus Kizar, count 44. Patricia Legarreta Roars, count 45. Brendan Lowak, count 46. Ryan Lumba, count 47. Caleb Medley, count 48. Ashley Mosher, count 49. Stephen Moton, count 50. Joshua Nolan, count 51. Pierce O'Farrell, count 52. Prodeo Patria, count 53. Rita Paulina, count 54. Christopher Raposa, count 55. Carly Richards, count 56. Dion Rosborough, count 57. Carrie Rotman, count 58. Lucas Smith, count 59. Heather Snyder, count 60. Farah Sudani, count 61. Catherine Streve, count 62. Jameson Taves, count 63. Denise Axelrod, count 64. Marcus Weaver, count 65. Michael White, count 66. David Williams, count 67. Aline Young, count 68. Jansen Young, count 69. Samantha Yowler, count 70. Gage Hankins, count 71. Michaela Hicks, count 72. Stephen Barton, count 73. Nicholas Gallup, count 74. Evan Ferris, count 75. Jennifer Avila Arredondo, count 76. Gerald Brooks, count 77. Amanda Hernandez Memije, count 78. Kelly Lewis, count 79. Bonnie Kathleen Borshaw Zogby, count 80. Angia Mora, count 81. Ethan Roars, count 82. Nathan Juranick, count 143. Corbin Dates, count 145. Lauren Schuler, count 147. Jamie Roars, count 149. Evan Morrison, count 151. Rochelle Hill, count 153. Kaylin Bailey, count 155. Kelly Bowen, count 157. Shirley Clark, count 159. Haley Hensley, count 161. Victor Edgar Nava Hernandez, count 163. Debra Thomas Kizar, count 165. Caitlin Petticord. The elements of the crime of attempt to commit murder in the first degree after deliberation as charged in each of these counts are: 1. That the defendant, 2. in the state of Colorado at or about the date and place charged, 3. after deliberation, and 4. with the intent, 5. to cause the death of a person other than himself, 6. engaged in conduct constituting a substantial step toward the commission of murder in the first degree after deliberation as defined in instruction 11, 7. and that the defendant was not insane as defined in instruction 23. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering all the evidence, if you decide the prosecution has proven each of the elements with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of attempt to commit murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of that count of attempt to commit murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. Instruction number 16. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in a count listed in instruction 15, he may, however, be found guilty of any lesser offense the commission of which is necessarily included in the charge offense if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of attempt to commit murder in the first degree after deliberation, as charged in each of the counts listed in Instruction 15, necessarily includes the lesser offenses of attempt to commit murder in the second degree and attempt to commit manslaughter. The elements of the crime of attempt to commit murder in the second degree are: 1, that the defendant, 2, in the state of Colorado, at or about the date and place charged, 3, knowingly, 4, engaged in conduct constituting a substantial step toward the commission of murder in the second degree as defined in Instruction 12, 5, and that the defendant was not insane as defined in Instruction 23. The elements of the crime of attempt to commit manslaughter are: 1, that the defendant, 2, in the state of Colorado, at or about the date and place charged, 3, recklessly, 4, engaged in conduct constituting a substantial step toward the commission of manslaughter as defined in Instruction 12, 5, and that the defendant was not insane as defined in Instruction 23. A substantial step, as used in the elements of the two lesser included offenses defined in this instruction, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any charged offense. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of a charged offense or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide that the prosecution has failed to prove one or more of the elements of a charged offense and one or more of the elements of each of its lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in Part A of the verdict form for that count. While you may find the defendant not guilty of each charged offense and its lesser included offenses, you may not find the defendant guilty of more than one of the following offenses in the same count: attempt to commit murder in the first degree after deliberation, attempt to commit murder in the second degree, attempt to commit manslaughter. Instruction number 17. The defendant is charged with attempt to commit murder in the first degree extreme indifference in each of the following counts. Count 83, Petra Hogan. Count 84, Aiden Avila Arredondo. Count 85, Brandon Axelrod. Count 86, Tony Villapando. Count 87, Cristina Blash. Count 88, Maria Carbonell. Count 89, Alejandra Cardona Lamas. Count 90, Luis Duran. Count 91, Craig Enlund. Count 92, Alex Espinosa. Count 93, Jacqueline Fry. Count 94, Joseph Garby. Count 95, Zachary Goldich. Count 96, Muniri Gravely. Count 97, Eugene Hahn. Count 98, Kristen Casey Hahn. Count 99, Katie Medley. Count 100, Jasmine Kennedy. Count 101, Marcus Kizar. Count 102, Patricia Legarreta Roars. Count 103, Brenton Loweck. Count 104, Ryan Lumba. Count 105, Caleb Medley. Count 106, Ashley Mosher. Count 107, Stefan Motan. Count 108, Joshua Nolan. Count 109, Pierce O'Farrell. Count 110, Prodeo Patria. Count 11, Rita Polina. Count 111, Rita Polina. Count 112, Christopher Raposa. Count 113, Carly Richards. Count 114, Dion Rossborough. Count 115, Carrie Rotman. Count 116, Lucas Smith. Count 117, Heather Snyder. Count 118, Farah Sudani. Count 119, Catherine Strebe. Count 120, Jameson Tabes. Count 121, Denise Axelrod. Count 122, Mark Marcus Weaver. Count 123, Michael White. Count 124, David Williams. Count 125, Aline Young. Count 126, Jansen Young. Count 127, Samantha Yowler. Count 128, Gage Hankins. Count 129, Michaela Hicks. Count 130, Stephen Barton. Count 131, Jennifer Avila Arredondo. Count 132, Gerald Brooks. Count 133, Amanda Hernandez Memije. Count 134, Nathan Juranik. Count 135, Kelly Lewis. Count 136, Angiat Mora. Count 137, Bonnie Kathleen Portia Zogby. Count 138, Ethan Roars. Count 139, Nicholas Gallup. Count 140, Evan Ferris. Count 144, Corbin Dates. Count 146, Lauren Schuler. Count 148, Jamie Roars. Count 150, Evan Morrison. Count 152, Rochelle Hill. Count 154, Kaylin Bailey. Count 156, Kelly Bowen. Count 158, Shirley Clark. Count 160, Haley Hensley. Count 162, Victor Edgar Nava Hernandez. Count 164, Debra Thomas Kizar. Count 166, Caitlin Petticord. The elements of the crime of attempt to commit murder in the first degree extreme indifference as charged in each of these counts are: 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Engaged in conduct constituting a substantial step toward the commission of murder in the first degree extreme indifference as defined in instruction 13, 5, and that the defendant was not insane as defined in instruction 23. A substantial step is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of attempt to commit murder in the first degree extreme indifference, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of that count of attempt to commit murder in the first degree extreme indifference, and you should so state in Part A of the verdict form for that count. Instruction number 18. If you're not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in a count listed in instruction 17, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the charged offense if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of attempt to commit murder in the first degree extreme indifference as charged in each of the counts listed in instruction 17 necessarily includes the lesser offenses of attempt to commit murder in the second degree and attempt to commit manslaughter. The elements of the crime of attempt to commit murder in the second degree are: 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Engaged in conduct constituting a substantial step toward the commission of murder in the second degree as defined in instruction 14, 5, and that the defendant was not insane as defined in instruction 23. The elements of the crime of attempt to commit manslaughter are: 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Recklessly, 4. Engaged in conduct constituting a substantial step toward the commission of manslaughter as defined in instruction 14, 5, and that the defendant was not insane as defined in instruction 23. A substantial step, as used in the elements of the two lesser included offenses defined in this instruction, is any conduct, whether act, omission, or possession, which is strongly corroborative of the firmness of the actor's purpose to complete the commission of the offense. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any charged offense. the law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of a charged offense or of a lesser included offense, you should find the defendant guilty of the offense proven, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide that the prosecution has failed to prove one or more of the elements of a charged offense and one or more of the elements of each of its lesser included offenses, you should find the defendant not guilty of these offenses, and you should so state in Part A of the verdict form for that count. While you may find the defendant not guilty of each charged offense and its lesser included offenses, you may not find the defendant guilty of more than one of the following offenses in the same count: attempt to commit murder in the first degree extreme indifference, attempt to commit murder in the second degree, attempt to commit manslaughter. Instruction number 19. In count 141, the defendant is charged with possession or control of an explosive or incendiary device. The elements of the crime of possession or control of an explosive or incendiary device are: 1. That the defendant, 2. In the state of Colorado at or about the date and place charged, 3. Knowingly, 4. Possessed, controlled, manufactured, gave, mailed, sent, or caused to be sent, 5. An explosive or incendiary device, 6. And that the defendant was not insane as defined in Instruction 23. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of possession or control of an explosive or incendiary device, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find the defendant not guilty of possession or control of an explosive or incendiary device, and you should so state in Part A of the verdict form for that count. Instruction number 20. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable mental state. Voluntary act means an act performed consciously as a result of effort or determination, and includes the possession of property if the actor was aware of his physical possession or control thereof for a sufficient period to have been able to terminate it. Proof of the voluntary act alone is insufficient to prove that the defendant had the required culpable mental state. The culpable mental state is as much an element of the crime as the act itself, and must be proven beyond a reasonable doubt either by direct or circumstantial evidence. In this case, the applicable culpable mental states are explained below. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when his conscious objective is to cause the specific result proscribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. A person acts recklessly when he consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. Instruction number 21. In this case, certain words and phrases have particular meanings. Accordingly, You are to use the following definitions where these words and phrases appear in instructions that define crimes, defenses, special rules, and verdict questions. Deadly weapon means 1, a firearm, whether loaded or unloaded, or 2, a knife, bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, that in the manner it is used or intended to be used is capable of producing death or serious bodily injury. A firearm, as used in the definition of deadly weapon, means any handgun, automatic, revolver, pistol, rifle, shotgun, or other instrument or device capable or intended to be capable of discharging bullets, cartridges, or other explosive charges. Explosive or incendiary device means dynamite and all other forms of high explosives, including but not limited to water gel, slurry, military C4 plastic explosives, blasting agents to include nitrocarbon nitrate and ammonium nitrate and fuel oil mixtures, cast primers and boosters, RDX, PETN, electric and non-electric blasting caps, exploding cores commonly called detonating core or det core or primacord, picric, acid explosives, TNT and TNT mixtures, and nitroglycerin and nitroglycerin mixtures, any explosive bomb, grenade, missile, or other similar device, any incendiary bomb or grenade, firebomb, or similar device, including any device except kerosene lamps, which consist of or includes a breakable container including a flammable liquid or compound and a wick composed of any material which, when ignited, is capable of igniting such flammable liquid or compound and can be carried or thrown by one individual acting alone. Explosive or incendiary device does not include rifle, pistol, or shotgun ammunition or the components for hand-loading rifle, pistol, or shotgun ammunition. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Possession constitutes a voluntary act if the actor was aware of his physical possession or control thereof for a sufficient period to have been able to terminate it. Victim means any natural person against whom any crime has been perpetrated or attempted, as crime is defined under the laws of this state or of the United States. Instruction number 22. It is the defendant's theory of defense that he was insane at the time of the commission of the acts. The defendant asserts that he suffers from a chronic and serious mental illness with psychotic features, which falls within the schizophrenia spectrum of disorders. The defendant further asserts that in the spring of 2012, his mental illness worsened. The defendant asserts that around that time he experienced his first psychotic break and began to suffer from a psychotic delusion that he could increase his self-worth by gaining human capital and killing people. The defendant acknowledges that he engaged in planning and preparation, but asserts that he did so as a result of his delusional beliefs and psychotic thought processes, and that his purpose for engaging in planning and preparation was to pursue a psychotic delusion that he could increase his self-worth and human capital by killing other people. The defendant maintains that his delusional belief system was born of his mental illness, obscured his ability to make moral distinctions, and render him incapable of understanding that his actions were wrong from a societal perspective of morality. The defendant further asserts that his delusional beliefs interfere with his ability to act with reflection and judgment concerning the charged offenses. Instruction number 23. The evidence in this case has raised the defense of insanity as a defense to all the charged offenses and lesser included offenses. The defendant was insane at the time of the commission of each act if, 1, he was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act, or, number 2, he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an essential element of a charged offense or of a lesser included offense. But care should be taken not to confuse mental disease or defect with moral obliquity, mental depravity, or passion growing out of anger, revenge, hatred, or other motives and kindred evil conditions, because when an act is induced by any of these causes, the person is accountable to the law. In addition, diseased or defective in mind does not refer to an abnormality manifested only by repeated criminal or otherwise antisocial conduct. Similarly, mental disease or defect means only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality and that are not attributable to the voluntary ingestion of alcohol or any other psychoactive substance. Mental disease or defect does not include an abnormality manifested only by repeated criminal or otherwise antisocial conduct. The prosecution has the burden to prove beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act alleged in each count. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt both of the above numbered conditions with respect to the act alleged in the charged offense in each count and in each of the lesser included offenses of that charged offense. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act, which is an essential element of each charged offense and each lesser included offense. If you decide that the prosecution has failed to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act alleged in a charged offense and in its lesser included offenses, you must find the defendant not guilty of that charged offense and of its lesser included offenses. In that event, you should have the foreperson sign on the designated line in Part A of the verdict form for that count to indicate your verdict on that count. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant was not insane at the time of the commission of the act alleged in a count, your verdict with respect to the charged offense in that count and the lesser included offenses of that charged offense must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of the charged offense and the lesser included offenses. Instruction number 24. The phrase incapable of distinguishing right from wrong, as used in instruction 23, refers to a person's cognitive inability due to a mental disease or defect to distinguish right from wrong as measured by a societal standard of morality, even though the person may be aware that the conduct in question is criminal. The phrase incapable of distinguishing right from wrong, as used in instruction 23, does not refer to a purely personal and subjective standard of morality. Instruction number 25. This is an informational instruction and must have no persuasive bearing on the verdicts that you arrive at under the evidence. If the defendant is found not guilty by reason of insanity, it will be this court's duty to commit him to the custody of the Colorado Department of Human Services until such time as the court determines that he is eligible for release. The test for determining a defendant's eligibility for release from this commitment is as follows: that the defendant has no abnormal mental condition which would be likely to cause him to be dangerous either to himself or others or to the community in the reasonably foreseeable future, and is capable of distinguishing right from wrong and has substantial capacity to conform his conduct to requirements of law. If the defendant is found not guilty by reason of insanity, he will never again be tried on the merits of the criminal charges filed against him. Instruction number 26. If you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard the remainder of this instruction as well as Part B of all the verdict forms. If, however, you find the defendant not guilty of the charged offenses and lesser included offenses in all the counts, you should answer the following verdict question in Part B of the verdict form for each count. Did you find the defendant not guilty on this count solely based on the defense of insanity? Answer, yes or no. The court reminds you that the prosecution has the burden to prove beyond a reasonable doubt each element of each charged offense and each element of each lesser included offense. Further, the court reminds you that, excuse me, give me a second. Further, the court reminds you that an essential element of each charged offense and each lesser included offense is that the defendant was not insane at the time of the commission of the act. As to each count, if you decide that the only element of the charged offense and the lesser included offenses that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act, you should have the foreperson mark yes in the appropriate space in Part B of the verdict form for that count. And you should then have the foreperson sign on the designated line in Part B of that verdict form. As to each count, if you decide that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses, you should have the foreperson mark no in the appropriate space in Part B of the verdict form for that count, and you should then have the foreperson sign on the designated line in Part B of that verdict form. Instruction number 27. This instruction does not apply to count 141, possession or control of an explosive or incendiary device. This instruction applies only to the charged offenses and lesser included offenses in the remaining counts. Each charged offense of murder in the first degree after deliberation and its lesser included offenses of murder in the second degree and manslaughter. Each charged offense of murder in the first degree extreme indifference and its lesser included offenses of murder in the second degree and manslaughter. Each charged offense of attempt to commit murder in the first degree after deliberation and its lesser included offenses of attempt to commit murder in the second degree and attempt to commit manslaughter, and each charged offense of attempt to commit murder in the first degree, extreme indifference, and its lesser included offenses of attempt to commit murder in the second degree and attempt to commit manslaughter. If you find the defendant not guilty of all the charged offenses and lesser included offenses in all the counts to which this instruction applies, you should disregard the rest of this instruction as well as Part C of each verdict form. If, however, you find the defendant guilty of the charged offense or a lesser included offense in a count to which this instruction applies, you should answer the following verdict question in Part C of the verdict form for that count. Did the defendant use or possess and threaten the use of a deadly weapon? Answer, yes or no. The defendant used or possessed and threatened the use of a deadly weapon only if 1. The defendant used or possessed and threatened the use of a deadly weapon, 2. During the commission of the offense proven or in the immediate flight therefrom. The prosecution has the burden to prove each number condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden of proof with respect to the offense proven in a particular count, you should have the foreperson mark yes in the appropriate space in Part C of the verdict form for that count, and you should then have the foreperson sign on the designated line in Part C of that verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof with respect to the offense proven in a particular count, you should have the foreperson mark no in the appropriate space in Part C of the verdict form for that count, and you should then have the foreperson sign on the designated line in Part C of that verdict form. Instruction number 28. During this trial, you were permitted to submit written questions to witnesses. If a particular question was not asked, do not guess why the question was not asked or what the answer might have been. My decision not to ask a question submitted by a juror was not a reflection on the person asking it, and you should not attach any significance to the failure to ask a question. By making legal rulings on the admissibility of questions, I did not intend to suggest or express any opinion about the question. My decision, whether or not to allow a question, was based on the applicable rules of evidence and other rules of law, and not on the facts of this particular case. It is my responsibility to assure that all parties receive a fair trial according to the law and the rules of evidence. The fact that certain questions were not asked must not affect your consideration of the evidence in any way. Do not give greater weight to questions or answers to questions that were submitted by yourself or your fellow jurors. In making your decisions, you must consider all of the evidence that has been presented. Instruction number 29. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to one of the bailiffs who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Before I read the last instruction, instruction number 30, let me go through the verdict forms, the sample verdict forms. So why don't you grab the sample verdict forms, please? Does everyone have the sample verdict forms? Okay. These are the 5 sample verdict forms. Verdict form, count 1, murder in the first degree after deliberation, Jonathan Blanc. Part A, Rome numeral 1, we the jury find the defendant James Eagan Holmes not guilty of murder in the first degree after deliberation and the lesser included offenses of murder in the second degree and manslaughter. And then there's a space there for the foreperson to sign. Roman numeral 2, we the jury find the defendant James Eagan Holmes guilty of murder in the first degree after deliberation or the lesser included offense of murder in the second degree or the lesser included offense of manslaughter. And then there's a space there for the foreperson to sign in case that's the jury's verdict. The next page, single asterisk. If you find the defendant not guilty of the charged offense and the lesser included offenses, the foreperson should sign only on the designated line in section 1 in the previous page. Double asterisk. If you find the defendant guilty of the charged offense or one of the lesser included offenses, the foreperson should complete only section 2 in the previous page by placing in ink an X in the appropriate bracket and signing on the designated line. Only one bracket may be filled in with the other brackets to remain unmarked. And if you go back to the first page, you'll see that there is a single asterisk next to the 1 and a double asterisk next to the 2. And so on the second page, that's the explanation for the single asterisk and the explanation for the double asterisk. All right, part B. If you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave part B of all of the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature in case the jury determines that this question should be answered. Part C, if you find the defendant not guilty of the charged offense and the lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? The defendant used or possessed and threatened the use of a deadly weapon only if 1. The defendant used or possessed and threatened the use of a deadly weapon 2. During the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? The first bracket reads yes, the second bracket reads no, and then there's a place there for the foreperson to sign in case the jury determines that this question should be answered. The next verdict form reads verdict form, count 13, murder in the first degree, extreme indifference, Jonathan Blanc. Part A. 1. We, the jury, find the defendant, James Eagan Holmes, not guilty of murder in the first degree, extreme indifference, and the lesser included offenses of murder in the second degree and manslaughter. And then there's a space there for the foreperson to sign if the jury determines that the verdict is not guilty. 2. We, the jury, find the defendant, James Eagan Holmes, guilty of, the first bracket reads murder in the first degree, extreme indifference, or the next bracket reads the lesser included offense of murder in the second degree, or the next bracket reads the lesser included offense of manslaughter. And then there's a space there for the foreperson to sign in case the jury determines that the verdict is guilty on this count. The next page reads as follows, single asterisk. If you find the defendant not guilty of the charged offense and the lesser included offenses, the foreperson should sign only on the designated line in section 1 in the previous page. Double asterisk. If you find the defendant guilty of the charged offense or one of the lesser included offenses, the foreperson should complete only section 2 in the previous page by placing in ink an X in the appropriate bracket and signing on the designated line. Only one bracket may be filled in with the other brackets to remain unmarked. Part B. If you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and there's a space there for the foreperson to sign. Part C. If you find the defendant not guilty of the charged offense and the lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? the defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson to sign. Verdict form, count 25, attempt to commit murder in the first degree after deliberation. Petra Hogan. Part A. 1. We, the jury, find the defendant James Eagan Holmes not guilty of attempt to commit murder in the first degree after deliberation, and the lesser included offenses of attempt to commit murder in the second degree and attempt to commit manslaughter. And there's a space there for the foreperson signature. Number 2, we, the jury, find the defendant James Eagan Holmes guilty of, the first bracket reads, attempt to commit murder in the first degree after deliberation, or the second bracket reads, the lesser included offense of attempt to commit murder in the second degree, or the third bracket reads, the lesser included offense of attempt to commit manslaughter, and then there's a space there for the foreperson to sign. The single asterisk reads, if you find the defendant not guilty of the charged offense and the lesser included offenses, the foreperson should sign only on the designated line in section 1 in the previous page. The double asterisk reads, if you find the defendant guilty of the charged offense or one of the lesser included offenses, the foreperson should complete only section 2 in the previous page by placing in ink an X in the appropriate bracket and signing on the designated line. Only one bracket may be filled in with the other brackets to remain unmarked. Part B, if you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a place for the foreperson signature. Part C. If you find the defendant not guilty of the charged offense and the lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? The defendant used or possessed and threatened the use of a deadly weapon only if 1. The defendant used or possessed and threatened the use of a deadly weapon 2. During the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? First bracket reads yes, the second bracket reads no, and then there is a place for the foreperson signature there. Verdict form, count 83, attempt to commit murder in the first degree, extreme indifference. Petra Hogan, Part A, 1. We, the jury, find the defendant James Eagan Holmes not guilty of attempt to commit murder in the first degree, extreme indifference, and the lesser included offenses of attempt to commit murder in the second degree and attempt to commit manslaughter. And then there is a space for the foreperson signature there. 2. We, the jury, find the defendant James Eagan Holmes guilty of, the first bracket reads, attempt to commit murder in the first degree, extreme indifference, or the second bracket reads, the lesser included offense of attempt to commit murder in the second degree, or The third bracket reads the lesser included offense of attempt to commit manslaughter, and then there's a space there for the foreperson signature. Single asterisk, if you find the defendant not guilty of the charged offense and the lesser included offenses, the foreperson should sign only on the designated line in section 1 in the previous page. Double asterisk, if you find the defendant guilty of the charged offense or one of the lesser included offenses, the foreperson should complete only section 2 in the previous page by placing in ink an X in the appropriate bracket and signing on a designated line. Only one bracket may be filled in, with the other brackets to remain unmarked. Part B, if you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature. Part C, if you find the defendant not guilty of the charged offense and lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? The defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature. Verdict form count 141, possession or control of an explosive or incendiary device. Part A, 1, we the jury find the defendant James Eagan Holmes not guilty of possession or control of an explosive or incendiary device. 2, we the jury find the defendant James Eagan Holmes guilty of possession or control of an explosive or incendiary device. And there's a space for the foreperson after number 1 and a space for the foreperson after number 2. Single asterisk. If you find the defendant not guilty of the charged offense, the foreperson should sign only section 1 above. Double asterisk. If you find the defendant guilty of the charged offense, the foreperson should sign only section 2 above. Part B. If you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature. All right, let me have you turn back to instruction number 30, please. This is the last instruction, and then we'll take a break. Everybody there? Everybody with me? Okay. Instruction number 30. Following the attorney's closing arguments, the bailiffs will escort you to the jury room where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any part of a verdict form that you may agree on according to the rules that I am about to explain. The verdict form for count 141, possession or control of an explosive or incendiary device, contains two parts, Part A and Part B. The verdict forms for the remaining 164 counts contain the same two parts and an additional part, Part C. You should indicate your verdict with respect to each count in Part A of the verdict form. If your verdict on a count is not guilty of the charged offense and the lesser included offenses, you should have the foreperson sign on the designated line in Part A of the verdict form for that count. If your verdict on a count is guilty, you should have the foreperson place in ink an X in the space next to the offense that you conclude has been proven by the prosecution beyond a reasonable doubt, whether the charged offense in that count or a lesser included offense of that charged offense. And you should then have the foreperson sign on the designated line in Part A of the verdict form for that count. Because the charged offense of possession or control of an explosive or incendiary device, count 141, does not have any lesser included offenses, if you find the defendant guilty of that charged offense, you should only have the foreperson sign on the designated line in Part A of the verdict form for that count. Only one verdict shall be returned signed in Part A of the verdict form for each count. As mentioned earlier in these instructions, each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. Therefore, the fact that you may find the defendant guilty of the charged offense or a lesser included offense in a count should not control your verdict as to the charged offense and lesser included offenses in any other count. Similarly, the fact that you may find the defendant not guilty of the charged offense and the lesser included offenses in a count should not control your verdict as to the charged offense and the lesser included offenses in any other count. This is the case even if the reason that you find the defendant not guilty of the charged offense and the lesser included offenses in a count is solely based on the prosecution's failure to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. Having said that, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard Part B of all the verdict forms. You should answer the verdict question in Part B of the verdict forms only if you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case. The verdict question in Part B of each verdict form asks whether the jury found the defendant not guilty of the charged offense and the lesser included offenses solely based on the defense of insanity. Pursuant to these instructions, you will either complete Part B of all the verdict forms or you will disregard Part B of all the verdict forms. If, based on your verdicts, you determine that you should answer the verdict question in Part B of all the verdict forms, you should have the foreperson complete and sign that part of each verdict form. In the event that you find the defendant guilty of any charged offense or lesser included offense in a count, you should answer the verdict question in Part C of the verdict form for that count. And you should have the foreperson complete and sign Part C of that verdict form. The verdict question in Part C of each verdict form asks whether the defendant used or possessed and threatened the use of a deadly weapon. The verdict form for count 141, possession or control of an explosive or incendiary device, does not have a Part C because the verdict questions in Part C do not apply to count 141. If you conclude that the verdict question in Part B of all the verdict forms should be answered, only one answer shall be returned signed in that part of each verdict form. Similarly, if you conclude that the verdict question in Part C of any verdict form should be answered, only one answer shall be returned signed in that shall be returned signed in that part of the verdict form. Your verdict as to each charged offense and lesser included offense must represent the considered judgment of each juror and must be unanimous. Likewise, your response to any verdict question that you conclude should be answered, whether in Part B or Part C of a verdict form, must represent the considered judgment of each juror and must be unanimous. All of you must agree to all the parts of each verdict form. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching your verdicts and answering any verdict question or questions that you conclude should be answered, you will inform the bailiffs, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 165 verdict forms. Each verdict form contains directions with respect to 1, how to state your verdict in Part A of each verdict form, 2, under what circumstances you should answer the verdict question in Part B of all the verdict forms, and 3, that should say 3, not 2 again. If everybody would make the correction, please, I'll make that correction on my original instructions. And 3, under what circumstances you should answer the verdict question in Part C of any verdict form. Because the verdict form for count 141, possession or control of an explosive or incendiary device, does not contain a Part C, it only has instructions related to Part A and Part B of the verdict form. This says, I will now read to you 5 verdict forms, but I've read them to you just now, which represent the 5 different types of verdict forms you will receive. 1, for each charged offense of murder in the first degree after deliberation and its lesser included offenses. 2, for each charged offense of murder in the first degree extreme indifference and its lesser included offenses. 3, for each charged offense of attempt to commit murder in the first degree after deliberation and its lesser included offenses. 4, for each charged offense of attempt to commit murder in the first degree extreme indifference and its lesser included offenses. And 5, for the charged offense of possession or control of an explosive or incendiary device. You must not draw any inferences based on the verdict forms that I have selected to read to you or from the order in which I read them. Did everybody make the correction on the penultimate page of the instructions? Okay, everybody's saying yes and nodding their head yes. By the way, my set of the instructions is stamped original. This is the original set, so please do not mark on the original set of instructions. Your copies are stamped copy. You can mark on your copies all you want. You'll get to take your copies back to the jury room with you during deliberations. I ask, however, that until you start deliberating, that you leave the instructions here in the courtroom on your seat. So don't take them back to the jury room. I want to make sure we avoid any temptation that you may have to read them again and start deliberating, even if internally in your own mind. You cannot start deliberating yet or forming any opinions about the case until I tell you that you can start deliberating. So please leave them on your seats. Once I announce who the alternates are, we will retrieve your notebooks and your copies of the instructions from you and keep them locked up. Or actually, we will ask you to do that. My staff will ask you to leave them in one of the 2 jury rooms that are not going to be in use during deliberations, or to leave them in your lockers. And so that way you won't be tempted to be looking at your notes or to be looking at instructions while you're waiting for the deliberating jurors to deliberate. Does that make sense to everyone? Everyone's nodding their head yes. All right, so if you want to make any notations on your copy, you can make any notes and notations. Same thing with the sample verdict forms, but please do not mark on the original instructions and do not mark on the original verdict forms, which I will send back with you. They're right here. They're marked original as well. Do not mark on these, other than to have the foreperson make any markings based on my instructions today. All right? Okay, folks, let's go ahead and take a break before we begin with closing arguments, okay? Please make sure you follow all my admonishments during the break. All of them continue to apply. And please make sure you leave the instructions and the sample verdict forms on your seats. Enjoy your break. I'll see you back here in about 20 minutes, 20 to 30 minutes. Thank you. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. It's my understanding that the parties have some issues that they want to raise with respect to the demonstrative exhibits. Mr. King, do you want to do that now?
Yes, Your Honor, if I may.
Yes.
Your Honor, first I apologize. It's not my intention to delay the proceedings here. I understand the court's on a schedule, but I was just handed this morning, and I understand counsel's been working on their argument, and that's why I didn't provide my PowerPoint to them before this morning either, just simply due to time constraints. But having been handed this, I'm frankly a little shocked at what I'm seeing. The first problem, Judge, or the larger problem, is that this doesn't seem to be a conventional use of demonstrative exhibits. My PowerPoint is pretty much a conventional use of demonstrative exhibits, which is exhibits that were entered into evidence at trial, so they're things that are in evidence, and then there are a few title slides and a few summary slides of the testimony in order to convey to the jury in a summary fashion under the rule what the argument is, or to complement the argument. On the other hand, Mr. Brockler's PowerPoint is, if my calculations are right, there are 859 slides. And this contains not only exhibits or demonstratives, but also appears to contain the argument itself in large part. And some of those arguments are particularly concerning. And I'm happy to provide the court with my copy of these so that you can review them if you wish, if I may approach.
Yes. I'm assuming there's no objection from the people to me reviewing them during the break?
No, sir.
Okay.
My first objection, Your Honor, is on some of the pages, page 14, 28, 67, and 77, and I apologize, the slides aren't individually numbered, so I don't have individual numbers, but on those pages are slides that talk about deceit. There's one slide that stuck out in my mind that says something like, "He deceives everyone." Judge, my concern here is twofold. First of all, that, in my opinion, violates the court's order D-241, which regards the issue of general credibility being left up to the jury. And it's inappropriate for commentary on the general credibility of Mr. Holmes, frankly, based upon the statements that were made that are only to be considered in determining his sanity and not his guilt. Pursuant to the court order. I would cite to Domingo versus Gomez, 125 P. 3rd 1043, a Colorado Supreme Court from 2005. Deceit is just like lie, Your Honor. It's another form of the same expression, and it is a strong expression that reflects the personal opinion of Mr. Brockler. This is not in evidence. There's been no testimony about Mr. Holmes deceiving anyone. All of the experts have unanimously testified that that is in fact not the case, and that the evidence is clear that he did not deceive anyone. And what this is, Your Honor, is Mr. Brockler commenting on the general credibility of Mr. Holmes, absent any reference to this or any evidence of it in the record. People versus Wilson, 743 P. 2nd 415, Colorado Supreme Court from 1987, says that it's improper for counsel to express his personal belief in the truth or falsity of testimony during final argument. And that's what is exactly going on here, Judge, so I would object to those slides and such an argument. Number two, Your Honor, on page 104 and 107 are references to defense experts Hanlon and Gurr. And they talk about, and I raised objections to this during the cross-examination, but they talk about Page 87 says the defense experts, quote, changed their practice to suit the defense attorneys. And Judge, number one, that's not true. And as I made in my argument during the contemporaneous objections I made to this during the testimony, there's no way for us to counteract this argument. It creates an implication that their testimony and their opinions are somehow suspect, that they've changed their testimony and their opinions in response to requirements that we've placed on them. And that's just frankly not the case, Judge, and we have no way to rebut that kind of argument absent taking the witness stand and testifying ourselves. I would say to the case of People versus Summers, Your Honor, 200 Pacific 3rd, 1087, at page 1097, a Colorado Court of Appeals case from 2008, which talks about it's appropriate to cross-examine a witness on their bias, but there are limits on argument. And the quote is here, unlike cases which the defendants relies, the prosecution pointed out the prospect that the expert was biased because he's been paid, because he, the prosecution didn't make any reference to the expert's pay or bias in their opening statement or their closing argument. Well, so they can impeach the witness as to bias in their cross-examination, but they can't make an argument that somehow, because the witness is retained by the defense, because there were conversations with the defense, because they're paid by the defense, that they are coloring their testimony, Judge. And the other case that I would cite too is People versus McBride, which is at 228 Pacific 3rd, 216, a Colorado Court of Appeal case from 2009, which says that the prosecutors cannot denigrate defense experts by insinuating that they are coloring their testimony. There's no evidence of that here at all, Judge, and that's what's being done on pages 104 and 107 in those slides. The third objection I have, Your Honor, is that there are statements. Well, first, there is on page 30 and 123 slides that refer to, quote, impression management by Mr. Holmes. Again, this is along the same line as deceit. It's prohibited by the court's order 241. It's a general commentary by Mr. Brockler on what Mr. Holmes' credibility is, and it violates due process. It violates his right to a fair trial by an impartial jury, a fair and reliable sentencing hearing, and I object to that, Your Honor. Next, on pages 129, 130, and 124, there are statements about, quote, look how deep I am, look how philosophical I am, look how smart I am, which appear to be being applied to Mr. Holmes. These are not statements that Mr. Holmes ever made. They're not evidence in this case, and it conveys Mr. Brockler's personal opinion that Mr. Holmes is incredible based upon no evidence that's before the court. So I would object to those as well. I would also point out, Your Honor, that there appear to be statements throughout this PowerPoint on pages 36 through 43, 45, 34, 50, 52, 53, 54, 56, and 57 that are all statements that Mr. Holmes has made to different experts. And these are being made in the context of an argument about his guilt, not about his sanity. These are statements about him going to the theater, what took place at the theater, what he was thinking at the time in the theater, and none of these relate to the issue of sanity at all, but are presented in this PowerPoint as they bear directly upon his guilt. That is forbidden by this court and is forbidden by the law, Your Honor, so I would object to any such notations as such. Finally, there is an indication
on page 84 about a, quote, kill suit, that Mr. Holmes put on a kill suit. Again, this is not in evidence. This is inflammatory. It's Mr. Brockler's personal opinion, and it's an improper commentary on the evidence. On page 93, there is the quotation that was elicited over my objection from Dr. Woodcock when he was doing his competency determination, that, quote, prosecutors seek justice for those who are wronged. That is inappropriate argument, Your Honor. People versus Cognac, which is a 2014 Westlaw 335597 at 19. It's Colorado Court of Appeals case from January of 2014, indicating that, doing things for victims or to obtain justice is not an appropriate argument for a prosecutor to make in closing argument. And the other case I would cite is State versus Gross, 189 Pacific 3rd, 477, a Colorado Court of Appeals case from 2008. On page 109, Judge, there is a slide that talks about Dr. Gurr, and it has the word manufactured, which I would state the same objection under McBride and under Summers, that is, again, insinuating that Dr. Gurr has manufactured her opinion somehow, and that's an inappropriate denigration and commentary on defense experts. Finally, on page 119, there's a reference to collateral damage. Again, this is a misuse of statements that are being used for the purpose of guilt and not sanity. This slide you can see is juxtaposed next to specific victims' names. The argument is I'm sure that these are the collateral damage. And it's an inappropriate use of those statements, Judge. Statements that we've objected to being elicited from, and we've objected to being used against Mr. Holmes continuously, and this court has said consistently that it would prohibit the use of these statements for arguing anything other than as it bears on Mr. Holmes' sanity. And it's quite clear that that's not what these arguments are going to be. Again, I apologize for the interruption in the proceeding, Judge, but I'm afraid I may have to make contemporaneous objections to all of these issues as they come up if we can't deal with this ahead of time. So I would make all of my objections pursuant to the 5th, 6th, 8th, 14th Amendments to the United States Constitution and the Colorado Constitution, Article 2, Sections 16, 18, 20, 23, and 25. Thank you.
All right, thank you. Do the people want to respond?
Thank you, Your Honor. Your Honor, there is nothing improper about argument-based slides, even in closing. I've been doing this with PowerPoint for 14 years. I've never had anyone stand up and argue that putting portions of your argument or statements that you reference in a slide is somehow violative of any rule, and we haven't heard a single case cited to it. So I presume that this is just Mr. King's argument about how he feels about it. In terms of the other specific slides that are referenced, there is no comment on credibility of someone who has testified with regard to the acts of deception that are listed. There simply isn't any other way to describe the motivation behind why someone would, you could use the word mislead, you could use the word deceive. There is no way to describe all the steps that the defendant took to mislead or deceive people in society. And that is part of the argument, that he does that because he knows that they will view what he is going to do to them and to others as wrong. And that's detailed out specifically in the various things that are there. I never once come out and called the defendant a liar. And the cases cited by Mr. King are cases that reference testimony and commenting on the credibility of people who have testified. And there's no such testimony here. The other portions of the slide, Your Honor, that reference things like Dr. Gurr and them changing the way they do their practice to defense attorneys. The court's going to recall that's actually something we talked about at the bench, and something that was actually testified to by each of the three hand-picked defense experts. They each did things because the defense told them to do it, and it impacts their credibility. It impacts their view of their bias. In no way are these phrased in such a way to as impugn the defense, but to suggest that they are malleable to the defense who hired them and picked them to do this. That is also not a reference to their credibility. Specifically, the reference to Dr. Gurr's quote being manufactured, not her opinion, her quote being manufactured. That just happened, Judge. That was just last week, and the court will recall she agreed that she took two quotes out of two different places of questions and put them together because she thought the gist of it sounded about right. That is manufactured, and that's argument. The rest of Mr. King's objections are all about my characterization or my argument of what the evidence shows. That's fair game, Your Honor, in defense. There are no low blows, no cheap shots here, and there's nothing violative of the court's orders or any of the practice so far that we've engaged in this case. If the court has specific questions, I'm happy to address them. Oh, hang on one sec, Your Honor, I'm sorry.
I haven't seen the slides, but Mr. King argued that on pages 129, 130, and 124, there are apparently three sentences that read, "Look how deep I am, look how philosophical I am, and look how smart I am." And again, I haven't seen it, but are those quotations taken from somewhere? What?
No, and Your Honor will note too by flipping through that stack, where there are quotes, I put quotes. And unlike Dr. Gurr, when I put quotes, they're real. That's actually what was either said or what came out of the discovery. These are my arguments about why he's doing what he's doing with this notebook and the other things. And I'll make that clear, but that's my argument about what he's thinking and what motivates him to do this.
There was also an objection, I think with respect to multiple slides related to statements that the defendant has made to different experts with respect, as part of the sanity examination of the court order. And as you know, that evidence was introduced for a limited purpose, and that's pursuant to statute. So what's your response to the objection that these are being used for purposes of the defendant's guilt, not for purposes of sanity?
I disagree, Your Honor. The court will know from the instructions it just read that sanity implicates a bunch of different things, and that also includes the defendant's ability, his capacity, to form the requisite intent, with intent, knowingly, after deliberation. Each of these, and by the way, he also has to suffer from a mental disease or defect that demonstrably impairs his ability to appreciate or perceive reality around him. Each of these statements is used as a way to highlight what he knows, what he intends, what he's capable of intending, his goals and his thoughts. That's how they're put in there, and the court will notice that around there, this all goes towards those specific issues.
And is that how you're intending to use them?
Yes, sir, yeah. And Your Honor, too, respectfully, the court already once again read to the jury the instruction about limiting instructions. If the court feels like it would be necessary to instruct them further, it could, but that in and of itself, when they read that, should highlight the fact that, and the court read this dozens of times over the last 2.5 months, that the statements made to mental health professionals, whether they were qualified as experts or not, like Dr. Fenton and Feinstein and Ms. Roth, were only for the purposes of the NGRI plea. If there was no NGRI plea, Your Honor, these statements wouldn't be necessary.
What about the quote related to prosecutors seeking justice for those wronged, or prosecutors seek justice for those wronged? In what context are you using that?
I think that, Your Honor, if you look at that slide, the word wronged is highlighted, different from the other words. And the point of that, especially in the surrounding statements there, are to highlight that this defendant, 4 days after he pulls the trigger, has an appreciation of things like right and wrong, and that there can be people who are wronged. It's just one slide in a bunch that go towards his capacity to know right from wrong based upon societal standards of morality.
And let me see if I had any other questions. The collateral damage reference, I'm assuming that one you're not using for purposes of establishing or attempting to establish guilt, but for purposes of the issue of sanity?
Absolutely, Your Honor. This was a statement that he made to describe, in part, I think, arguably how his delusion worked. He believed that he got value from those that he successfully murdered, but the others, he got no value from them. They were worthless to him in terms of his assessment of this increasing his self-worth.
But right after your slide, it appears, I mean, I don't know what order these are in, but I'm looking at page 119, and on the same page that you have collateral damage, then you have the names of a couple of victims, and Mr. King mentioned that, and then you have a picture of an injured victim also on that page. So, I mean, if you're saying, defendant referred to collateral damage, and here's a collateral damage, and then referring to the victims, then how's that being restricted to the issue of sanity?
Well, Your Honor, this goes towards how he views those particular people as he's going through the theater and shooting them. The ones that he injures, even severely, they mean nothing to him. The ones that he kills, even if it's not messy and it's quick, those he gets value for. And so these would be two examples of collateral damage that under his quote-unquote delusion, he would not gain any value from them. But Your Honor, it's not being used for guilt because it doesn't go towards whether he shot them, I guess, yeah. It doesn't go to whether he shot them.
Okay, what else?
If the court has any other questions about the slides, and there was a number that, and I tried to make some marks here, Your Honor. Give me 1 second, please. One of the argument slides that was objected to was on page 84, where I described the defendant's head-to-toe self-protection prior to going in to this mass murder he was hoping for as a kill suit. That is clearly not a quote. That is clearly my argument about what that represents.
But the slides that Mr. King referred to on pages 36 through 43, 45, 34, 50, 52, 53, 54, and 57, you're only using those slides with respect to the issue of sanity.
Absolutely, Your Honor. And if you look at some, like the quotes on 45, we've got to prove that he was able to deliberate and form the intent to kill, whether he was successful or not. And his statements to Dr. Metzner about deliberately targeting people who were trying to flee the theater goes directly towards his capacity to do that. And the other statements are similar.
Okay, I'm going to take a break and review the slides and the arguments by counsel, and then we'll start when I'm ready, okay?
Thank you, Your Honor.
May I cite to one more case, Your Honor?
Sure.
And this is a case that's directly on point, on PowerPoint, as a matter of fact, where the case was reversed due to improper PowerPoint. It's out of this jurisdiction, but it's In Re Glassman, Glassman, 286 Pacific 3rd, 673, Washington Supreme Court case from 2012 that's directly on point.
All right, thank you. Okay, the court will be in recess. Thank you.
Please rise.
Well, good morning. Welcome back inside our 7 News newsroom. If you had the opportunity on your second screen, your television, to watch our 11 a.m. broadcast, you know that our legal expert, Dan Recht, is in the studio with us today. And so now that we have this recess here on our webcast, he's going to join us. And the first question for you, Dan, I think is pretty obvious. 859 slides for a 2-hour closing argument. That's what Dan King cited George Brockler as having. Is that a large number, a reasonable number?
It's a way large number, but it's not necessarily unreasonable. You know, I had predicted, and clearly that's what's going to happen here, the way the lawyers are going to try to condense months and months and months of testimony into 2 hours is to highlight and summarize with demonstrative evidence, which is what these slides are. So nothing new in those slides. It's summarizing what the jury's already heard about, but emphasizing what Brockler wants to emphasize. The defense will do the same thing.
We heard a lot of definitions in the instructions this morning, but demonstrative evidence was not one of those. Would you explain that for all of us?
Sure. It just means they aren't new pieces of evidence. It's stuff that demonstrates what the jury's already seen. So many of these slides will be a summary of what the attorneys want the jury to remember, because as you TV folks know, and it's absolutely empirically true, people remember what they see and hear better than what they simply hear.
Okay. We also noticed, and I know many of our viewers noticed, at the start of the day, piles of evidence, things that looked like the model, things that looked like the seats we'd seen earlier in front of the court recorder. Are all of those considered demonstrative evidence as well for this case?
Well, those aren't quite demonstrative evidence, but you'll see them used in closing arguments, because anything that's been admitted into evidence, any physical piece of anything, if the judge allowed it into evidence during the trial, it can be used by the attorneys to emphasize what they want to emphasize in the closing argument. So Brockler, if he wants, can pick up a gun or a bullet or whatever he wants that came into evidence, and he's simply showing it again to the jury in his summary.
The other thing we heard that we should ask you for some sense of scale on is we heard the reading of the 30 instructions. And in a case, a capital case, the 165 counts, is that large, is that small, is that normal?
Well, it's not a huge amount of instructions, but these lawyers with the judge, away from the jury, have been working on these instructions for days. They are tailored to this case. And you've heard instructions, one in particular that was tailored exactly to this case about when Holmes had his first psychotic break, etc.
The theory of defense, right?
The theory of defense, exactly right. So the defense tenders that as their instruction. It might have gotten tweaked by the judge, we don't know exactly, and then the jury hears that, and it's a summary of the defense position.
One of the, I think, most interesting was that theory of defense, and they had this debate, balance yesterday between what's appropriate for that and what should be just argumentative and made during the defense's own closing statement. What is your sense of the limitations, why they had such frustration over whether we say the defense states or the defense asserts? Why was that so picked over? Why was it so important that they spent literally hours, or at least felt like 2 hours, maybe more, on that yesterday?
Yeah, the theory of defense is usually the most controversial instruction that the judge gives. And they pick at the words like that, sort of wordsmithing. You're exactly right, for this reason. It isn't just part of King's closing argument. It's an instruction being given by the judge. And so these are words expressed by the judge. And so the judge wants to be sure, or Broccoli wants the judge to be sure, not to make it sound like he's siding with the defense. And so the very language used is important, and that happens in most cases.
Sure. Well, based on what we've heard and what we think to expect, any last thoughts before we look at some replay of some of these instructions that we heard earlier today?
Sure. Brockler has to condense, months of testimony into his 2 hours, and he's going to emphasize clearly in probably subtle and maybe not so subtle ways the emotional impact on the families and the victims. The defense, you can distill their case down to Dr. Gurr's testimony, and she's a well-respected expert saying that Holmes was insane. And the defense, I'm predicting, will also say that, of course, they don't argue with Holmes being the shooter, and the defense I predict, will express sympathy also for the victims and their families.
Well, thank you for joining us. Dan will be here with us all throughout the day, throughout these closing arguments on television and here online, on YouTube, on the 7 News app, on the Denver channel, where we are streaming this coverage to you throughout the day. I'll also let you know that this recess that we're in now is of indeterminate length. The judge had some objections from Mr. King on the defense to review, and we're going to come back and likely hear his decision on those, the 859 PowerPoint slides that he had objections not to all 859, but to several throughout. And when we return from this recess, when court returns from this recess, we will rejoin that live. In the meantime, Andrew has prepared for us a replay of some of these instructions that we heard throughout the morning. So if you missed any of that, we will replay for you right now. Thank you for joining us.
We, the jury, find the defendant James Eagan Holmes guilty of, the first bracket reads, attempt to commit murder in the first degree extreme indifference, or the second bracket reads, the lesser included offense of attempt to commit murder in the second degree, or the third bracket reads, the lesser included offense of attempt to commit manslaughter, and then there's a space there for the foreperson signature. Single asterisk, if you find the defendant not guilty of the charged offense and the lesser included offenses, the foreperson should sign only on the designated line in section 1 in the previous page. Double asterisk, if you find the defendant guilty of the charged offense or one of the lesser included offenses, the foreperson should complete only section 2 in the previous page by placing in ink an X in the appropriate bracket and signing on a designated line. Only one bracket may be filled in, with the other brackets to remain unmarked. Part B, if you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense and the lesser included offenses in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides that the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense and the lesser included offenses in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature. Part C, if you find the defendant not guilty of the charged offense and lesser included offenses in this count, you should leave Part C of this verdict form blank. If, however, you find the defendant guilty of the charged offense or of a lesser included offense in this count, you should answer the verdict question below. Did the defendant use or possess and threaten the use of a deadly weapon? The defendant used or possessed and threatened the use of a deadly weapon only if 1, the defendant used or possessed and threatened the use of a deadly weapon, 2, during the commission of the offense proven in this count or in the immediate flight therefrom. The foreperson should mark in ink yes if the jury unanimously decides that the prosecution met its burden of proving beyond a reasonable doubt each of these two conditions. The foreperson should mark in ink no if the jury unanimously decides that the prosecution did not meet its burden of proving beyond a reasonable doubt each of these two conditions. Did the defendant use or possess and threaten the use of a deadly weapon? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson signature. Verdict form count 141, possession or control of an explosive or incendiary device. Part A, 1, we the jury find the defendant James Eagan Holmes not guilty of possession or control of an explosive or incendiary device. 2, we the jury find the defendant James Eagan Holmes guilty of possession or control of an explosive or incendiary device. And there's a space for the foreperson after number 1 and a space for the foreperson after number 2. Single asterisk. If you find the defendant not guilty of the charged offense, the foreperson should sign only section 1 above. Double asterisk. If you find the defendant guilty of the charged offense, the foreperson should sign only section 2 above. Part B. If you find the defendant guilty of a charged offense or a lesser included offense in any count, you should leave Part B of all the verdict forms blank. If, however, you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case, you should answer the verdict question below. Did you find the defendant not guilty on this count solely based on the defense of insanity? The foreperson should mark in ink yes if the jury unanimously decides that the only element of the charged offense in this count that the prosecution failed to prove beyond a reasonable doubt is that the defendant was sane at the time of the commission of the act. The foreperson should mark in ink no if the jury unanimously decides the prosecution failed to prove beyond a reasonable doubt any other element of the charged offense in this count. Did you find the defendant not guilty on this count solely based on the defense of insanity? The first bracket reads yes, the second bracket reads no, and then there's a space there for the foreperson's signature. All right, let me have you turn back to instruction number 30, please. This is the last instruction, and then we'll take a break. Everybody there? Everybody with me? Okay. Instruction number 30. Following the attorney's closing arguments, the bailiffs will escort you to the jury room where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any part of a verdict form that you may agree on according to the rules that I am about to explain. The verdict form for count 141, possession or control of an explosive or incendiary device, contains two parts, Part A and Part B. The verdict forms for the remaining 164 counts contain the same two parts and an additional part, Part C. You should indicate your verdict with respect to each count in Part A of the verdict form. If your verdict on a count is not guilty of the charged offense and the lesser included offenses, you should have the foreperson sign on the designated line in Part A of the verdict form for that count. If your verdict on a count is guilty, you should have the foreperson place in ink an X in the space next to the offense that you conclude has been proven by the prosecution beyond a reasonable doubt, whether the charged offense in that count or a lesser included offense of that charged offense. And you should then have the foreperson sign on the designated line in Part A of the verdict form for that count. Because the charged offense of possession or control of an explosive or incendiary device, count 141, does not have any lesser included offenses, if you find the defendant guilty of that charged offense, you should only have the foreperson sign on the designated line in Part A of the verdict form for that count. Only one verdict shall be returned signed in Part A of the verdict form for each count. As mentioned earlier in these instructions, each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. Therefore, the fact that you may find the defendant guilty of the charged offense or a lesser included offense in a count should not control your verdict as to the charged offense and lesser included offenses in any other count. Similarly, the fact that you may find the defendant not guilty of the charged offense and the lesser included offenses in a count should not control your verdict as to the charged offense and the lesser included offenses in any other count. This is the case even if the reason that you find the defendant not guilty of the charged offense and the lesser included offenses in a count is solely based on the prosecution's failure to prove beyond a reasonable doubt that the defendant was sane at the time of the commission of the act. Having said that, if you find the defendant guilty of any charged offense or lesser included offense in any count, you should disregard Part B of all the verdict forms. You should answer the verdict question in Part B of the verdict forms only if you find the defendant not guilty of all the charged offenses and all the lesser included offenses in this case. The verdict question in Part B of each verdict form asks whether the jury found the defendant not guilty of the charged offense and the lesser included offenses solely based on the defense of insanity. Pursuant to these instructions, you will either complete Part B of all the verdict forms or you will disregard Part B of all the verdict forms. If, based on your verdicts, you determine that you should answer the verdict question in Part B of all the verdict forms, you should have the foreperson complete and sign that part of each verdict form. In the event that you find the defendant guilty of any charged offense or lesser included offense in account, you should answer the verdict question in Part C of the verdict form for that count. And you should have the foreperson complete and sign Part C of that verdict form. The verdict question in Part C of each verdict form asks whether the defendant used or possessed and threatened the use of a deadly weapon. The verdict form for count 141, possession or control of an explosive or incendiary device, does not have a Part C because the verdict questions in Part C do not apply to count 141. If you conclude that the verdict question in Part B of all the verdict forms should be answered, only one answer shall be returned signed in that part of each verdict form. Similarly, if you conclude that the verdict question in Part C of any verdict form should be answered, only one answer shall be returned signed in that part of the verdict form. Your verdict as to each charged offense and lesser included offense must represent the considered judgment of each juror and must be unanimous. Likewise, your response to any verdict question that you conclude should be answered, whether in Part B or Part C of a verdict form, must represent the considered judgment of each juror and must be unanimous. All of you must agree to all the parts of each verdict form. The verdict forms and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching your verdicts and answering any verdict question or questions that you conclude should be answered, you will inform the bailiffs, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 165 verdict forms. Each verdict form contains directions with respect to 1, how to state your verdict in Part A of each verdict form, 2, under what circumstances you should answer the verdict question in Part B of all the verdict forms, and 3, that should say 3, not 2 again. If everybody would make the correction, please, I'll make that correction on my original instructions. And 3, under what circumstances you should answer the verdict question in Part C of any verdict form. Because the verdict form for count 141, possession or control of an explosive or incendiary device, does not contain a Part C, it only has instructions related to Part A and Part B of the verdict form. This says, I will now read to you 5 verdict forms, but I've read them to you just now, which represent the 5 different types of verdict forms you will receive. 1, for each charged offense of murder in the first degree after deliberation and its lesser included offenses. 2, for each charged offense of murder in the first degree extreme indifference and its lesser included offenses. 3, for each charged offense of attempt to commit murder in the first degree after deliberation and its lesser included offenses. 4, for each charged offense of attempt to commit murder in the first degree extreme indifference and its lesser included offenses. And 5, for the charged offense of possession or control of an explosive or incendiary device. You must not draw any inferences based on the verdict forms that I have selected to read to you or from the order in which I read them. Did everybody make the correction on the penultimate page of the instructions? Okay, everybody's saying yes and nodding their head yes. By the way, my set of the instructions is stamped original. This is the original set, so please do not mark on the original set of instructions. Your copies are stamped copy. You can mark on your copies all you want. You'll get to take your copies back to the jury room with you during deliberations. I ask, however, that until you start deliberating, that you leave the instructions here in the courtroom on your seat. So don't take them back to the jury room. I want to make sure we avoid any temptation that you may have to read them again and start deliberating, even if internally in your own mind. You cannot start deliberating yet or forming any opinions about the case until I tell you that you can start deliberating. So please leave them on your seats. Once I announce who the alternates are, we will retrieve your notebooks and your copies of the instructions from you and keep them locked up. Or actually, we will ask you to do that My staff will ask you to leave them in one of the two jury rooms that are not going to be in use during deliberations, or to leave them in your lockers. And so that way you won't be tempted to be looking at your notes or to be looking at instructions while you're waiting for the deliberating jurors to deliberate. Does that make sense to everyone? Everyone's not in their head, yes. All right, so if you want to make any notations on your copy, you can make any notes and notations. Same thing with the sample verdict forms, but please do not mark on the original instructions and do not mark on the original verdict forms, which I will send back with you. They're right here, they're marked original as well. Do not mark on these, other than to have the foreperson make any markings based on my instructions today, all right? Okay, folks, let's go ahead and take a break before we begin with closing arguments, okay? Please make sure you follow all my admonishments during the break. All of them continue to apply. And please make sure you leave the instructions and the sample verdict forms on your seats. Enjoy your break. I'll see you back here in about 20 minutes, 20 to 30 minutes. Thank you. The record should reflect that the jury has exited the courtroom. Please be seated, everyone. It's my understanding that the parties have some issues that they want to raise with respect to the demonstrative exhibits. Mr. King, do you want to do that now?
Yes, Your Honor, if I may.
Yes.
Your Honor, first I apologize. It's not my intention to delay the proceedings here. I understand the court's on a schedule, but I was just handed this morning, and I understand counsel's been working on their argument, and that's why I didn't provide my PowerPoint to them before this morning either, just simply due to time constraints. But having been handed this, I'm frankly a little shocked at what I'm seeing. The first problem, Judge, or the larger problem, is that this doesn't seem to be a conventional use of demonstrative exhibits. My PowerPoint is pretty much a conventional use of demonstrative exhibits, which is exhibits that were entered into evidence at trial, so they're things that are in evidence, and then there are a few title slides and a few summary slides of the testimony in order to convey to the jury in a summary fashion under the rule what the argument is, or to complement the argument. On the other hand, Mr. Brockler's PowerPoint is, if my calculations are right, there are 859 slides. And this contains not only exhibits or demonstratives, but also appears to contain the argument itself in large part. And some of those arguments are particularly concerning. And I'm happy to provide the court with my copy of these so that you can review them if you wish, if I may approach.
Yes. I'm assuming there's no objection from the people to me reviewing them during the break?
No, sir.
Okay.
My first objection, Your Honor, is on some of the pages, page 14, 28, 67, and 77, and I apologize, the slides aren't individually numbered, so I don't have individual numbers, but on those pages are slides that talk about deceit. There's one slide that stuck out in my mind that says something like, "He deceives everyone." Judge, my concern here is twofold. First of all, that, in my opinion, violates the court's order D-241, which
regards the issue of general credibility being left up to the jury, and it's inappropriate for commentary on the general credibility of Mr. Holmes, frankly, based upon the statements that were made that are only to be considered in determining his sanity and not his guilt pursuant to the court order. I would cite to Domingo versus Gomez, 125 P. 3rd 1043, a Colorado Supreme Court from 2005. Deceit is just like lie, Your Honor. It's another form of the same expression, and it is a strong expression that reflects the personal opinion of Mr. Brockler. This is not in evidence. There's been no testimony about Mr. Holmes deceiving anyone. All of the experts have unanimously testified that that is in fact not the case, and that the evidence is clear that he did not deceive anyone. And what this is, Your Honor, is Mr. Brockler commenting on the general credibility of Mr. Holmes, absent any reference to this or any evidence of it in the record. People versus Wilson, 743 P. 2nd 415, Colorado Supreme Court from 1987, says that it's improper for counsel to express his personal belief in the truth or falsity of testimony during final argument. And that's what is exactly going on here, Judge, so I would object to those slides and such an argument. Number 2, Your Honor, on page 104 and 107 are references to defense experts Hanlon and Gurr. And they talk about, and I raised objections to this during the cross-examination, but they talk about, page 87 says, the defense experts, quote, changed their practice to suit the defense attorneys. And Judge, number 1, that's not true. And as I made in my argument during the contemporaneous objections I made to this during the testimony, there's no way for us to counteract this argument. It creates an implication that their testimony and their opinions are somehow suspect, that they've changed their testimony and their opinions in response to requirements that we've placed on them. And that's just frankly not the case, Judge, and we have no way to rebut that kind of argument absent taking the witness stand and testifying ourselves. I would say to the case of People versus Summers, Your Honor, 200 Pacific 3rd 1087 at page 1097, a Colorado Court of Appeals case from 2008, which talks about it's appropriate to cross-examine a witness on their bias, but there are limits on argument. And the quote is here, unlike cases which the defendants relies, the prosecution pointed out the prospect that the expert was biased because he's been paid, because he, but the prosecution didn't make any reference to the expert's pay or bias in their opening statement or their closing argument.
The court admitted certain evidence for a limited purpose. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. Instruction number 9. Every defendant has a constitutional right not to testify. The decision not to testify cannot be used as an inference of guilt and cannot prejudice the defendant. It is not evidence, does not prove anything, and must not be considered for any purpose. Instruction number 10. In this case, a separate offense is charged against the defendant in each count. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately and influenced by your decision as to any other count. The fact that you may find the defendant guilty, not guilty, or not guilty by reason of insanity of one of the charged offenses should not control your verdict as to any other charged offense against the defendant. The defendant may be found guilty, not guilty, or not guilty by reason of insanity of any one or all of the charged offenses. Instruction number 11. The defendant is charged with murder in the first degree after deliberation in each of the following counts. Count 1, Jonathan Blanc. Count 2, Alexander Boyk. Count 3, Jesse Childress. Count 4, Gordon Cowden. Count 5, Jessica Gowie. Count 6, John Larimer. Count 7, Matthew McQuinn. Count 8, Michaela Medic. Count 9, Veronica Mosher Sullivan. Count 10, Alex Sullivan. Count 11, Alexander Taves. Count 12, Rebecca Wingo. The elements of the crime of murder in the first degree after deliberation as charged in each of these counts are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, after deliberation, and 4, with the intent, 5, to cause the death of a person other than himself, 6, cause the death of that person or of another person, 7, and that the defendant was not insane as defined in Instruction 23. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant guilty of that count of murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt with respect to a count listed earlier in this instruction, you should find the defendant not guilty of that count of murder in the first degree after deliberation, and you should so state in Part A of the verdict form for that count. Instruction number 12. If you are not satisfied beyond a reasonable doubt that the defendant is guilty of the charged offense in a count listed in Instruction 11, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the charged offense if the evidence is sufficient to establish his guilt of the lesser offense beyond a reasonable doubt. The offense of murder in the first degree after deliberation, as charged in each of the counts listed in Instruction 11, necessarily includes the lesser offenses of murder in the second degree and manslaughter. The elements of the crime of murder in the second degree are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, knowingly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. The elements of the crime of manslaughter are 1, that the defendant, 2, in the state of Colorado at or about the date and place charged, 3, recklessly, 4, caused the death of another person, 5, and that the defendant was not insane as defined in Instruction 23. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser offense which is necessarily included in any charged offense. The law never imposes. Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Rather than keep the jury waiting, I think what makes the most sense is to have them go to lunch. We were planning on taking a lunch break anyway. Have them go to lunch, then we'll come back. We'll do the prosecution's closing argument. We'll take a break. We'll do the defense's closing argument, take a break, and do the prosecution's rebuttal at that point. I'm going to need a little more time. There are a lot of slides or a lot of objections, and I need to review them. And if I decide that any slides need to be modified, that's going to take the prosecution some time as well. So I'm thinking it's almost 12 right now. I'll bring the jury in and see how late they can stay today, and then we'll go from there, okay? Let's bring the jury in, please.
Judge.
Please be seated, everyone. The record should reflect that the jury's back in the courtroom. Folks, thank you very much for your patience. There are some things that I need to talk to the lawyers about outside your presence still. And rather than keep you waiting, it occurred to me that it makes more sense to have you go to lunch, and then when you come back from lunch, we'll proceed. The question then is, how long do we take for lunch? And that depends on how late you can stay today. If we take an hour lunch, I could have you back by 1, and then 4 hours of closings would take us to right about 5. But then when you include the couple of breaks in there, it'll take us beyond 5. So to be safe, is there anyone here who is not able to stay as late as 6 tonight? Is there anyone on the jury who's not able to stay as late as 6 if necessary? Anyone? Okay, no one's raising their hand. All right, and I'm assuming everyone's willing to do it, and everybody's saying yes. Okay, great. I appreciate that. I'm not saying that we're going to stay till 6, but just in case. What I'm going to do then is give you a lunch break until 1 o'clock, and then hope that at 1 o'clock when you come back, we're ready to go, and we're ready to start with the first closing argument, which is the prosecution's closing argument. All right? During the lunch break, you need to make sure that you abide by all my admonishments. Please leave your instructions or your copy of the instructions and your copy of the sample verdict forms on your chair. I've given you the law that you're to apply in this case. And by the way, there was a question from you, and I think that my instructions answer that question, but the lawyers will also get to comment on the instructions during their closing argument. You may be tempted to want to start thinking about the case and forming opinions about the case. You need to resist that temptation. You cannot do that until I tell you that you can start deliberating, and that won't be until after closing arguments. Does everyone understand that? And everyone's saying yes and nodding their head yes. All right, enjoy your lunch, and I'll see you back here at 1. Please be seated, everyone. What I propose, folks, is to give me another 15 minutes or so. Let me get through the slides and through the cases that were cited, and then I'll try to come out around 12:15, 12:20, give you my rulings, and then that hopefully still gives you about a half hour or so for lunch and to make any changes that need to be made. All right?
Yes, Your Honor, and I had one argument that briefly that I wanted to add, which was the slides that talk about, look how smart, how philosophical I am, et cetera, highlight the defendant's decision and right not to testify under the Fifth Amendment and the Colorado Constitution, Article 2, Section 18.
Okay, thank you. All right, the court will be in recess. Thank you.
Please rise.
As we resume this recess process, as the judge goes through these objections, we are bringing our legal expert Dan Recht back onto our trial set here in the 7 News newsroom to talk a little bit about what exactly the judge is debating here. We know 859 slides, and you said that that was not necessarily a crazy number for a case of this size, right?
It's way more than I've ever seen a lawyer use. And I don't know how he shows that many slides in 2 hours, unless that is what his closing is, just going from slide to slide and explaining each of them. And that could be. So the number of slides seems to me, if I was the judge, are not objectionable. We don't know what's in each of those 800 and some slides. So they can not be new information. That is taboo. You can't do it. So if the judge is reviewing them to see if there's new information in those slides, then that's appropriate, and he should be doing that.
What about this idea that some of these might be George Brockler, the district attorney's interpretations of what people said or what people meant by what they said? And that seems to be the gist of some of Dan King's objections. What is your thought on that?
That's a fair objection. Whatever is in one of those slides, the same analysis applies to what Brockler or any other lawyer, King, says in their closing argument without a slide. You can't tell the jury that there was evidence of stuff that there wasn't evidence of. Right. And you can't distort the evidence beyond argument. So I guess King is saying, there's stuff in these slides that didn't come into evidence or are an unfair characterization of the evidence, and then that's an appropriate objection.
So one of the examples that came up a couple times that I caught, and we can ask you about it now, the George Brockler apparently putting in statements like, "Look how smart I am," that Dan King objected to as people are going to misinterpret these to be quotations when they're not. They're George Brockler's interpretation of what pieces of evidence might mean or represent. He's, I guess, narrating what, I imagine like reading a chapter of a novel, what the narrator might be thinking, and that seems to be what George Brockler is trying to do with some of these slides as he sets up these 859 different slides and the different ideas that he wants to express. Is a statement like, "Look how smart I am," when it's not a direct quote, a potential problem, something that the judge would sustain an objection to?
It is if it's a distortion of the evidence that's been presented, absolutely. So it doesn't matter if it's in a slide or, frankly, if it's said by Brockler in his closing argument. If he's saying stuff was in evidence that wasn't in evidence, or he's characterizing it as though it was in evidence when it wasn't in evidence, then that's a fair objection, and the judge should sustain it and not allow that slide in.
Sure. I'll take a moment, if you don't mind, Dan, and I'll say that I have a couple more questions of my own, but folks on the chat rooms, if you do want to submit any questions, we have, let's see, about 9 or 10 minutes left until the judge said he would try to be back in the courtroom. We certainly have plenty of video to play for you from highlights from throughout this case. But if you do have any questions that you'd like to submit for Dan or I, we'd be happy to take this time now while we have this unexpected break to chat with all of you. So if you have that moment. Let's talk for a minute about what else is coming today after this lunch break. 2 hours apiece of closings. Is that long? Is that standard for Colorado?
It's not exceptionally long, but often in a less serious case, a less high visibility case, a shorter case, the judge will restrict closing arguments to an hour, and sometimes less than that. So it's longer than usual, but not unusually longer. I mean, these lawyers are put in a position where they have to condense months and months of testimony into 2 hours. Yeah, that doesn't seem like an excessive amount of time to give them to do that. And keep in mind, the prosecution gives the first argument, then the defense, and then the prosecution, if they want, can give a rebuttal. Both of their arguments, both of the prosecution arguments, can't total more than 2 hours, so they can break it up any way they want. The other thing I've heard people say is, well, will the prosecution use their rebuttal time? With 100% certainty. Okay. There is no question they will use that time because they want the last word. So they will save time. They will be watching the clock. They will not do their first argument for more than, I don't know what, an hour and a half or so. They're going to save significant time for their rebuttal.
Now we're going to run a stopwatch on that so we can report to all of you how long that rebuttal opportunity is going to be. What should we expect, for example, when they have a cross-examination? It is limited to what comes before it. Is this rebuttal close limited to specifically rebutting points that the defense brings up?
No.
It's not. It's more wide open.
They can say whatever they want, and as long as, if it would have been appropriate in their first argument, it would be appropriate in their second argument. I've never seen, or only gross examples of that being the case. Normally they can say what they want.
Sure. And a cornerstone of the prosecution's case, you might even say the prosecution's case has been largely more emotional and the defense has been largely more cerebral about the mental health evidence. How do you think George Brockler might incorporate some of the various emotions, difficult bits of testimony that he presented throughout the course of his case, his primary case? How do you think he's going to bring that back up again? What tools does he have at his disposal?
Well, with certainty he's going to emphasize the emotional piece, like you say. And so we're going to see replays, I would guess, of the testimony of the most, the saddest victims. You will see quotes of that. You will see him talking about that. But in addition, Brockler has to summarize the evidence that showed, from his perspective, that Holmes knew what he was doing and knew the difference between right and wrong when he was doing it, and thought that this was wrong to do, but did it anyway. That's sort of his burden, and it's a way significant burden because under Colorado law, and this gets a little confusing, but it couldn't be more important, the prosecution has to prove beyond a reasonable doubt that Holmes was not insane. Right. There's a negative in there. And if the jury has any question in their mind, any doubt in their mind about whether he was sane or not sane, they're instructed to find him not guilty.
Right. It does seem like the not guilty by reason of insanity defense introduces all of these double negatives to the language throughout the case.
It does, and unless it's totally lost on the jury, it's got to be difficult for the jury because that's the decision they have to make, not who presented the better case, not who, do we think the prosecution is more likely right than the defense, and not, the prosecution psychiatric witnesses were a little better than Dr. Gurr. But, so there's no doubts left in their mind, and that's a steep burden on the prosecution.
Right. And each individual count has to have that same test, that same level, right?
It does. However, presumably, it's all going to go one way or it's all going to go another way. If the verdict is anything other than that, it almost feels like the jury then didn't understand their job.
Sure. Well, let's take a moment. Let me, don't think I'm rude, please. I'll pick
up
the laptop
please.
here and see if we can find any questions from the chat room for you. Are we surprised that there were no outbursts of emotion in the courtroom? And I don't know that that's been entirely true throughout this case, but they have been certainly under instructions. So what are your thoughts about that? This has been obviously such an emotional case.
Maybe it's a little surprising that there haven't been in such a long case, and let's wait to see if there is in the, during the closings there won't be, but the verdict, I'm guessing there will be emotional outbursts at the verdict. Guilty or not guilty. Sure. It's either going to be a huge relief for people or they're going to be upset, but that's generally when you see emotional outbursts.
And we do know that the judge is making an accommodation, giving what he's talked about hypothetically at least a 3-hour window to make sure that all the families, survivors on both sides of this case will have the opportunity to be there in that room.
Right, and let's be clear, when that's exactly right. When you say 3-hour window, from the time the jury tells the judge that it's reached a verdict, a unanimous verdict, then the judge is going to wait 3 hours before he reads it to give people time to get there.
And just like tonight, he's talking about keeping the jury in the courthouse, not letting them go home, and just like he doesn't want to split up the closings tonight, if it comes late in the afternoon, he's going to keep them there so that nobody goes home knowing what this verdict is, no potential for leaks or anything like that, right?
Yeah, he will, but more than likely, well, I don't know. 3 hours is a difficult one.
Right.
So what he would do if there was a 5 o'clock verdict, would he wait until 8 o'clock, or would he wait until 8 o'clock the next morning? I don't know. He can do it either way.
Yeah. Another question from you here, or for you here. Why is the judge seem to be in such a hurry?
Oh, this is a constant question. Judges feel compelled, and for some reason, to move things along. And think of how long this case has been going on. And if Judge Samore had not been as stringent about moving things along, the proceedings before the trial could have gone on, I suppose, years longer. He constantly was not granting continuance motions, right?
Right.
And still it took several years. And the trial is the same. So if a judge, and judges believe this more than frankly I do, but judges stress moving things along, efficiency. Let's not make the jury wait. Let's consider their time. Let's move things along. And so it's a good question. It's a controversial one because often the parties think that judges are overemphasizing the need to be efficient over the need to seek justice.
Right. Well, I know that we have counted in our terminology 48 days of work in this trial, but really that's only since April 27th. The actual trial, as it's considered in the court, began back in January when jury selection began, right?
Yeah, it depends how you define the actual trial, but yes, I consider jury selection part of the trial process, absolutely.
Certainly
I mean,
a lot more
dealing
work
with the jury.
Right. Certainly a lot more work for lawyers like you and your partners than it is for us who didn't get camera access until April.
Oh, it's huge. Yeah, from a lawyer's perspective, that is work. That is serious work, and that began in January. Absolutely right.
We have a question here from Chris asking about the strategic difference between openings and closings, and I think there's also a lot of rules that define the two. And so, would you explain that for us?
Absolutely, good question. The open is called the opening statement. Right. The closing is called the closing argument, and those words are carefully chosen. So, in the opening statement, the lawyers are supposed to give a statement of what evidence they anticipate the jury's going to hear during the trial, not an argument. Now, where you draw that line is a gray area at best, but nevertheless, you see judges sustain objections if the opening statement from either lawyer gets to be too argumentative. In the closing argument, it is just that, an argument, and it's anticipated that the lawyers will argue, and they can argue, and they will argue. So, yes, they're different and have different rules that apply.
Sure. Give me a moment as I scroll through to see if we can find any other questions for us, Dan. Are we surprised the judge will wait 3 hours for a verdict, referring to our conversation from just a moment ago? And Rocket here is asking if that's something that's common in Colorado or uncommon.
No, it's only done in a case with many victims and victims' families, and a high publicity case. I think in part he's giving the press time to get there. Right. And so no, normally, and depending on the case, some judges on low publicity cases will make the lawyers stay in the courthouse. And as soon as the jury verdict is presented to the judge, he'll reach out to the lawyers, and they have to be in there in 10 minutes, and boom, they read the verdict.
And that brings up an interesting subject, and something that we haven't really noted recently, but the fact is that this is an uncommon level of access that the media has, that everyone watching through this bird eye camera in the ceiling has to this court.
Absolutely. I mean, you can see it live.
Right.
That hasn't been true of major trials in the past.
Right.
It wasn't true of the Oklahoma City bombing case.
Mm-hmm.
It wasn't true of the Boston Marathon bombing case.
Right.
And so it is unusual. I, frankly, as a First Amendment advocate, think it's a good idea. The public should get to see this. I mean, if we go back into the history of our constitutional scheme, the whole idea was you'd have public trials. But in those days, there wasn't electronic media, so public trial meant the public had a right to be in the courtroom, right? Just like the public had a right to stand on a soapbox and say what they wanted to say.
Right.
Well, now, with electronic communication, seems to me that means that we should allow cameras in the courtroom, not so they're obtrusive or get in the way, but here they don't. I mean, the lawyers presumably don't even think about it.
Right. Now, the camera access has been granted, and we knew it was coming for many months. The access to evidence has been something that's been more debated. And so our media consortium that secured the camera feed and made the technical equipment available also has an attorney who had gotten some evidence released to us, but not all evidence. We've gotten written things that we couldn't see through the screen, but in other cases we're not getting access to that. What is Colorado's rule for making evidence that's been introduced in court public?
There isn't a rule.
There isn't a rule.
There isn't a statewide rule. On each trial, the judge makes the rules.
Sure.
And it just depends. I mean, the whole thing the judge is concerned about isn't really keeping the media from having the information so much as tainting the jury pool.
Yeah.
So you don't want to taint the jury pool, and if things are in the media, arguably, then the potential jurors have a greater likelihood of reading it and be influenced inappropriately by it.
You bring up the jury, and since we are still, by the way, it is 12:20, we did expect the judge to be back in the courtroom around 12:15, so we're obviously stretching for time here, but thank you all for having submitted questions. But the last thought, and after this we'll go to some replay and let everyone catch their breath. You brought up the jury. We started with 24 jurors, 12 alternates and 12 voting, deliberating jurors. We've lost 5. In a case of this length and magnitude and exposure, did we do well or did we?
I think we did pretty well. We still have a lot of alternates left, and the trial is about ended. So, it is about ended, of course, this first phase, but it's the very same jury that should there be a guilty verdict, and therefore should there be a penalty phase, that's a whole separate trial in essence with the same jury.
Right.
And that will go on, of course, as you've all discussed, for weeks.
Right. Well, everyone, it is now 12:21 here in Denver. Just south of us, Arapahoe County, we are awaiting for the court to return, for the judge to return to the court, let us know his rulings on Dan King, Public Defender Dan King's objections to these slides that George Brockler wants to present. In the meantime, while we wait for the judge to return to the courtroom, since this is obviously about seeking justice, we wanted to replay for you viewers at home the testimony of many of those people who were affected by this case. And so in this segment, and then what remains until the judge gives us his rulings, we will play that sound for you now. Dan Recht, our 7 News legal analyst, will be with us. We're not going to play that video because the court has just resumed, so we stretched just long enough. Let's hear what the judge has to say.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. In the brief amount of time I had, I did my best to look at the slides in the prosecution's closing argument, or the ones that the prosecution intends to use in closing arguments. And then I also looked at some of the authorities cited by the defense. So let me first talk about in Ray Glassman, 286 Pacific 3rd, 673. This is a Washington Supreme Court case from 2012. And again, the record should reflect that I am limited in the amount of time that I have to get this done based on when the objections are being raised and based on when the parties exchanged PowerPoint presentations. So this is not my doing, this is the parties' doing. I encourage them to do this. The parties are indicating that they only had them ready this morning when they showed up to court. So that's when they exchanged them. That's up to them. That's not up to me. In terms of Glassman, this is a case from the Washington Supreme Court. It is not binding on this court, but I found it to be helpful reading. I don't find it to be applicable in general. It is a case that includes what I would describe as egregious conduct by a prosecutor. And without getting into detail, a lot of detail, in that case, the prosecutor used a PowerPoint presentation that included altering some of the exhibits that had been admitted into evidence by adding a caption, his own caption of what he believed the exhibit demonstrated, or his own opinion in the caption. Of particular concern to the court was a picture that showed the defendant and the prosecution added a picture or a caption that said, "Do you believe him?" There was another slide where the prosecution added the caption, "Why should you believe anything he says about the assault?" There was another caption that showed the defendant and the victim, and this was apparently a domestic violence type case based on what I could gather from my quick reading of the case. And then there was a caption added to that photograph as well, something like "the end of our love" or something like that. And I am paraphrasing because I can't find that specific quote right now. Perhaps most concerning to the court was a slide where the prosecution added the words "guilty, guilty, guilty" as a caption to a picture of the defendant, and the words were all in red. And the court mentioned how red is the color of blood, and that based on all these captions, that the jury was likely inflamed. The court explained that a prosecutor could not stand up in closing argument and just start yelling, "The defendant is guilty, guilty, guilty." And the court then concluded that just as the prosecutor could not do that, the prosecutor also should not be allowed to add a caption to an exhibit that was admitted when the caption was not part of the evidence. And the court stated that the picture as admitted did not have the words "guilty, guilty, guilty" on it. So I think that case is different than what we're dealing with here, but I did find it helpful. I also read People versus McBride and People versus Summers. These two cases have to do with comments in closing arguments, and the prosecutors can make with respect to defense experts. And it's not as simple as saying, "Well, Your Honor, the prosecution can't say anything negative about our experts because that's denigrating our experts." It's more complicated than that. But the prosecution also has to be careful because it is not a situation where there are no limits. There are limits. So in the McBride case, which is cited at 228 Pacific 3rd 216, that's a Colorado Court of Appeals case from 2009, the court indicated that the prosecution made repeated personal attacks on a defense expert who had relied on crime scene evidence to offer an opinion. The prosecutor, in closing argument, said or referred to the expert as the hired gun expert, and stated that the hired gun expert had come up with something. And experts aren't going to just admit to you that they made this up. But that's exactly what happened. Either he made it up or he didn't look at the evidence. The prosecutor added that the expert was full of it, and that his testimony was garbage. And the court said, while prosecutors are entitled to challenge defense experts' biases, methods, and conclusions, they may not resort to unfairly prejudicial comments denigrating the expert. The court discussed the decision in Summers, People versus Summers, Sommers, which I'll get to in a moment. And the court said that in Summers, the court distinguished out-of-state cases holding that the prosecution denigrated the defense by insinuating that the expert concocted or colored his testimony in exchange for his fee and the prospect of future work. The Court of Appeals in Summers wrote that unlike in those cases, the prosecutor pointed out the expert's potential bias but made no prejudicial comments denigrating the expert. There was no prosecutorial misconduct upon which a claim of plain error can be based. That's a quote from Summers that appears in the McBride case. The court in McBride then went on to say that the prosecutor's repeated personal attacks on the defense expert went so far beyond accepted limits as to constitute obvious error. Those attacks denigrated the expert as a hired gun who was full of it, and who in return for $275 an hour fees, which by the way overstated the actual $175 to $225 per hour fee, made up the testimony that was garbage. So that went too far. In Summers, the out-of-state cases that were cited on appeal were cases that stand for the following propositions. One of them was from Massachusetts, and in that case, the prosecutor's remarks as to the experts were based on facts not in evidence, and the prosecution called the expert witness mercenary soldiers and prostitutes. Another case was from North Carolina, where the prosecutor apparently argued that the doctor was motivated by pay and claimed you can get a doctor to say just about anything these days. Another case was from New Jersey. There, the prosecution's closing remarks suggested that hefty fees would influence experts' testimony because they would want to be hired again by defense counsel. And there was a case from Oklahoma where clearly it was found to be clearly improper to say that defense counsel sought to bring this guy in here from Ohio, pay him to come in here to testify. He's an expert. Here's what we need to testify. Here's your 10 grand. Thank you. That was all a quote. These are all cases that were cited in Summers. The court in Summers, though, acknowledged that the prosecution is entitled to point to circumstances that raise questions about or cast doubt on a witness's testimony and may draw reasonable inferences from the evidence as to the credibility of witnesses. What the prosecutor may not do is express a personal opinion as to the credibility of witnesses or the guilt of the defendant. In Summers, during jury selection, the prosecutor made reference to the fact that the defendant would be presenting an expert who had been hired and paid by one side to testify. During cross-examination of the expert, the prosecutor elicited testimony that the expert advertised in a lawyer's magazine. The advertisements referred to a website. The expert advertised to make money, and he was being paid around $7,000 for his efforts in the case. The prosecution also presented copies of the advertisements, printed pages from the website, and a bill for the expert's services in the case. The court said a witness may be cross-examined to point out potential bias. But again, as I said a moment ago, there are limits. One of the cases cited by Summers, by the way, is People versus Taylor. That's a Colorado Supreme Court case from 1976 for the proposition that within broad limits, any evidence tending to show bias or prejudice or to show light upon the inclinations of witnesses may be permitted. The court in Summers added that cross-examining an expert about his or her fees is an acceptable way to demonstrate bias. The court concluded that unlike the cases from other jurisdictions that I listed a moment ago, not by name but by state, the prosecutor pointed out the prospect that the expert was biased because he had been paid, but the prosecution did not make any reference to the expert's pay or bias in opening statement or closing argument. The court then explained that although the prosecution impeached the expert as permitted by the law, it made no prejudicial comments denigrating the expert. Accordingly, there was no prosecutorial misconduct upon which a claim of plain error could be based. And the court in that case was reviewing for plain error. All right, with that authority in mind, let me go through the specific objections that were raised by the defense. First, Mr. King objects to a slide in each of the following pages, 14, 28, 67, and 77, because they refer to the defendant deceiving people. And the objection is based on Dominguez and Wilson. And I issued an order related to this, but I think it is important to draw a distinction between the type of situation involved in Dominguez and Wilson and the situation we have here. The situation in those cases included the defendant testifying and a prosecutor generally commenting on the character for truthfulness of the defendant and or other witnesses. That's not what we have going on here. Now, having said that, the slide on page 14 is problematic for me because it says that the defendant, it just says he deceives everyone, and he presumably is referring to the defendant, and then everyone is underlined with red. First of all, I don't think it's accurate to say that he deceives everyone. I don't think that the evidence reflects that, and so it's problematic from that point of view. It's also problematic, though, because saying he deceives everyone seems to me to be closer to a general attack on character than some of the other slides that are in question. And so I will sustain the objection with respect to that particular slide. So that particular slide should be taken out. In terms of the other slides on pages 28, 67, and 77, these are slides that Mr. Brockler has represented to the court are being used only for purposes of proving what is at the heart of the case, and that is the defendant's sanity. And of course, related to that are the culpable mental state elements of the offenses charged. So these are not gratuitous shots at the defendant's character or any kind of gratuitous character attack. This is not an attack on the defendant in general. These are specific examples of evidence that the prosecution is relying on to argue that the defendant at different points of the planning and preparation that took place in this case deceived people. And I think that goes to the element of whether he was sane or not. I don't know what else, I don't know how else you can, what other words you can use. I think deceived or mislead. And by the way, there has been evidence of this during the trial. There was evidence that the defendant took certain steps to make sure that people would not know that he was planning the shooting. Well, what is that? That's taking steps to conceal what he was doing from people, and that he did certain things to make people believe one thing when in effect he was doing something else. Well, that's the definition of deceit, isn't it? That's the definition of deceiving. So as long as it's not being used in general, but with respect to specific evidence, and as long as it is being tied to the issue of sanity and the issues related to that, including the culpable mental states, then I think it's a fair argument, and I don't know what other terminology you could use to convey the point. So the objection with respect to the slides on pages 28, 67, and 77 is overruled. The next objection, I wrote down pages 104 and 107 with respect to Drs. Hanlon and Gurr, but I don't see it on 107. I do see it on 104, so I may have misheard. Mr. King, did you say 104 and 107?
I think it was 94.
No, 104 is right. Is it 104 and 94? Is that what you're saying?
Give me one moment, Your Honor.
These are references to Dr.
87.
Hanlon. Oh, 87?
87, Your Honor, is the statement that the defense experts, quote, changed their practice to suit defense attorneys.
All right, and what's the statement on page 104?
It's the argument about Hanlon not contacting parents that we objected to, that I objected to during Dr. Hanlon's testimony. The implication being that I directed him to not interview the parents.
Which slide on 107? Is it the one that says,
That's on page 104, I believe.
104, what slide on 104 specifically?
I gave my copy of the presentation to the court, so I
Sorry.
don't have one here.
Here are the slides. I have it is his normal practice. The next slide is capitulated. That one is in quotes. The next slide is nothing about mental illness before April 2013. The next slide is he asked defense attorneys for it. The next slide is nothing before April 2013. And the final slide is nothing about capacity to know right from wrong before/after 2013.
So the slide would be capitulated and asked defense attorneys about it. I'm sure the argument is going to be he asked to do the interview and I told him no, and he capitulated, which is not correct. And I have no way of rebutting that statement, as I stated in my previous objection.
All right, that's in quotes. Is that something he said, capitulated? Did he say that word?
On the stand, Your Honor. And
Okay.
I don't know if the court needs more, but the court will recall Mr. King, prior to this, went through a lot of, hey, you're a man of integrity, scientists, all this other stuff. You wouldn't do something that you thought, yes, yes, yes. And then when we got to this, he conceded, yes, I capitulated.
Yeah, I disagreed, I think, at the bench conference, and my position hasn't changed. As defense counsel, I don't think you get to limit an expert in how he proceeds. And I understand that it may be for strategic reasons, I get that. But I don't think you get to tell an expert, here are the limitations that you have to work within. And then when the expert testifies, to say, wait a minute, the people can't ask about those limitations that we placed on him. I think it goes to his credibility, it goes to his bias, and it goes to the reliability of his opinions. I understand that you may have reasons for not wanting him to do certain things, but if he deviated from his normal practice because defense counsel asked him to, and that's what my recollection of the testimony is, and he capitulated to what defense counsel said, then I don't know how that doesn't go to his bias and to his credibility and to the reliability of his opinions.
Well, if I may, Judge, that's the issue, is that that's not what we did. We did not limit his testimony or his inquiry into the parents. He asked if we wanted him to test the parents, to give neuropsychological testing to the parents. And we said no, and limited his ability to do that. We never limited his ability to talk to the parents in any way. And when my objection at the time was that I have no way of proving that is an erroneous statement, that he's making a mistake, other than testifying myself, because there's no one else who knows that information. So that's the problem, Your Honor. The problem is not that I am limiting his examination and there's a fair commentary on that. I didn't limit his examination, and I have no way to rebut that statement. That's the nature of the objection.
First of all, that's not my recollection of the testimony. My recollection of the testimony is that there were certain limitations that the defense placed and that he acquiesced. But furthermore, to the extent that he answered a question wrong, then that's on him. And an attorney can't fix that. That's on him. And so to the extent that the defense feels like the only way they can remedy this is by making themselves witnesses, well, that's because their expert apparently, according to the defense counsel, answered a question wrong, not for any other reason. But my recollection of the evidence is that there were certain things that he agreed to do or not do based on defense counsel's request. And when he was asked about that on the witness stand, that's what he testified to. And I think that's fair game because it goes to his bias, it goes to his credibility, and it goes to the reliability of his opinions. Now, if you're saying he gave wrong testimony or false testimony, then that's an issue that we can't deal with in this proceeding. That's the way it goes. If you have something to impeach him, you could have impeached him, but my recollection is that he agreed that there was one or maybe more than one thing that he wanted to do and ended up not doing, and that he capitulated at the request of defense counsel. And I understand that to the extent that any requests were made by defense counsel, it may have been as a result of strategy, but you can't, once you make that decision for strategy or other reasons, you're exposing your expert to being attacked on the witness stand, and to having his credibility called into question, and to having the reliability of his opinions also called into question. So I don't have a problem with the slides on pages 87 and 104, because I think that they accurately reflect the evidence. There's no argument with respect to that, and I don't think there's anything improper about either slide, given what evidence was presented. The next one I have is impression management. And I may have taken down the pages wrong here again. I wrote down pages 123, and then the other one I have is 30, but it may be wrong. Do you know whether I got that one wrong, Mr. King?
Those are the pages I have written down, Your Honor.
And this one doesn't bother me. I mean, there was testimony, including from Dr. Gurr, that the defendant did things or said things to try to alter people's perceptions of him, experts' perceptions of him, including her. Now, her testimony was that he did it because he wanted her to think that he was less ill, mentally ill, than he actually was. That was her interpretation of why he did it. But it's fair game. I mean, there has been evidence of this, whether you want to call it management of what impression other people have of you, or manipulation, that came out in the testimony. So I don't have a problem with respect to those lies, and the objections as to those lies are overruled. With respect to the next ones, pages 129, 130, and 124, these are the ones that say, look how deep I am, look how philosophical I am, and look how smart I am. I do have an issue with these three slides, and the reason why is that I think that the jury, first of all, they read like the defendant testified about them, or like he said this about them, like he said this. And the defendant didn't testify. These are not quotes, so these are not things that he told anyone. This is the prosecution's interpretation of why he did certain things. The prosecution can draw inferences from the evidence, but I don't think it's fair to put it as though it's something the defendant said. So I'm sustaining the objection as to all three. You can argue that the defendant was trying to show how deep he was, or that these acts show the defendant's need to show people how philosophical he was. If those are reasonable inferences from the evidence that you're relying on as a prosecutor, I think you can say that. But I don't think it's fair to put up on a slide the statements that read as though he said them. And so the objection with respect to those slides is sustained. The next group of slides,
Your Honor, I'm sorry. May I ask for a clarification on that?
Yeah.
If I simply change the language to make it clear that they're not his statements, and instead of I am, put he is, would that satisfy the court's concern?
Well, so it's going to read, look how deep he is, and look how philosophical he is, and look how smart he is.
Yes, sir.
I think that's different, and I think if those are reasonable inferences from the evidence, I think those are different for me. So, but just saying them the way that they appear right now is problematic for me. The next group are the slides that appear at pages 36 through 43, 45, 34, 50, 52, 53, 54, and 57. And the objection with respect to all of them is that these are statements by the defendant to different experts, and that the prosecution is using them improperly to establish his guilt, not his sanity. To the extent that these were made to an expert witness, I told the jury that the jury could only consider these statements for the limited purpose of the issues raised by the not guilty by reason of insanity plea. Mr. Brockler is representing to the court that that's not how he's using them, that he's not using them. When I say that that's not how he's using them, I mean that he's not using them as the defense is arguing he is. He's saying, as an advocate of the court, that he's going to use them for the limited purpose for which the court introduced them. And as long, Mr. Brockler, as you're clear about that, and they are specific, then I overrule the objections. I will note that many of these have the actual language about after deliberation, or the actual language about part of the definition of deliberation in there. And so I'm assuming that they're going to go exactly to the issues for which these statements were admitted, but you have to be very careful about that.
The court would also note from these that I've also, where those quotes are taken from a mental health expert for sanity, I've put that mental health expert's name there. And the point of that was to highlight for the court and for the jury, again, that statements made to the mental health professionals are only available to them for purposes of determining issues from the not guilty by reason of insanity plea. They don't just hang out there on their own.
Okay, and if you want to clarify that for the jury as well in terms of reminding them that this evidence was introduced for the limited purpose of the issues raised by the not guilty by reason of insanity plea, that's even better, that's even cleaner. I just want to make sure the jury's not left with the wrong impression. So the objections are overruled with that caveat. The next one is
Judge, if I could, I would just say that that limiting instruction also pertains to the notebook. Many of those slides talk about statements that are made in the notebook, and they're talking about planning and different aspects of how he conducted himself in the theater and prior to that. And I think it needs to be made clear, if that's the argument, that they relate only to sanity.
Yes, I thank you for reminding me. There were some of those slides that are taken from the notebook. Again, it appears from just my review of the slides that Mr. Brockler is using them for the limited purpose for which the notebook was admitting, but you have to be careful again to make that clear to the jury. One thing about these slides before I move on, there were a few slides that have red underlining, and I know you're simply trying to highlight some portions of the slides, but you know the slides were not admitted with any red underlining. I don't have a problem with the fact that the font is larger because that was done by both sides here in the courtroom, but putting red underlining in exhibits that did not have red underlining when they were admitted, I think is problematic, and so those red underlines should be deleted. There are only a handful of them, but I noticed that there were a handful of exhibits that have that red underlining in them, and so based on the Glassman case that I read, I think it's appropriate to have those underlines deleted. The next one is about the kill suit on page 84, and this is argument. That's the people's argument in terms of what description of the suit. This is the armor that the defendant put on before he went to the theater to commit the shooting. That evidence is undisputed. And I don't think that it only comes up in one slide, and it is referred to as a kill suit. And again, given that this is argument, I don't have a problem with that. So the objection is overruled as to that specific slide. The next one is the slide that says on page 93, prosecutors seek justice for those who are wrong. I think the objection was based on how the case law says that it is improper for a prosecutor to tell the jury that he's doing things for victims or to obtain justice. But I think that's taking it out of context. My understanding of the context of that slide is that Mr. Brockler is using it to show the defendant's capacity or evidence of the defendant's capacity to distinguish right from wrong. And he highlighted the word wrong, in fact. Am I right about that, Mr. Brockler? That's correct. Okay, so the objection as to that slide is overruled. The next one has to do with manufactured, and it has to do with Dr. Gurr, and apparently what Mr. Brockler referred to as manufacturing a quote. The problem I have with this slide is the slide is taken out of context. It just says manufacturer, Dr. Gurr. It's on page 109. You know, if you want to say that she took portions from two different quotes and came up with and then combined them both and came up with her own quote in her report, I think that's fine. That's part of what came out in the evidence. But to just have a slide that says Dr. Raquel Gurr and then below it manufactured, I have a problem with. So I will sustain the objection. That's based in part on the case law that I cited earlier from McBride and Summers. The final one is page 119, and this is the reference to collateral damage. And Mr. Brockler argued that he's not going to use collateral damage in the context of guilt, but rather in the context of the issues raised by the not guilty by reason of insanity plea. The problem with this particular slide, however, is that on the same page, there is a name, Caleb Medley. The name Farah Sudani is in another slide, and that's the only name that appears in the slide, is Caleb Medley. And in another slide, the only name is Farah Sudani. Then there is a picture of, I believe it's Farah Sudani in her injury in one slide. And then it says Dr. William Reed, plus 58, plus page report. I think the way that this is set up, it is problematic because it is specifically referring to the injuries. It is connecting the injuries that some of the victims incurred and the term collateral damage. And that's problematic for me, so the objection with respect to that particular slide is sustained. In terms of the global objection, I think I've addressed all of the objections. I think that the global objection is to PowerPoint presentations in general. The defense, it's my understanding, is using part of a PowerPoint too, and the defense used a PowerPoint presentation with a couple of experts, at least one expert witness. I think it was Dr. Gurr, and maybe there may have been a PowerPoint presentation with respect to another expert. I can't remember now. It may have been with respect to Dr. Hanlon. So PowerPoint presentations and visual aids have become more and more popular in trials. The reason is the lawyers realize what experts in the field have said, and that is that visual aids can help the jury understand things better or remember things better. But that is also part of the reason why you have to be careful with them. And that's why I'm trying to be, in addressing all the specific objections, I'm trying to be as careful as I can in following the law and setting the parameters that I think are appropriate. Now, I want to make sure I caution the prosecution that to be careful to avoid opinions. Obviously, a prosecutor is not allowed to have his own opinion expressed to the jury in closing argument. It has to be based on the evidence and reasonable inferences raised from the evidence. You're allowed to make argument. You're not allowed to interject your opinions about the evidence. So that's number one. Number two, you have to be careful not to confuse arguments with the evidence and not to mislead the jury. I'm not saying that Mr. Brockler would intentionally mislead the jury, but even if you don't intend to do that, you have to be careful not to do that. And so be as careful as you can, Mr. Brockler, when using your PowerPoint presentation so that it is clear when you're referring to evidence, for example, if it's in quotation marks, and when you're not referring to evidence and you're referring to argument. I just don't want the jury to be misled in any way. And then I have talked about the exhibits that need to be modified already. Given those cautionary remarks, the global objection to the PowerPoint presentation is overruled because I think in general PowerPoint presentations, as I said, are appropriate. I'm not aware of any rule that says that you're not allowed to have slides that contain sort of an outline, if you will, or that contain a few words to remind you as you're making your way through closing argument what your next point is. This is a closing argument for each side that is 2 hours long. I have given each side 2 hours long, and it is difficult to make a 2-hour closing argument even when you're splitting the 2 hours into opening closing argument and rebuttal closing argument. It is difficult to do a 2-hour closing argument without some kind of outline or some kind of aid. And I don't think there's anything improper with respect to using the PowerPoint presentation as an outline to guide you through your presentation. As I said, my understanding is the defense is doing some of that too. The defense did that with Dr. Gurr as well. So just be careful to make sure you stay within the legal parameters. Is there anything else at this time before we break for a short lunch?
May I ask for some clarification on 2 points, Your Honor?
Yes.
That Back to the 109, which was the slide regarding Dr. Gurr, where I had put manufactured in between two slides setting out her quote from her report and then what the real quote was from her notes. Would it resolve the court's concern to put manufactured quote as opposed to just manufactured? And Judge, I totally get where you're going. In isolation, it doesn't make any sense. But in the context of talking about it, it's to say, this quote here, it was manufactured. She put it together out of two other quotes, and that's what I sort of go to do. So I don't want to step on the court at all. I just want to make sure I understand.
Does the defense have a position on that? Mr. King, you haven't been heard on that, so I'll give you a chance.
I would maintain my objection, Judge. It isn't manufactured. That's incorrect. What apparently happened was there were two different quotes, and she just combined them into one quote in her report. They're still quotes. They're not things she made up or manufactured. They're evidence in the case. And if he wants to comment on how she wrote it in her report, that's fine, but they're not manufactured.
I'll sustain the objection. It causes me concern to have the word manufacturer on a slide. I think, as I said, Mr. Brockler, it's fair game for you to argue and remind the jury. And the jury, this is a smart jury. They remember things. They will remember, and they will remember the exchange. And you can tell them she took two quotations, two quotes, she put them together, and your argument is, and you asked her about it, is that this then meant something different than what was said. I think that's fair. I think to say manufacture, especially in a slide, given how careful appellate courts want trial courts to be when it comes to using words such as manufacture, as it relates, when it comes to using words such as lie, when it comes to witnesses, I want to be careful about that. And so I'm going to err on the side of caution and sustain that objection. So that objection is sustained. Anything else? Any other clarification that you wanted, Mr. Brockler?
Well, on that one, would inaccurate be fair?
Inaccurate is fair, yeah. You can say inaccurate.
On the collateral damage one, Your Honor, just to be clear, that I understand the court's ruling on it.
And if you, hold on, sorry. If you say inaccurate, I'm assuming you're going to say inaccurate quote.
Yes, sir.
Okay, I think that's fair.
On the collateral damage slide on page 119, it follows the video clip of him talking about collateral damage and how he viewed the non-deceased victims he created. Is that out as well? Take both those things out, given their proximity to the other victims?
Yes. Yes. What concerns me is connecting the two. I know what you're trying to do, and if there is a sentencing phase, perhaps this is fair for that. I don't know. I'm not ruling on that, so don't quote me on that. I'm just saying that it doesn't, to connect the two, to say, well, he referred to these injured victims as collateral damage, and then show the jury, here's what he thinks is collateral damage. That's what's, I think, could be very prejudicial, and it doesn't go to the issues raised by the not guilty by reason of insanity plea.
If I separate them, does that resolve the court's concern if I
Yes.
there's some disconnection?
Yes, as long as that connection is not made in any way, then that takes care of it. All right, Mr. King, here are your slides, thank you. All right, how long do you need for a lunch break, folks?
I have no preference on a lunch break. Can we make that a court's exhibit, Your Honor, the original of the PowerPoint, please?
Yes, do you want this copy back right now, though?
Sure, I'll
All
do
right.
that.
Why don't we mark it later, if it's okay with you, that way you can have it for now. Thank you. All right, is it okay if we take 15 minutes? Is that okay with everyone? Does that give everyone a chance? Okay, let's take 15 minutes. The court will be in recess. Thank you.
Please rise.
Jumping now back inside our 7 News newsroom, I'm here again with our legal expert, Dan Recht. We are going to get 15 minutes, which will bring us to 1:15 as I peek at my clock across the room. 1:17 or so before the jury gets back in the room and we get to start hearing these closings. Now, we want to take a moment here to discuss with you some of these rulings that the judge has made. I know you were taking notes, but I'm going to read from my notes here. Sure. The last one he did was that the global objection to PowerPoints is being overruled. That is, the PowerPoint slides that both sides have are going to be admitted. Is that exactly as you expected?
That is exactly as I expected. PowerPoints are nothing more than a high-tech chart or graph, and those have been used for 100 years.
All right, next thing, is, and tell me again if this is what you expected. The judge reminding the attorneys to be very cautious not to confuse argument with evidence. Common, uncommon, is it expected, is it not expected?
Totally common, and the point is that the slides have the same rules as what a lawyer might say.
Mm-hmm.
In the slide and in what you might say the old-fashioned way, you have to distinguish between argument and evidence, and you can't try to persuade the jury that your argument is the evidence. You simply base your argument on the evidence.
Gotcha. Let's see. And by the way, folks, I am reading from our Scribble Live chat room where I take notes throughout the proceedings, or where our staff take notes throughout the proceedings. And so the next item that I have is a slide with Farah Soudani's injury and related to the phrase collateral damage. That is being sustained. That objection is being sustained. Do you have any inkling about why that might be?
Yeah, any piece of evidence can be shown to the jury in closing argument. But when you editorialize about it on the slide, when you call it collateral damage, that's the part that upsets the judge. So I suspect if they took any language off it and just showed the slide without their editorializing, the judge would have allowed it.
And certainly that's what George Brockler and his staff are going to be doing now, is making these modifications. One of the other modifications was underlines. Apparently both sides played with font sizes in their slideshows, and that the judge said was fine. But red underlines, or the judge has ordered that those be stricken from the slides.
Yeah, that was a judgment call. I'm not sure every judge would make that judgment call. It's a discretionary thing. He seems to think that is somehow prejudicial, and maybe it is, but there's no law on that. He's just making a judgment call on it.
Got it. The next item, the phrase kill suit. This is what George Brockler has used for weeks now to refer to the gunman's all-black body armor, the partially obscured gas mask. The judge is going to allow George Brockler to continue using that phrase. Is that what you would have expected?
Yeah, so long as the jury understands that's George Brockler's phrase, and that's his argument and his editorializing, then that's not surprising. That's just part of the argument.
Sure.
I'm not sure, as a judge, I would have allowed it, but it doesn't surprise me that he did. Just another one of those judgment calls.
Sure. Another item I have here is that the judge agrees that Mr. Brockler needs to make very clear that pages from the notebook that appear in his slideshow are admitted only for the purpose of discussing sanity. That was the reason why they were introduced in the first place. How could it be, or could it be? Is the judge being much too careful here?
Yeah, no, but keep in mind, in this case, there's other sanity cases that might be different. In this case, there is no question about who did the shooting, who did the act, who was in the theater. The defense has agreed that it was James Holmes. So these cautionary instructions in this particular case are sort of boilerplate, and no one cares too much about them, because everyone knows, and certainly the defense knows, that and wants everything to come down to sanity or insanity.
Right. Another item that I wrote down from these objections, the judge has decided to overrule that slides about the DA's slides about deliberation, but cautioned DA George Brockler to focus directly. And of course, I can't even interpret my own notes anymore. So I think what this was getting at was the idea that the DA is trying to prove that these deliberations are related to legal sanity, right? Let's see what else we have here. The judge does have an issue with 3 slides about, look how smart I am, look how deep I am, things that he was saying he was narrating the gunman's supposed thoughts, but they were never actually direct quotes. The judge, of course, said that those appeared to be quotes and those shouldn't be allowed.
Yeah, and that makes sense. And the same thing would have been true if he had just said it without a PowerPoint.
Right.
Because the judge is worried that the jury is going to think, oh, was that a piece of evidence? Did Holmes say,
Right.
look how smart I am? Because the jury can't remember every little piece of evidence for 4 months.
Right.
So the parties, the lawyers and the judge have to be really careful that what the lawyers say in closing argument or what they put in a PowerPoint presentation in closing argument is in fact evidence that was in the case. And if it suggests something that wasn't evidence, like that Holmes said something he never said, well, then the judge is absolutely right to keep it out. I would have kept it out.
And the judge said that these inferences are fair, but slides appear to be quotes, and that's the reason they're not fair.
Right.
Of course,
remember Brockler said, well, what if I change it to, he thought he
Right.
was really smart.
Or look how smart
or
he
look
is.
how smart he is. And
Uh-huh.
the judge said that's fine, as long as it doesn't look like it came out of Holmes' mouth.
Right. So at this point then, that's the end of my list of notes here, but I see a question for you, if you don't mind. Ask if they were required to show the slides before today. And I know that they said earlier they didn't exchange these slides until this morning. Why didn't they exchange them before today? Why couldn't they have spared us all of these delays?
Well, that's an interesting point. I mean, they can't prepare their closing argument or the aids they're using in their closing argument until all of the evidence is over. So they couldn't even start to accumulate what slides they want to use until the evidence was over last week. But the judge could have been a bit stricter and said, by Monday morning,
Right.
at 8 o'clock, I want you to exchange whatever demonstrative evidence you want to show in your closing arguments.
Mhm.
And instead, he didn't impose that kind of deadline, and therefore the parties exchanged them this morning without any violation of a court rule.
Yes.
So maybe in retrospect, and the judges had to make a gazillion decisions here,
Mhm.
but maybe in retrospect, he probably wishes he had said to them, get those to the other party by 8 o'clock Monday morning.
Right. Well, and now we're looking at staying on with this coverage. Obviously, that we would be staying on this through 6 o'clock tonight, probably.
Well, it's 4. He's giving the parties a total of 4 hours, and there will
Right.
inevitably be some breaks. So, yeah, I would bet it's going to go until 6 o'clock or so.
Mm-hmm. Well, at this point, folks, we are, 7 minutes or so away from court resuming. Dan, as I look at you, I hate to be a busybody, but I'm noticing that your microphone has fallen to the floor here. So I'm going to hop down from my stool and get that back to you, because the next question I want to ask you about is regarding what you think we should all be listening to in these cases. And if you clip that there on your tie, it'll work just great.
We should be listening.
Thanks, Dan.
We should really be listening to the difference, and I don't know what the difference will be, between the arguments of the prosecution and the arguments of the defense. And we should be keeping in mind, hopefully like the jury is, that the burden is on the prosecution. I mean, the defense will stress that, but it can't be more important in this case and in any other case. The prosecution has the burden of proving this beyond a reasonable doubt. And that's the interesting part. Have they done that, and does their closing argument persuasive in trying to do that?
Right. When we hear this 2-hour discussion from each side, and we know this process is going to be broken up, one of the things that I've seen discussed in the chat room throughout the day with George Brockler deciding to save time strategically, what is his reason for doing that? Save time for a rebuttal.
Oh, because there's huge advantage to being the last one talking, the last argument, because psychological studies are uniform in saying that juries best remember the first things they hear and the last things they hear. So there is just zero chance the prosecution's not going to use their rebuttal. They literally want to get the last word.
Now the defense team, knowing that that's coming, knowing they won't have the last word, and also knowing that their case is much more of a educational case, a cerebral case, how are they going to make sure that their points are vigorous and caught and stick in the jury's minds?
You know, you're going to hear something like the following from Dan King. At the end of his 2 hours, he's going to say, I don't get to come back up here, ladies and gentlemen. This is my one shot. And so remember, ask these questions to yourself. See if George Brockler is answering these questions. Was Dr. Gurr effective? Did she even create a doubt in your mind? And so he will raise questions that he wants the jury to remember to think about during Brockler's rebuttal.
Right. So we know that George Brockler has 859 slides to show. The defense, we've heard, has some kind of PowerPoint. Since you've been working with us throughout this trial, what kinds of things do we think the defense is likely to bring up again for the jury to see during their 2-hour period?
The defense case is going to hone in on, the defense case could be distilled to Dr. Gurr and her reputable background, her being this Ivy League medical school professor that's not a professional forensic expert, who stresses that Holmes was insane. You know, there'll be lots more than that, of course, but that will be the emphasis, for sure.
Is the defense likely to use any of the physical exhibits that we see under blankets and plastic in the courtroom right now?
Well, I don't know if they're going to use any of them, but my strong suspicion is those are there because Brockler wanted them there, and it will be primarily him showing them because they're not unfairly inflammatory, they're pieces of evidence, but they have an emotional impact, and that's what Brockler's looking for, an emotional impact.
I feel like we've talked about this before, but it seems like with all of those items that we can see through the camera in front of the court recorder, all of these 860 slides, how is he going to get all of this done in 2 hours?
Yeah, again, I'm just guessing because I've not seen a lawyer do it quite that way. I'm guessing they have someone working the slide machine. Although if I remember right in opening, he was pretty good at switching the slides and a little thing in his hand. And it's going to be constant. Yeah. Everything he says is going to be reflected in a slide. So there won't be a time when there's not a slide being shown to the jury, and he'll just run through them as he's talking.
Sure. And folks, we should be resuming court in just 2 or 3 minutes here. Let me ask you, from your personal experience, how does a lawyer prepare? They know the evidence, the case is ready, it's ripe for closing arguments. What are attorneys doing? Do they rehearse? Do they look in the mirror and talk and read cue cards? How do they get ready to actually present it to a jury?
Well, younger, less experienced lawyers for sure rehearse, and you're encouraged to rehearse. And when I teach about this stuff, I encourage less experienced lawyers to rehearse, either to a family member or in the mirror. But my guess is neither of these lawyers has rehearsed it verbatim. I would bet, well, I know with certainty, each of the lawyers has memorized their first line or two, and you can be sure those are meant for emotional impact from both sides. So the first few lines and the last few lines have been memorized. The other 2 hours are extemporaneous. Not extemporaneous to the point they don't know what they're going to say. They know darn well very much the subjects they're going to cover and how they're going to cover them, but they haven't memorized 2 hours worth of closing argument, no way. And you never want to walk up there and read from your notes because that creates a barrier between you and the jury, and you want an emotional connection to the jury. So you do not want to have a verbatim notes. You might have some like bullet points so that you don't forget certain subjects as you're standing up there, and my guess is they both will have that, but no verbatim notes, none.
Right. Well, and I should point out that even though our view of the courtroom has the screen that's behind the witness stand, there is another screen over top of the jury. And so I would imagine George Brockler and Dan King, as they click through their slides, having that prompt them that way. which Yes. certainly, it's like a teleprompter on television.
Well, it is, except it's not verbatim.
Oh,
Yeah,
true.
exactly.
Yeah.
So it jogs their memory about what they want to talk about, and they'll occasionally quote from their own slides. But they very much want their arguments to feel from the heart and not seem like they're just reading a prepared statement.
Sure. Forgive me, I'm going to scroll down here and see if there's any other questions
Of
for us,
course.
because by my watch and by our wall clock, it is 1:18. We should be resuming very, very shortly. But at the moment, as I look over on our control panel, we still have that Colorado Courts logo ready to go. This question here, I'm not sure what this means. A soft transition state and a hard transition state. I think that was in reference to mental health and things. Nikki, if you would like to resubmit that question to give me some clarity so that Dan and I can chat about that, we'd be very happy to explain that for you.
Yeah, I'm not sure what she means either.
Yeah. Well, with a sanity case like this, and the burden being on the prosecution to prove that he was sane,
Beyond a reasonable doubt.
Beyond a reasonable doubt. And that's a very important element of this, that reasonable doubt factor. What do we think George Brockler is going to say?
George Brockler is going to first present and summarize the emotional evidence and the just total devastation to the victims and the families, and how horrendous an act this is in the prosecutor, well, in anyone's mind. And then he's going to emphasize that the experts that say that Holmes was sane were not paid for by the prosecution. They were court-ordered evaluations. And he will criticize hard and long Dr. Gurr for, in his mind, being a defense-paid expert. Now, I don't know that that's fair criticism of her. She's a college professor, but it's fair game. He can make those arguments because, in fact, she's being paid by the defense and not by the court.
And now let's flip it around, knowing that they don't have the burden of proof. What is the defense likely to try to drive home?
Well, they're going to stress all day long Dr. Gurr, and that Dr. Gurr's strong opinion is that Holmes was insane. They are going to stress that everyone, even the prosecution witnesses, agreed that he is severely mentally ill and that there are elements of schizophrenia beyond a doubt. And they are going to say to the jury, really, they will say, did Dr. Gurr not even create a doubt in your mind? Because if she did, that's, they haven't proven their case beyond a reasonable doubt that he was sane, and you have to say not guilty by reason of insanity.
Now, I notice both sides had two admitted experts who came to the court to give their opinion on legal sanity or insanity. With the defense, Dr. Woodcock was their very first witness. He was their leadoff hitter. But it was a very vigorous cross-examination, to the point that some people were, on our chat room, were blown away by just how hard George Brockler came out and attacked Dr. Woodcock. Do you think that that makes him more or less likely to be brought up by the defense?
Oh, he'll be brought up. And it depends if the defense team agrees with your viewers that he was beat up badly. If they think Woodcock was beat up badly and lost credibility, then they won't stress him as much as they stress Dr. Gurr. But of course, there's people that believe Dr. Gurr was beat up pretty badly too, and so it's a judgment call on their part.
All right, folks, court is resuming. We're going to get ready now, hopefully, to hear this first closing argument from DA George Brockler. Thank you, Dan.
Good afternoon, everyone. This is the case of the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. We are outside the presence of the jury. Before I bring the jury in, I have two things. One, I just want to confirm that with respect to any references to deceiving, and this is on pages 28, 67, and 77 of your PowerPoint presentation, Mr. Brockler, those all refer to activities that took place before the shooting. Is that correct? We're not talking about deceiving, for example, an expert witness.
No, Your Honor, could you, 28, you're correct about that one?
67 and 77.
Yep, that's correct, Your Honor.
Okay, great. All right, and that was, I just wanted to make sure, because I ruled based on that understanding, so I wanted to make sure that was accurate. Before I bring the jury in, I want to address the spectators in the courtroom. This is a public trial, and I want everyone to feel welcome and comfortable here. That's important to me. However, you must observe proper courtroom decorum. I am sensitive to the fact that this case may evoke powerful emotions. I fully understand that. For that reason, I have not prohibited emotional reactions. To the contrary, in Order D-79, I recognize that some visible emotional reactions are inevitable and appropriate. What I have prohibited are audible comments and emotional outbursts that may improperly influence the jury. If at any time you feel the onset of an emotional outburst, please quietly and discreetly exit the courtroom. You may return to the courtroom when you're ready to do so in compliance with my order. In general, so far in this trial, there have been no issues with anyone in the gallery. I thank you for that, and I ask that you please continue to conduct yourselves as you've done throughout the trial. Please remember that it is my duty and responsibility to ensure that both parties receive a fair trial and to uphold the dignity of the court. All right, with that advisement, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good afternoon, folks. I hope you had a good lunch. I apologize for the delay. As I have mentioned before, delays are unavoidable. There are times when issues come up and I have to take my time with them. I can't rush things. Please don't hold it against either side. If you need to hold it against someone, because that will make you feel better, hold it against me. But don't hold it against either party, okay? All right, with that, we're ready for the next step in the proceedings, which is closing arguments. And as I indicated to you, the prosecution goes first. Mr. Brockler.
Three years ago, next Monday morning. Your Honor, I'm sorry. I'm looking at a TV that doesn't have anything up on it. Can we get me fired up?
Yes.
May I blame the court for that as well?
You may not blame me, you may blame my staff for that one. Just trying to spread it a little bit.
3 years from next Monday morning, 3 years ago, 400 people from this community filed into this theater. They came in happy. They came in hopeful of being entertained. They came in, some alone, some with loved ones, some with parents, and some with children. They came in hoping to see a story of a hero dressed in black, someone who would fight insurmountable odds in the name of justice and trying to protect others and for peace. But that's not what happened. Instead, a different figure appeared by the screen, dressed all in black. And he came there with one thing in his heart and in his mind, and that was mass murder. He came in with overwhelming firepower. He brought with him over 700 rounds, including steel-penetrating rounds. And he shot anything and everything he could. On July 20th, 2012, in this kill box, 13 miles from where we sit right now, this guy walked into that theater and tried to murder everyone in it. But he was successful in, and I use this term delicately, only killing 12. Now, as we've gone through this case, this guy created so many victims. Admittedly, there was a sense of rote or routine about it. Some victims, even beyond the deceased we see here, and we struggle to try to remember over the last 2.5 months, some of them don't ring a bell, and we'd have to go to our notes. Because he made more than 12 deceased. He made 70 other victims. Some names you'll recall, some names you won't. Some sat up here for all of 10 minutes, and it felt like all they were allowed to tell us was they went into that theater to watch a movie with someone, they smelled tear gas, something horrible happened, and they were injured. But this part of the case makes them more important now. There's no way I can go through all of these victims with you, just like I told you in opening, but your notes and your memories hopefully will help guide you to what they told you. 70 people were injured in that theater. You heard from 69. The only one you didn't hear from was Ethan Roars, because he's 3. Instead, you heard from the people that were with him. One of the people that you didn't hear from was Matt McQuinn. You may remember that Matt was 27, and he went to the theater with his roommate and the woman he loved and had hoped to marry. No other victim was shot as many times as Matt McQuinn, 8 times. And you'll recall from that horrible image in your mind that he was near the bottom of the theater seating, legs contorted underneath him in an unnatural way. He did that. And like all the victims he created here, he did it for one purpose: to make himself feel better and to increase his theoretical sense of value, not to anyone else, to himself. Now look, this is the portion of the case where we have to talk about the law. My goodness, the judge read to you some jillion instructions, lots of pages. And I want to go through some of that with you now, and you'll get them, obviously, to take back and look at. This one is the first one I think that we should focus on. It talks about reasonable doubt, and it tells us reasonable doubt isn't some vague or speculative, guessing, imaginary doubt. It's a doubt that's based on common sense. That means you get to use your common sense in evaluating every piece of evidence in this case, and that includes evidence from people that have been called experts by the court. There are charges here, and you've heard them, and they overlap, and we'll talk a little bit about them, and I'll try to make some sense of them. Murder in the first degree. There's 2 kinds, remember? There's after deliberation, and there's extreme indifference. These same 12 people that guy murdered applies to both of these charges. Now, the elements of these things, and the way every charge works is, it's somewhat like a recipe or a math formula. If you're missing one of the elements, you can't get to the right answer. So it's our burden to prove to you beyond a reasonable doubt every single thing with a number by it up there. Not because I say so, but because the judge says so. Now, some of this stuff isn't really hotly contested here. That the defendant There has been no evidence that anyone else on the planet Earth walked into that theater dressed in bulletproof garb, armed to the teeth, trying to kill everyone in the theater. Just him. In the state of Colorado, at or about the date and place charged. No one says this took place anyplace else or at some other time. The other part of this is that he caused the death of someone not himself. There's really been no evidence at all that anyone other than this guy seated right here killed all those people. So what we will discuss are the things in the middle, after deliberation, with intent, and thankfully the court gives us some instructions on that. And you're going to have to forgive me here. I thought I could do this without this. Oh, man. The term after deliberation is defined for us in a pretty good way. It is a decision after the exercise of reflection and judgment. And you know what? It's never hasty. The opposite of hasty. You've thought about it. A person acts with intent or intentionally when their conscious objective is to cause the specific result they were trying for. It really doesn't matter if the result occurred, and that's helpful to us in the attempted murder charges, and we'll talk about that. Now, how is that different than extreme indifference murder? Well, we still have the defendant in the state of Colorado, and he caused the death of another person, not himself, but in the middle we have some different elements. Now he has to act knowingly, and knowingly is defined only as with respect to the conduct he's engaged in. He's aware that his conduct is of such a nature that it could result in what? Right here, with respect to a result that is practically certain to cause that result. Here's some key language for extreme indifference. He has to act with attitude of universal malice, manifesting an extreme indifference to the value of human life generally. This isn't just risky behavior. This is behavior that is obviously going to lead to potentially the death of another person. He also has to engage in that conduct that created a grave risk of death. So here's how we might analyze that charge regarding these people. This is just an example of working through this instruction. We know he wants to kill people. He knows that there are people in the theater. He creates a kill box through all of his planning and his efforts. He goes there with 700 rounds. He surprises the people he wants to kill. He traps the people he wants to kill. And he fires steel penetrator rounds at the people that he wants to kill. At people. And he causes their death. He's aware when he shoots those steel penetrator rounds throughout that theater that it's practically certain to result in the death of people. He's also, in doing that, isn't he evidencing an attitude of universal malice, an extreme indifference to the value of human life? And when you work through the checks that way, that leaves us with one thing at the bottom that we have to prove beyond a reasonable doubt, and that's that he wasn't insane when he did it. So can someone be guilty, and this was a question asked, of both extreme indifference and after deliberation murder? Absolutely they can, just like here. So for instance, when he goes into that theater, we know that he intends to kill everybody he can in that theater. That's his intention. He's deliberated on it, and now he's carrying out the plan. But the way he goes about it in the theater, specifically the steel penetrator rounds, the way he shoots at people sometimes to try to get them to stop fleeing, going through the walls, going through seats, he does so in such an extreme manner, it shows this universal malice and this grave risk of death to others. He didn't go in and line people up and shoot at them face to face, one-on-one. This is both. Now the attempted murder, again, there's attempted murder for after deliberation. All 70 of these victims apply. There's all the same elements with this one exception. They didn't cause the death of the person. Instead, they had to take a substantial step towards it. Same thing with extreme indifference. Same elements as extreme indifference, but you didn't cause the death, you took a substantial step. So what's a substantial step? You probably didn't need the law for this. It's conduct strongly corroborative of that person's purpose in the commission of that offense. That's what attempt is. And if you didn't have that instruction, you'd use your common sense and it would be just like that. So, here's that last piece. He said, I'm not responsible for what happened because I was insane. And so now we have to prove beyond a reasonable doubt that he was sane. Here's what the defense of insanity says. First, he's got to be insane at the commission of the act. Not 4 months later, not February of 2015, not today. Got to be back on July 19th and 20th of 2012. So one of the things that is an issue here is he so diseased or defective in mind at the time that he's incapable of distinguishing right from wrong? And that's defined for you too. Incapable means, just like we've talked about for months now, measured by societal standards of morality. It doesn't refer to, however, a purely personal and subjective standard of morality. The law doesn't care what he thinks is right or wrong. It cares if he knows what society thinks is right or wrong. Here's the other part of that. He could have a mental disease or defect that prevents him from forming the intent to act, to deliberate, or even to act knowingly. That's another component of insanity. But there's a cautionary tale here. Do not confuse mental disease or defect with moral obliquity, the idea that someone just simply rejects society's norms and standards. Mental depravity, passion growing out of anger, revenge, hatred, or other motives, those things don't get you to insanity, because when an act is induced by these causes, the person is accountable to the law. So what is a mental disease or defect? Only those severely abnormal mental conditions that grossly and demonstrably impair a person's perception or understanding of reality. Now, to some extent, it seems like it's been taken for granted that if someone has a diagnosis of anything that we've talked about, like's been talked about for this guy, that automatically makes it a mental disease or defect under the law. And you can see that's not true. In fact, if you conclude that the evidence has shown that he's mentally ill, has a mental diagnosis, but it hasn't grossly and demonstrably impaired his perception or appreciation of reality, then that's it. We're done. There is no more insanity. Here's the other thing that we know. It's not enough to have that. See, here's what Colorado could have done. Colorado could have had a law that says, if you have a mental disease or defect that grossly impairs your ability to understand reality, that's it. Game over. Didn't do that. Instead, they said, you need more. You need to have it be such that it affects your capacity to know right from wrong and your capacity to form the intent to act. So here's what we know is not insanity just by virtue of it existing. Mental disease or defect. 1 million different diagnoses that in our own life experiences are serious but not enough on their own to be insanity. Bipolar, depression, ADHD, Asperger's syndrome, antisocial personality disorder, delusion, psychosis, schizotypal personality disorder, schizoaffective disorder, even schizophrenia. In and of themselves, they're not enough under the law. You have to have something more. And who says that? How about every single mental health witness that we've had in this case has said that that's not enough. Just because you're schizophrenic or ADHD or schizotypal, that doesn't mean you're insane. DSM-5 says the same thing. Remember that when we had a couple different people read it up here, there's a cautionary instruction in there. Do not use this book to simply try to figure out sanity. It takes something more. It takes something forensic. Your common sense tells you that too. From your own life experience, the people that you know, that you've encountered, maybe even people in your own family, that simply having a mental disease or defect or a diagnosis doesn't make them insane under this law. Our law says that that's not enough. So it's not enough to know what the diagnosis is. We've spent a lot of time trying to drill down on what's the diagnosis, and what the law tells you is, doesn't matter. The diagnosis is irrelevant. It's how it affects the person. Here's some other stuff that isn't relevant to the law, but for someone's mental illness or their desire to want to do something. You don't see that in any instruction that's been given to you. That's not part of the law. It's not about November of 2012. It's not about the things that we spent about a week to a week and a half going over 4 unmedicated months after that guy was locked up and was facing numerous murder charges and potentially the death penalty. What happened in November of 2012 cannot instruct us on what he was capable of in July of 2012. You know who said that? All those mental health providers that came in and talked about him. It's not about an MRI taken only months ago. Now, the questions can and were asked about what could it have told us if it were taken earlier. Here's what we know. No matter when it was taken, it's simply not good enough. The technology isn't good enough to make it diagnostic. More than that, we don't know what it would have looked like in July of 2012 to not diagnose something. And one of your questions revealed something even more telling, and that is we don't even know what impact the antipsychotic medication the defendant has been mandated to take for the past couple years has on that MRI. So discussions of this MRI cannot help us know what his brain was like in July of 2012. What will tell us is behavior. We can also look at changes. And what you know from every single person that has come up here and testified, from CU, his girlfriend, his friends, Drs. Fenton, Drs. Feinstein, anybody that saw him over that year-plus period before he committed this horrible act, they've all said the same thing. Guy was exactly the same at the end as he was at the beginning. Who says so? Everybody. You cannot find someone that says he was different. So we look to function, and that's what the mental health experts say. Not diagnosis, it's function. Capacity. Did that mental disease or defect demonstrably impair him, even before we get to right or wrong? So let's start talking about some of the stuff that we know from the evidence. He knows his plans are against society's standards of morality because of deception. Look at the things that he does with his parents, how he communicates with them. 3 days after the G-Chat, where he talks with Gargi Dada about human capital, these are the emails he exchanges with his parents about a Roth IRA. Not much stuff going on in April 1st. Been working with stem cells. School's boring. Seems like a degree factory. Mother's Day, he calls his mother. Shares nothing of this with her. In fact, when he calls her, it's 3 days after he purchases the tear gas, the gas mask, and the handgun. And he says nothing. And he gives no indication of anything wrong. One of the victims that you may recall was Rebecca Wingo, and she was a mother of 2 daughters, a single mom. 32 years old, she went to the theater that day with a man named Marcus Weaver, who you heard from. She went there for a nice night out, not having to care for the kids. She, like almost all the other deceased, was shot in the head and in her torso. On May 21st, after Mother's Day, he's emailing his mom, finished the quarter, choosing a thesis lab. By June 9th, he'd purchased a handgun, a shotgun, and assault rifle, and here's the communications with mom and dad. Not much news here. We talk about the weather. And then on June 11th, after it's become official that he's not going to be in school anymore, he tells his parents, I'd prefer not moving back with you, if only as a last resort to homelessness. June 12th, after he owns all those things, he gives 2 alternate emails. They have no indication from him of anything. By June 16th, he's purchased a 100-round drum, magazines for his weapons. On June 16th, after that, he's emailing his mom about applying for unemployment. And you know what? He did apply for unemployment. Nothing else new going on. By June 20th, he purchases targets, laser sights for his weapons, bullet, blocker, jacket. And here are the conversations with mom and dad. She emailed him in Spanish. He emails her back in Spanish with the cutesy sign-off, hasta la vista, baby. To his dad, he says they denied the claim for unemployment insurance. Again, no indication of his true motives. June 27th, no fires or smoke. Not much else going on the 4th of July. And 7 days before he unleashes havoc in that theater, his parents reach out and say, we'd like to come out in August. How about the 10th or 12th? And his response is, I don't have any plans for that weekend. Now that's not deception of law enforcement. That's deception of his mom and dad, also part of society. But there's more. How about his girlfriend and his friend? He tells Dr. Woodcock that he attempts to recruit them subtly, lightly, when he has that G-chat with Gargi. And I want to take a moment to remind you of this. There will be pictures of the notebook up here. There will be quotes that you will see are attributed to statements that the defendant made to mental health professionals. And you have to remember that those things can only be considered by you for sanity issues. Nothing else, not any other part of the charges, just the issue of sanity. He says he's going to test the waters. But now you know what he knows? They reject his philosophy. These members of society push back. Gargi tells him, it may satisfy you, but it doesn't help fulfill your purpose. And he says, well, it still makes my life more meaningful. And she says, I don't see how it's useful. And she comes back hard on whatever he thinks or tells us is going to be his delusion. You're not getting anything incorporated into you. It's not as if by killing someone, you're making yourself stronger. You're just taking away a life, and that seems like destruction. He goes out of that and knows that his girlfriend, the only woman he's ever loved, rejects that idea. Another indication society doesn't agree. Gargi shows it to Ben. Ben is his longest and only friend at grad school, other than Gargi. Remember when Ben Garcia gets up here and testifies, amongst other things, he says, you know what, the defendant seemed to be angry at the world a lot of the time. And he was a very deliberate guy. Well, he and Gargi take that chat and they go and talk to him about it. Now he knows his friend has read it too, and his friend rejects it too. They ask him to share it with his therapist, and he says, I am. But you know what? He's not. He doesn't. He won't. He knows now that these other people have heard his philosophy, and they disagree with him. That relationship ends shortly after he has revealed to them what he's thinking. How about Miss Allen? Does he come clean with her? No. It's July 8th. It's now 11 days before he'll create this bomb inside his apartment. She asks, are you back in California already? And he says, still have a couple months on the Colorado apartment lease, knowing full well he's never going to fulfill that lease. How about Drs. Fenton and Feinstein? Never tells them, denies a plan, denies the target. Why does he keep seeing them? Why does he keep seeing them? It's the same reason he didn't drop out of school. And here's what he told Dr. Reed. I thought it would look conspicuous if I just dropped out without any warning or any justifiable cause. So I dropped out with the reason that I failed prelims. The questions asked by Dr. Reed, well, what if you just dropped out? It probably would have raised red flags to my professors and to Fenton. That's why he continues to go see her. No false sense of rapport and no information gets exchanged. He is killing time. How about to the CU neuroscience program? He acquires the cell phone, stun gun, and folding knife prior to May 10th. I can't tell you when, but what I can tell you is we know every single purchase that he made from May 10th forward. You've seen them, the ones that he didn't make with cash. But here he has a cell phone, stun gun, and a folding knife while he's still at school. He attempts an online purchase of a handgun on May 10th. He purchases that gas mask, he purchases the tear gas, and let's stop for a minute to ask the question, why does he need tear gas as he's thinking May 10th of 2012? Well, we know that he considered doing serial murder on hiking trails in federal forests. Doesn't need tear gas for that. He also considered a biological attack. He doesn't need tear gas for that. Why the tear gas? Because by May 10th, 2012, he already knew what he was going to do. And that was go to that theater and try to murder 400 people. He attends all of his classes despite these steps in preparation. He attends all of his labs. He turns in all of his assignments on time. He does well on the written assignments. He gives presentations, including that one there, to Freed's class. We saw that video that was taken by Yom up here. And you can watch it again. It's 3 little segments that add up to a minute or 20 seconds. He's still giving presentations and doing okay. He decides not to drop out of school. He goes through the prelims, as we know, because of deception, because he doesn't want to raise red flags. He goes and sees Drs. Fenton and Feinstein on the 11th. Again, never tells him how much he's purchased already in weapons. He tells him he's going to look for a job. That's not true. No student loan debt. He tells him he has $10,000 in the bank. He has his parents' support. He tells him he has a lease until November 1st, and he has no intention of breaking that.
Objection to misuse of the defendant's statements. This is not relevant to sanity.
Would counsel please approach? Objection is overruled, but Mr. Brockler, you may proceed as we discussed at the bench.
Yes, Your Honor, thank
All right,
you.
Go ahead.
And I want to be clear about this. You know that slide I put up there where we talked about the statements made to mental health professionals and that they can only be used for sanity? This one right here is demonstrative of that guy's understanding, even back then, that what he was going to do was wrong based on societal standards of morality. And that's why he attempts to deceive her about his true plans. He rebuffs all offers at continued free treatment because that's not his goal. His goal is to get out of there. And he's gone in, I failed the prelims, I'm ready to go. He's completely unprepared for them to say, that's okay, you don't have insurance, we'll take care of it. That's not the answer he wants. So what does he do? He gets up and leaves. How about his neighbors? He closes the blinds at his apartment as he begins to plan this massacre, and the numerous air fresheners that he places in his house. Why does he do that? Because he doesn't want them to know, or anyone to know, about the gasoline and the other chemicals inside of his apartment before he's ready to surprise them. How about the purchases? He bought some online. He says he told Dr. Reed he tried to buy it online because it was cheaper, and like any good compulsion, you can still be a bargain shopper when you're compelled by some mental illness. He bought some at stores based on location. No hasty purchases, not a one. Says he bought firearms and related equipment over time in order to avoid suspicion. And he needs to avoid suspicion because he knows that anyone, including the stores, that see him purchasing in a certain way would object or ask questions or even question whether or not what he's doing is societally appropriate. Patience. Patience is paramount with this guy. He knows society believes it is evil and it is wrong what he's doing. How about these G-chats? What's important about these is this is him unplugged. This is him unfiltered, right? There's no impression management here. He is talking to the one woman who he has fallen in love with in his life, the one woman with whom he's had any intimate experience physically. So he's willing to be open with her, to see what she'll say. And he tells her, what I feel like doing is evil. So I can't do that. She asks, what's so evil? And he says, kill people, of course. She says, killing people is too much effort. You'll get locked up. And he says, that's why you kill many people. She asks, why don't you kill me and Ben and others? And selfishly, he says, well, I would be caught, and I wouldn't be able to kill anymore. I'd also lose the rest of my life. And he says, I'm not inherently evil, because he knows what evil is. I've found a purpose for good, because he knows what good is as well. He says there's no way to do it and not get caught, and that's why you wait till the end of your life, so you don't have anything to lose. He knows what society thinks about what his conduct is going to be. There's no reference there to anything that Dr. Gurr came up with in her interviews. Where's that reference to put others out of their misery, an inevitable catastrophe, not believing he was substantively harming anyone? He knows that life has value. He talks about it. He tells Gargi, what is more valuable than life? Taking a life will prevent that person from having any of life's experiences. A.J. Boyk, 18, was prevented from having any more of those experiences. This is that picture that was taken inside this theater, in seats just like these behind them. He'd found a woman that he loved, and she was turning his life around. They loved the movies. They loved Batman. She went out to buy the Batman paraphernalia that day, and like so many others, never made it out of his seat as he came in with those steel penetrator rounds and shot him dead. This guy knows that life has meaning before he does this, because he says, listen to Gargi, if there's meaning to life and you take that away from other people, you've prevented their purpose. Jessica Gawi, 24, she was prevented from her purpose. Wanted to be a sportscaster, aspiring, young, full of life. She too murdered in the seat she sat in. Alexander Teves, 24, had just completed his master's degree in psychology. He was with his girlfriend, the woman he would have married, but for the fact that he was shot through the head in these seats by him over there. He says, my outlook on destroying life. He knows what he's doing. He knows his plans are cruel to his victims. This is out of that notebook that we get to consider for insanity. The cruel twists of fate are unkind to the misfortunate. That's what he writes before he heads out the door to murder. And he's sort of right here. You remember Michaela Medic, 23? Michaela had come to the theater with a group of friends, and they'd gotten stuck in these seats up here. Do you remember that? And she and a friend looked back, and they saw two seats. And they thought, our lucky day. And they got up and left their friends and sat there. And the bullets hit her, and not the friend with her. And she died right there where she sat. He knows that his victims won't agree with him. He knows his victims want to live. He knows his victims are going to resist his attempts to kill them. They're going to try to save their own lives, so he leaves nothing to chance. He's planned for all the contingencies. And all of that planning goes to the intent. His conscious objective is to cause that specific harm, to take away that value, to take away that meaning, to destroy life. So once he chooses Century 16 Theater, he's got a series of steps to go through. And this guy thinks way down the road. That superior intellect, it shows no signs of waning as he leads up to those theater doors. Look at what he does. He's got to find the right theater inside that complex, the most controllable, with limited exits. He's got to limit the victim's ability to escape him. Again, intent. So he goes to case the place. Out of this notebook we can consider for insanity.
Objection, misuse of the defendant's statements.
Overruled.
Isolated, proximal, large. That's why he picks it. And here's a big one, inconspicuous, because he knows society will reject what he wants to do. Do you know over that course of that 2 months, he sees 9 different movies in that theater to find the perfect one for the killing fields he wants to create. And he does it with cash. And we know that because you don't find any purchases on any of the credit cards. And not Fandango either. And what that means is he had to personally go in, interact with the ticket taker, and pay them money 9 times to get this information. That's the theater he cases. There's his drawing, pretty accurate. Here's what he's looking at, reduced visibility from behind. Here's more visibility, unoccupied buildings that block the view if you go to the back of the building. He begins to go through and you saw these and you can see them again. Look at the words he uses. Don't like this one, too many exits. Here's a good one, only 2 exits. This is a smaller area size, only 2 exits. Again, very positive. Too visible, 4 exits. Avoid this one. Starting point more conspicuous than others because he knows that if people see him, they will resist his attempts to kill them.
Objection, misuse of the defendant's statements. It's nothing to do with sanity.
Overruled.
You can't lock the double doors on a couple of these things. And look at the word he uses there. Many escapees. He knows what he's doing is objectionable to his victims, and he doesn't want them to get away. Least conspicuous is a theater. You can lock the double doors, inflicting mass casualties. I might even be able to re-enter and kill more, or, if the compulsion lets me, bail. Real smokers could be an early warning sign. We don't like that. He's also got to find a place, maybe he can limit the exits if there's too many. And there's the double doors he can lock with the handcuffs he talked to Dr. Metzner about. There's these double doors in the theater, and you could lock them by having the handcuffs connected to each handle. I'm sorry, Dr. Reed. And he buys them. June 6th, the day before the prelims. He already knows what he's going to do. The prelims are irrelevant. And there's one pair of them that were still there at the scene. He decides to start at theater number 9. He researches other mass shootings like Columbine. Now, he tells Dr. Metzner that, and he tells Dr. Metzner it's to figure out police response times and how much ammo is needed. But maybe there's something else. Maybe it's the opportunity to figure, how can I be the biggest, the best? And he does. He figures that the Aurora Police Department is 3 minutes away. And he even has the National Guard up there because this thing's going to be so big, maybe they'd get involved too. Remember, he has the capacity to form the intent to act. This is his conscious objective, is to cause the specific result, the death of other people. He knows his victims want to live. The question that's asked by Dr. Reed is, and the question is, would they mind being shot? What do you think you would have said on July 19th? And he says that they'd probably mind being shot. He knows the victims don't agree with him. And by the way, those victims also part of the societal equation. He wants to anticipate the victims' efforts to flee, despite the fact that he's gone to the trouble of limiting their exits. So here's our theater. It's right here, and you can see. Limit exits available to the victims. We know there's the one that's going to be behind him, right? So he's blocked that one off. We also know that there are the 2 entrances from the side that form around the back. And so how does he block those off? The only other exit is unaccounted for is the uphill one. And he leaves that
Judge,
one.
I object to the red crosses on the exhibit. The court's ruling.
Sustained.
You can see from here are the exits he needs to limit. He wants to control the crowds that will try to save their own lives. Again, it's his intent to cause their deaths. He's going to trap them. And how is he going to do it? How is he going to account for these 2 side exits? 2 tear gas canisters, 2 clear out gas canisters. But you know what? At the time he's purchasing that, he thinks, well, I got to protect the most important person. I got to protect me. So he gets a gas mask that he researches online same day. And there it is. Step number 3, he needs to anticipate how they'll try to save their lives once they realize they're trapped. They're going to try to escape anyway. So he gets a scope and he gets a laser and he's prepared to target individuals as they try to flee. He's going to shoot at the ones that try to escape to make sure that others don't follow. That's what he told Dr. Metzner. That shows you his intent is to cause their death. And here's that theater number 9 with all that FBI voodoo with the lines, and here's the ones where he is shooting specifically at the exits. And look at where those rounds are going. They're not going high, they're going right where someone would walk. And if you're looking for evidence of extreme indifference, those steel penetrator rounds, they go right through theater number 8, and we know that one of them hits someone all the way across the theater. There's those rounds going through. That's that universal malice. That's that extreme indifference to the value of human life. And that's the grave risk of death that he creates. And yet, Mora, he was one of the ones that was injured trying to flee with his family, including Rita and Prodio, all shot by this guy trying to save their own lives. This is before the foot was amputated. He knows his victims want to live. He knows that the victims don't agree with him. So step 4, he's got to anticipate how those trapped will try to save their own lives if they don't try to flee. They might fight. That's how he looks, proudly, in this picture. And when he describes the importance of that outfit to Dr. Reed, he says, well, I think someone would see someone dangerous.
Objection. Misuse of the defendant's statements. This has nothing to do with sanity.
Overruled. And members of the jury, I remind you that the statements the defendant made to Dr. Reed were admitted for a limited purpose and may only be considered by you for that limited purpose, and that is to consider the issues raised by the defense or by the not guilty by reason of insanity plea. Does everyone understand that? And everyone's saying yes and nodding their head yes. The objection is overruled. Proceed.
Thank you. The other part of that quote was, you don't want 400 people rushing you. And the reason it's relevant to sanity, the reason it's relevant to his intent to act and deliberate, is why does he think they would rush him? Because he knows those members of society would disagree with what he was going to do. They're not going to view it as a favor. They're not going to view it as being put out of their misery. So they might rush him, and he needs to look ominous. He knows his victims want to live. He knows they don't want to die. They'll resist. How might they react? Well, running down the rows is impossible. It's impossible, especially with people laying there from having been shot. So victims will hide. They'll hide behind seats just like this one. His intent is to cause their death, and here's proof. He doesn't buy normal rounds for an AR-15. Already a powerful assault weapon. He buys steel penetrator rounds. 9 trips to the theater, and he knows if someone tries to get behind something to save their lives, that's what I think I need. And you can see he's right. Those rounds go all the way through. And in picking those rounds, and in the way that he targeted these people, he's also evidencing universal malice and extreme indifference to the value of human life. And of course, when he uses those rounds in this kill box, it creates a grave risk of death. Someone that found that out was Josh Nolan. You may remember Mr. Nolan. He ducked down with a friend and the friend's wife, and they both tried to cover her behind the seats. But Josh got shot a couple times. In fact, he still walks with a cane. It was the cane he used to demonstrate how this guy was patrolling around the front of the theater, seemingly looking for more victims. Do you remember the tattoo? It's not the same anymore because they had to move it over to his arm, which was braced down behind the seats when he shot through it with one of those rounds. So he's also got to anticipate things like the screams of his victims, because he knows they don't want to be shot, they don't want to be killed, they don't want to be hurt. So he gets wireless headphones and he pumps it up all the way. That's what he tells Dr. Metzner. And there's the headphones sticking out of that gas mask. Now, once these people are contained, what can he do in advance to get himself an extra chance of killing them? How about weapons in practice? He's got to pick the right weapons for this killing. It's not going to be a bow and arrow. It's not going to be a BB gun. This shows you what his intent is. He tells Dr. Reed, I decided on the 40 cal because it has more stopping power.
Objection, misuse of the statements, Judge. This has nothing to do with sanity.
Overruled. And members of the jury, you'll remember the instruction that I gave you a moment ago that applies still. Mr. Bruckler, you may proceed.
Yes, thank you. And I want to reiterate that too. There is nothing that's going to be up here over a mental health professional's name that you should be using for anything other than sanity. And part of sanity is trying to figure out if that guy could form the intent to murder after deliberation and act knowingly. And this says he could. He picks a 40 cal because it's got more stopping power. And then William Reed asked him, well, when you bought it, what were you thinking? What was your fantasy? And he said, just a mass murder situation. That tells you he's forming the intent. He's formed it. He got familiar with the guns by getting ready. He trains with them. He also gets a 12-gauge shotgun on May 28th. That's it right there. It's up here. And he tells Dr. Metzner, I picked that one because it was optimal in a theater for killing people. That shows you he has the intent, the conscious objective to kill people. He gets a laser sight to be more accurate, targets on June 18th, a rifle scope, and then he goes out and trains. Byers Canyon, we heard about, or the Byers shooting range. It's 2.5 hours away, and that's important because it's unsupervised, and he doesn't want anyone to see what he's doing because he knows society would reject his plans. He goes out there 5 times, 2.5 hours away. He practices not on the little accuracy targets, the round targets. He practices on life-size silhouettes. That tells you what he's going to think he's shooting at here. He moves side to side. He's got to be able to move with his gun. He fires standing up. He tries crouching down. He needs to have all contingencies covered. He even practices inserting the magazines and reloading that. At the gun range, he puts his gloves on, the gloves he knows he'll use at the theater. I'd just go and practice in each designated area, and I'd keep shooting until I ran out of ammunition. But there's a problem, and this guy can solve problems. Problem is, Officer Donald Ransom pulls him over on July 2nd. Do you remember that? Going to Byers. And here's what happens. Donald Ransom comes up, and he looks in the back clear window of the defendant's car, and he sees weapons cases. And so he asks the defendant about him. And the defendant, without really making eye contact, tells him he's going to go shooting. But he's learned the lesson there. People can see through my windows. What's he going to do about that so that they can't see through the windows? Because he knows society would reject his plans. He goes online. He looks up window tinting, the fine for it in Colorado. He looks up the laws regarding window tinting. And then he goes to O'Reilly Auto Parts about 9 days later, buys window film, an easy install kit, and puts it on his car. Problem solved. He also now, on step 8, has to bring enough ammunition to kill everyone, because that's his conscious goal. And he brought 700 rounds of ammo. That's his conscious objective, to kill all those people. Now he's got to plan that last piece of this, to escape. And I know that there's been some suggestion, oh, he never planned to escape, he just went outside and that was it. We know that's not accurate. First, the apartment diversion. Yes, it would allow him to kill more people, but it would also allow him to get away. He tapes up the gas mask, and we know that it doesn't affect his ability to see. He does a pretty good job of shooting people. It doesn't affect his ability to aim. He hits a lot of people, like Dion Rossborough. Do you remember Dion? Sat up here, nice man. He's got that drop foot problem now because of him. And he says, I am crouched down. I think I'm going to die. I'm scared. And I look up, and who's coming towards me? And he demonstrated that for us just like Josh Nolan did. He is. He looks right at him and pulls the trigger. He's also disguised by armor, head to toe. He goes online. He looks for tire puncturing devices. Why? If getting away isn't part of the calculus, why would you ever look for that? And more than that, why would you buy it? Way back on June the 6th, before you even started buying body armor. The day before the prelims, these in his car, in case I had to get away. Why would he have to get away? Because he knows what he's doing is illegal and society would reject it. He has $280 cash in his pocket. This is, by the way, at the same time that he tells one of the mental health providers, I sent that burnt money to Dr. Fenton because I didn't need it anymore. What's this? He's got a first aid dressing that he purchases on June 6th also. And he tells Dr. Reed, that's if I got shot. He anticipates that someone, likely law enforcement, will want to shoot and kill him for the horror he's about to visit on these people. But here's the thing. If he expects to be killed, if he really expects to be captured, why does he need a first aid dressing? They'll either have him dead on the street or they'll be there to patch him up. Why does he think he'd need a first aid dressing? Unless it's in case he got away. There's no meaningless decisions for this guy. There's no meaningless purchases. Nothing is left to chance for him. That's that first aid dressing. Remember the 4 things we talked about before in opening statement? His main weapon for killing jams. And so now he walks outside from that theater to the unexpected. In his mind, when he goes out that door, there should be no one but victims at best. Everybody should be at his apartment building in flames. But you know what? They're not there. And when he walks outside, he tells Dr. Metzner he has the presence of mind to also problem solve. He does an assessment. There are 2 police. There's a police car with lights on it. He's got to be hearing the millions of sirens that are coming to the theater. And for the first time, he's got to know the apartment thing didn't work. My diversion failed. The police had already arrived. He felt outnumbered. He assessed that it was difficult to drive away in his body armor. He put his gun on the roof, and he waits for them to come get him. That is logical, that is rational, and that is anything but psychotic. Police officers come towards him, and he puts his hands up in the air to surrender, because you know what he's concerned about after what he's done in the theater? Him getting shot. Because I was surrendering. He doesn't want to get shot or hurt. It's all about him. Let's talk about that apartment and the presence of mind and his ability to know, intent, deliberate, all of that. There are 2 issues that the apartment presents for us, really. One is it's part of the mass murder because it's the diversion that will allow him to make more victims and potentially get away. But more than that, and this goes to the intent, conscious objective, it's got its own count. Count 141, possession or control of explosive or incendiary device. Here's that instruction. There's those elements that we have to prove. No one thinks it was anyone other than the defendant in his apartment in the state of Colorado. And they describe knowingly for us, with respect to conduct, that he is aware that his conduct is of such a nature that he can possess those items. Explosive or incendiary device. Now I gotta be honest, this is a long instruction. There are a lot of words in there, but here are the ones most applicable to what this guy set up in his apartment. An incendiary bomb, a fire bomb, an explosive bomb. Now before the mass murder, he goes online and he looks up how to make bombs. Now, I get it. Dr. Woodcock thinks that anybody that's taken college chemistry knows how to build explosives. That's not true. Despite getting an A in it, this guy goes online to make himself smarter. He's able to learn new tasks. But here's the deception part of the apartment. He plans for contingencies. See that in the notebook, which we can consider for his ability to form the intent to act? He says the wild card in all this is explosives. I'm going to go simple and least suspicious because suspicion tells you he thinks what he's going to do is societally objectionable. He goes with gasoline and oil. He acquires a remote detonation system. On July 14th, only 6 days before the mass murder, he goes to the science company. Remember that guy, by the way, saying, hey, this is kind of like nerd heaven here? And there was nothing unusual about that guy when he came in to buy those things. He tests at his house the only thing he can safely test. And by the way, if you don't think it's going to work, why test anything? He tests the quick fuse in the bathtub. Do you remember the glycerin that he buys from the science company and the potassium permanganate? Had you ever heard those terms before this trial? He's got it rigged up in a way where he's got that thin wire over the left part of that opening to his apartment, and it's going to pull that thermos, spill that the glycerin into the pan of it. What's the pan sitting on? A carpet soaked in gasoline and oil. And if that glycerin touches that pan, kablooey, fire everywhere, right? It's a hypergolic reaction. You'd have to look it up. I don't know. Hypergolic reaction, fire. There's a quick fuse that goes to each of these jars that contain thermite on the top. He didn't buy thermite. This guy learned how to make thermite. And in learning how to make thermite, he had to learn how to make rust. He made rust to make thermite to help make his apartment blow up. You remember Garrett Gumbener, special agent? He says, and the thermite in the shell, and he says, yeah, so like it would burn down the fumes, and then into that jar. That smokeless powder, he tells him, that's napalm. Did he go buy napalm at the science store?
Judge,
Nope.
I'm objecting to the doctoring of the exhibits with the red arrows.
Sustained.
An objection.
Sustained.
Your Honor, may we approach real quick?
Yes. Mr. King, this is your copy. Oh, is it? Oh, okay. Sorry. Thank you. Do you know? It's off. The objection is sustained, and then Mr. Brockler may proceed as we talked about at the bench. Whenever you're ready. Take your time. Okay, thank you. All right, turn your mic on, please. Okay, there we go. All right, you may proceed, Mr. Brockler.
One of the things that's found in the defendant's apartment with all those other explosives that he sort of created, including the napalm that he made out of all that styrofoam he bought at Safeway, was a magnesium ribbon, which specifically talks about how reactive it is with water. But why magnesium? And you may remember this hypothetical question given to Dr. Gurr. Why magnesium? This goes to reflection and judgment, because he anticipates, he deliberates, that firemen will come and try to put out this fire. And so he wants to keep the fire from being put out by water, so he creates something on the floor that would keep that fire going. I got the green soda bottles because you can't see the gasoline in them. That's what he tells Garrett Gumbener. Why would he want to deceive people about what's in those bottles? Because he knows it's danger that it presents, and he doesn't want them to know about that danger. He saturates the carpet with gasoline and motor oil, a bunch of aroma things so that people, including his neighbors, won't smell the gas. In fact, he says, so you don't smell the gas, to Garrett Gumbener. Boy, that's thoughtful. Boy, that's deliberative. He says the computer makes the initial noise. I set that for 25 minutes of silence and then the noise, and then the boombox was 40 minutes. And then he goes into this lengthy discussion about how they're going to go outside and check on that remote control car that he'd set up out there, and people will fidget around with the remote and help set it off if the neighbor doesn't. The second-guessing neighbor was one of the other things that kept this from being an even bigger massacre. After the mass murder, right there on the ground behind the theater, this guy has the presence of mind to answer this question. Do you have any weapons? 4 guns, he says. No bombs here, but improvised explosive devices at my place. There's the improvised or incendiary device, firebomb, and he tells, without any prompting, he tells Officer Blue, they won't go off unless you set them off. He knows. And he knows what he possesses, and that is explosives and incendiary devices. His deception continues with the theater goers. He can't just walk through the lobby dressed to kill, so he dresses like everybody else. He purchases tickets just like everybody else. He's not going to sneak in, that might draw suspicion, or barge in, that might get people wondering. He's not hasty, he's very patient. He wants everyone at the theater to see him as no different than they are, as no threat. So he parks in the rear of the theater by theater number 9. He puts on his ballistic chaps because you can't drive with them on, and that becomes an issue later when he does the assessment about not fleeing. These are the ballistic chaps. And then he puts pants on over those, because otherwise they draw suspicion from society. He walks around to the front of the theater, and that's no short walk, but it's worth it because he's got his plan in mind. He enters with all his potential victims, and he's got to know that, doesn't he? He dresses inconspicuously, just like them, on the right side of that picture. He acts like they do. He uses his ticket like they do. He waits in the concession area near theater number 9, right there, just like they do. And it has to dawn on him that some of these people could be in those chairs he puts those steel penetrating rounds through. He can see what they might see. And that is people, men, women, and even children walking through the concession area. Just like everyone else, knowing he is surrounded by those he will shortly try to murder as they sit in their seats. There's no haste about him. It is all patience. He poses no threat. He gives no indication of what is to come. He picks a seat near the exit he needs to access, and he waits patiently for all his future victims to get packed into their seats. He waits for the movie to begin. No haste. He picks his moment, and then he uses that cell phone ruse with that cell phone stun gun, right? Pretends to take a call. No one would expect anything else, and he heads outside. It's inconspicuous. He goes to the exit and secretly applies that special picnic table clasp that he's manufactured to block the door from locking. Then he goes into his car and he puts up the sunshade to keep people from seeing what he's doing. He puts on his kill suit. He makes one last call to that general CU number. Why? And the mental health professionals that actually talked to him about it told you. It's because he knows what he's doing is wrong and he's ambivalent. Someone answers. He says nothing. He hangs up. He gets his weapons and his ammo. He moves back to theater number 9. Do you remember the 4 things? Here's another one. The fumbled tear gas. And he fumbles it right behind that theater. That's going to be for this exit right here, isn't it? He fumbles it, looks for it for a moment, then decides he's moving forward. He opens the door and he steps into the darkness. It was Alex Sullivan's 27th birthday that morning, July 20th, 2012. And you'll remember he was a man larger than life and a large man with a large heart. He stood up. He was the one that multiple witnesses said screamed, "Yeah," when the trailer for Superman was there. But the thing that brought down Alex Sullivan, as he was there with 9 other members of Red Robin where he worked, was that shot to the heart that went through his heart and his lungs, and he died right there. Jonathan Blunk was only 26. He was there with a loved one, and you'll remember that Jonathan tried to cover her up to protect her, and protect her he did, at the cost of his own life, because the bullet that went through his head came in from the back and went out into the front, and he died right there. In fact, you'll remember that the woman that he was with had to testify that she couldn't get him off of her. She had to crawl away and run away. Now this case, even though we have already shown all of the intent, all of the knowing, all of the extreme indifference, it's got mental health witnesses because he said he was insane when he did it. There's defendants' mental health witnesses here, and one of the things the judge told you about is you get to consider any relationship a witness may have to either side in judging their credibility. That's true for experts too. Here are the 3. Dr. Jonathan Woodcock, Dr. Robert Hanlon, and Dr. Raquel Gurr, in the order they testified, and they all have 4 things in common. They were handpicked by the defense. Not a single one of them is forensically certified. They have all testified exclusively for defendants in criminal cases, and each one of them, as you recall, changed the way they normally conduct themselves to suit the limitations placed on them by defense attorneys.
Objection, Your Honor.
Overruled.
Let's talk about Dr. Woodcock. Dr. Woodcock, board certified in forensic psychiatry? Never. Court appointed? The court trust him enough to appoint him? No. He worked for the prosecution? Never. He has worked exclusively for criminal defendants, including the same defense attorney here that used him before. He says he was qualified as an expert hundreds of times, but you'll remember when we actually discussed what it means to be qualified, it actually turns out to be tens of times. It was the only curriculum vitae not admitted into evidence by a psychiatrist or psychologist, and that's got to say something. He goes and sees this guy 4 days after he tries to murder that theater full of people. 4 days. What a great opportunity. He sees him when he's unmedicated. But here's the problem. He allowed the defense to change the way he would do business, to influence the evaluation.
Same ruling. Overruled. Based on my previous ruling. Go ahead.
Thank you, Your Honor. Remember the defense investigator got to be present in the interview and even offered at least one answer to the defendant. Even Dr. Woodcock said that could be a problem, and the others agreed. Nobody else had a defense investigator with them for their interviews. He's not allowed to discuss the planning of the mass murder, the booby trapping of his apartment, can't discuss the crime at all. He's never told about the notebook, so he doesn't know to ask about it. He doesn't return the jail psychiatrist's repeated calls about medicating this guy if he's that sick because the defense attorney told him not to call him back. So he acquiesced. He only spends 2 hours and 45 minutes, and he gets some statements from the defendant. Defendant says he drops out of school because he felt like he was asked to quit. Said I was able to do the work, but I got bored. I didn't like it. He knows, he has the presence of mind 4 days after this to remember the precise 1,000th of his GPA from undergrad. He also remembers that he went to the gym a lot there. He told him that people tend to show what's in their best interest to show in describing his parents. He told Dr. Woodcock that he decided he wouldn't build a false sense of rapport with Drs. Fenton and Feinstein. He also says he didn't consider any of the homicidal ideation stuff a problem. He decided to quit school and his career as a neuroscientist. He tells him he stops taking his meds in May of 2012. Incredible presence of mind for an unmedicated guy 4 days after this mass murder. He tells him online dating doesn't work. And that actually turns out...
misuse of the defendant's statements.
Mr. Bruckler?
Do you want me to...
Yes, why don't you come up here? Is overruled. Members of the jury, I remind you that any statements the defendant made to an expert mental health individual were admitted for a limited purpose, and you can only consider them for that limited purpose, and that is for the issues raised by the not guilty by reason of insanity plea. Do you understand that? Yes. Everyone's saying yes and not in their head yes. Mr. Bruckler, you may proceed.
Really? Okay, thank you. Let me explain this quickly then. The reason this matters is you'll recall that Dr. Gurr, who based in large part her opinion of the defendant's sanity on this diagnosis of schizophrenia, said that one of the key features of that was withdrawal from society. And she had said that the defendant had withdrawn from society. Here, 4 days after the mass murder, he's confirming for this mental health professional, an expert hired by them, that he was making ongoing efforts to remain socially active, but they were failing. Online dating doesn't work. He tells them that he had these plans that he was thinking about. One was find a fix for whatever he perceived his issues to be. Plan B was the biological weapons issue, and Plan C was what he did, which was the mass murder. In knowing what he was doing was wrong, he describes those, the bad ones, wouldn't be good for others. Again, 4 unmedicated days after he did it. He even says, I wouldn't want it to happen to me. He knows it's wrong. Wrong for him, wrong for society. He also knows right and wrong as he describes that prosecutors seek justice for those wronged, like in this case. He told him he decided not to take the antipsychotic drugs offered by Drs. Fenton and Feinstein because what future would I have if they took away that Plan C, this mass murder thing that he wanted to accomplish? That goes to his intent to obtain and achieve that specific goal. He says he tried to recruit his friends in grad school. He says, I hate everybody. And isn't that a recurring theme through much of his writings before he gets to jail? In the notebook, in the G-chats, hate, hate. Oh, woe is me, I'll release havoc. He tells the doctor that he's catatonic, another thing that later we're told is a key feature in some schizophrenics. Except he's catatonic except for riding his bike to school every day, attending laboratory time, turning in all of his assignments on time, strong grades on his written work. He keeps shopping. He keeps paying his rent and bills on time. In fact, you'll remember, we had the lady from the apartment complex who said she saw him right there in June, at the end of June, with the red hair. And he seemed just like he always did as he politely handed over the check. He worked out regularly at 24 Hour Fitness. And remember, Dr. Woodcock confirmed that, yep, he was really trying to fit his catatonia in over lunch. He denied having any thoughts of control. He denied being suicidal. Dr. Woodcock observed no mania. The guy denied any voices. The only thing he talked about with any potential hallucination, and it's the first time we hear this, are flashes to the side in undergrad, not the third lab rotation. Why did he dye his hair? Says, I don't know where that came from. There's no mention of an other guy. There's no mention of two selves. There's no mention of not me having done it. There's no mention of a master power that had influenced him or controlled him. No mention of a call for action or a mission. And remember, that word mission shows up nowhere before Dr. Gurr. No reference to the world coming to an end. No inevitable catastrophe. He doesn't write a report, handwritten notes only. And then, just months ago, 2 years and 4 months exactly, during jury selection, 18 days before you got picked, he's had no contact with any mental health professional. He has watched only 30 minutes of Dr. Reed's 23 hours. He called it sampling. He generated a 13-page report. He details the wrong legal standard, you'll recall.
Objection, that misstates the evidence.
All right, members of the jury, you have to rely on your own memory of the evidence. The attorneys are allowed to argue based on what they remember the evidence to be, but ultimately you have to decide what the evidence is. Does everyone understand that? All right, go ahead, you may proceed.
Thank you, Your Honor. Citing irresistible impulse, which isn't the law here. And
Objection, Your Honor. That's not what his sworn testimony was.
All right, again, same instruction, members of the jury. You have to rely on your own memory of the evidence. The attorneys may differ in their recollections. What's important is what you remember and what you determine the evidence to be. Again, do you understand that? Yes, and everyone's saying yes and nodding their head yes. Mr. Bruckler, go ahead.
He spent less time interviewing the defendant than answering defense counsel's questions on what he did in the case, in his opinion. Here's the kicker. 5 days after he opines that this guy is insane, during jury selection, 5 days after he generated his report, he goes and visits him in the jail for an entire hour. No discussion of planning of the mass murder, no discussion of booby-trapping the apartment, no discussion of the crime. That is Dr. Woodcock. Dr. Robert Hanlon, he is a board-certified forensic psychologist? No, never. Never been board-certified in forensics, never been court-appointed, never worked for the prosecution against a defendant. He initially said, with Mr. King, I've testified almost exclusively for criminal defendants, but you'll recall under cross-examination we were able to get rid of that misleading word. It's exclusively for criminal defendants, including this same defense attorney, Miss Brady. He did not interview the parents of the defendant, even though he wanted to, even though he thought it was important to do so. It was his normal practice to do so. He'd asked the defense attorneys for it, and remember the word he used? And he regretted it. He capitulated and didn't do what he would normally do. But here's the other thing with him. He can't tell us anything about this guy before April of 2013 when he does his first testing. He can't tell us anything about his mental illness before April of 2013. He can't tell us anything about his capacity to know right from wrong either before or after 2013. He can't tell us anything about his capacity to intend or deliberate or act knowingly, none of it before or after 2013. Dr. Gurr. Dr. Gurr is an accomplished academic and researcher, and what she does matters, no doubt. But what she does is not in this courtroom, and she is ill-suited to do this function. Is she board certified in forensic psychiatry? No. In fact, what she told us up here was she's not board certified in her career field ever. She's never been court appointed. She's never worked for the prosecution. She's worked exclusively for criminal defendants. She did not interview his parents before opining that that guy was insane and schizophrenic, even though she wanted to, thought it was important to do so. It's her normal practice. It's in her published recommendations in her books. And she said because their calendars didn't match up for almost 2 years on the most important case in their lives. 2 months before jury selection, she finally sits down with the parents. And why? Preparation for trial? She doesn't video record the evaluation, even though she's testified previously she's delighted when it's recorded. She commonly video records her interviews in her practice, and she video recorded the last criminal defendant that she worked for the last time she testified. She discussed it with the defense attorneys, but then never pursued it. She spent only 13 and a half hours with the defendant before she declared him insane and schizophrenic, only 12 pages of notes before rendering a 14-page opinion in June of 2013. The majority of those 28 hours that she talked about, those came after Doctors Metzner and Reed. The majority of her notes came after Doctors Metzner and Reed. And remember those quotes that she had in her report? She said, yep, I agree with you. You can take them to the bank. When they're in quotes, they're his words, the way he said them. And then we got here. This was one of numerous examples of things that just didn't match. Getting killed was an option. Being captured was another. She said that's what he told her. That has a very different 50-50, could go either way meaning than what happened in her notes. I asked if he thought he might get killed. That was an option. I asked if he thought what will happen, and he said, I will be captured. That's different, and that's not indifferent the way that first quote says. And you remember her defense to that? As to with many other things that were inaccurate? Well, it's the essence. It's the gist. It was the essence of it. Well, you know what? That might work in academia. That might work in the clinical setting. But in here, with lives at stake and lives lost, what we need from here is not essence. We need facts, and we need the details that are always important. Do you remember the thing that she testifies about and she puts in her report? She says, right at the end of the session, I asked him if he sees things no one else sees. And he looked behind me at the wall and he pointed and said, right there. A huge moment for any psychiatrist. That is a hallucination taking place in front of her. And do you know where it's documented? Nowhere. Nowhere. It just shows up in her June 2013 report. She also attributes to him statements and thoughts that nobody else says. Thought he would wound some, but didn't know he'd kill. That he was possibly being controlled by a master power. That taking action would lead others to do the same. And then there's that word mission that shows up in her notes in a question she asks him. And then it shows up everywhere thereafter. She also says that he indicates the world is coming to an end, that there's inevitable catastrophe. But here, last week, that gets watered down quite a bit. And that inevitable catastrophe, which are her words apparently, now becomes something more akin to the call for action. She is probably great at research, probably great at academia, but this requires a different skill set. A call for action, a phrase that has only been used with her ever. Do you remember Dr. Metzner asks him about it 2 months after she writes her report, and 2 months later he says, I never said that. Dr. Reed, in 23 hours, you never heard the phrase a call for action. But do you know when he brings it up again? With her again? In November? Right before trial? She details the wrong legal standard and says she's considering irresistible impulse.
Objection, that misstates her testimony.
Again, folks, same instruction I gave you. You have to rely on your own memory of the evidence, including the testimony. That's what matters. The attorneys are allowed to make arguments and as part of the arguments, they may remember testimony and other evidence in a particular way. You're not bound by what the attorneys remember or by the attorney's arguments. You determine what the evidence is. All right, Mr. Rockler, you may proceed.
Thank you. And finally, she indicates that he thought when he was going into that theater to murder all those people that he was putting them out of their misery. And then on redirect, Mr. King asked her if he ever told her that, and she said, well, no. And then on recross, I asked her, didn't you put that in your report in quotes? And then she said, well, yeah. Gordon Cowden. You'll remember Gordon Cowden was a father. 51 years old, he'd had the summer off, and he was at the movies with his daughters when he was shot in the head and killed, amongst other places. There were also court-appointed mental health witnesses. Dr. Jeffrey Metzner, Dr. William Reed, they too have 4 things in common. They were also handpicked by the Colorado Mental Health Institute at Pueblo and appointed by this court. They're both forensically trained and forensically certified, and they did not change their practice to suit anyone on any issue. Let's talk about Dr. Jeff Metzner. Board certified in forensic psychiatry, sanity evals. He at best estimates 100 to 200 times has he done this. He's been court appointed 80% of the time. That's how much the court values his opinion. He's worked for the defense and prosecution. He said that other 20% pretty equally divided. He reviewed every single thing in this case. The only thing he told you he glanced at cursorily were the medical records of some of the victims, same as Dr. Reed. He called everyone. Again, no one else had done this. He's calling every mental health provider. He's calling parents. He even calls doctors Woodcock, Hanlon, and Gurr to get their input. He spends hundreds of hours before he conducts his forensic interview. That's obviously 23 hours of not video recording, because that was Dr. Reed. 23 hours he spent interviewing him. He generated a 120-page report, including an addendum he described, where he went line by line through that notebook. It was detailed. He found corroboration for all the things that they discussed. He did a detailed analysis that you got to hear about up here. And he rendered a clear opinion. An opinion that he said, I am highly confident that the defendant had the capacity to know right from wrong on July 19th and 20th, 2012. That the defendant had the capacity to intend, to deliberate, and to act knowingly on those same dates. He is sane. And he was on the 19th and 20th of July. How about Dr. Reed? I'm sorry, ma'am? Thank you, ma'am. William Reed, also board certified in forensic psychiatry. He's done dozens of sanity evaluations. He's been court appointed 2 times, including in this case. But here's the kicker. Much like the witnesses hired by the defense, he's testified almost exclusively for criminal defendants too. Remember that? He's testified for the prosecution only 1 time. And you know this about a guy who does sanity evaluations and testifies 13, 14 times for the defense. He's not testifying that their clients are sane. This guy knows sanity and he knows insanity. He also reviewed all the reports, all the records. He called everyone, including Doctors Woodcock, Hanlon, Gurr, hundreds of, there it is, now it's accurate, 23 hours of video recording that he did, and you sat through all of it. It wasn't the essence of what was told to him. It wasn't the misquoted phrase. It was his words, the way he delivered them to the questions that were asked, including follow-up. He came back afterwards to chase down answers to other questions. Not every victim in this case, as you know, is deceased. There was Caleb Medley, age 23. Caleb was that aspiring stand-up comic who was there with his pregnant wife. And in one of the most compelling parts of this case early on, you'll remember as he sat there with blood pouring out of his face, his wife takes a cup of water as the first responders are saying, you gotta go, you gotta go. And she's like 9 months pregnant. She pours that water over his face and she kisses him and she says, I'll take care of our baby, because she thinks that's the end for him. Miracle of miracles, it's not. She's in one place delivering their son. He's in another place having his brain put back together. And he's seated out there right now.
Judge, objection. This is calling on the passions of the jury.
Overruled.
Farah Soudani was 22. She was part of that Red Robin crew, the big one there to celebrate Alex's 27th birthday. Do you remember that? Now, this is the injury we can show, and it's the least of them, because what you'll remember about Miss Soudani is that she was completely eviscerated by the defendant's bullets. Her organs spilled out of her and had to be held together in her as they whisked her away. These too are victims of the defendant. William Reed generates, despite the 23 hours of recording, a 58-plus page report. It is detailed. There is corroboration. There's a detailed analysis, and there's a clear opinion, and he too, highly confident, the defendant had the capacity to know right from wrong back in July. He had the capacity to intend, to deliberate, and act knowingly. He too, the second court-appointed psychiatrist, forensic psychiatrist, says that guy was sane when he went into that theater to murder all those people. All of this evidence allows you to check these boxes, and the last bit, the defendant was not insane beyond a reasonable doubt. And as you work your way through these charges, keep in mind, it is unlikely that he could be guilty of attempting to kill one and not another, but go through that process. Sane. Sane. John Larimer. He was one of the people killed when the defendant was sane. 27 years old. You'll remember that he had friends. Bear was one of them. Big guy. Came down here and wept as he tried to describe how he and his friend would not leave John behind. They tried to drag him down the stairs. They couldn't do it because he came back. So they hid behind the seats, and ultimately they had to abandon their friend. John was only hit a couple times, but the bullets ripped through almost all of his internal organs, killing him pretty quickly. Jesse Childress, 29 years old, Air Force guy. You remember that he bought the tickets for his friends that he went there. He likely died early from the shotgun blasts, the pellets ripping through him. The defendant, before the notebook, before he mails it off, before he heads out to do what he's going to do, changes his dating headline on 2 websites, Match.com, Adult Friend Finder. And he lets us know what he thinks society will think about his conduct. Will you visit me in prison? And you knew it ended this way. Ashley Mosier. Ashley Mosier walked into that theater on the 20th of July, a pregnant mother of a 6-year-old. And in moments, she left there carried out, a miscarried mom with a dead 6-year-old daughter. 4 bullets pumped into her by that sane guy right there. The courage that she showed to come here and tell you that was remarkable. And then Veronica Mosier Sullivan, forever our kindergartner.
Aurora 911, where's your emergency? I can't hear you. What address? Theater, Aurora, Colorado. Okay, I can't hear you. Give me the address again. There's gunshot. What address? Say it loud.
The picture is her. The sound is him. when you're done with this case, I want you to go back there, go through the instructions, deliberate the way that you've sworn to deliberate, look at the evidence, then hold this man accountable. Reject this claim that he didn't know right from wrong when he murdered those people and tried to kill the others. Reject this claim that he couldn't form the intent to murder, to deliberate on murder, and to act knowingly when he set up his apartment full of explosives. That guy was sane beyond a reasonable doubt, and he needs to be held accountable for what he did. Thank you.
Members of the jury, let's go ahead and take our first afternoon break. It's about 3:05. Let's plan on taking about 15 minutes if it's okay. Please make sure you follow my admonishments during the break. They continue to apply, all right? I'll see you back here in about 15 minutes. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about before the break, Mr. Brockler, on behalf of the people?
Your Honor, may I confirm the amount of time that I have left? We have down that I have 23 minutes and 30 seconds plus the extra hour the the extra 2 minutes the court promised. So 25, 30. Does that sound right?
Wait, the extra 2 minutes that I...
Your Honor, Mr. Orman thought that you had said up at the bench that you could give me 2 minutes to help fix these slides and whatnot.
Oh, I did, but I don't think I said that I would give you extra time. I did say I would give you whatever time you needed. But if that's what you meant, now I understand what the request was about. Ms. Robinson, what do you show him having left?
23.
So she shows you having 23 minutes. Mr. King, do you have any objection to an additional 2 minutes?
Yes, Judge, I do.
All right, I'll give you an additional 2 minutes. There were several interruptions, so I think it's fair. So you'll have 25 minutes for rebuttal. Is there anything else we need to talk about on behalf of the people at this time?
No, sir.
Anything else on behalf of the defense at this time?
No, Judge.
All right, have a good break. I'll see you back here in about 15 minutes. Thank you. The court will be in recess.
So George Brockler will have 25 minutes reserved from his 2 hours here for his rebuttal. I'm Phil Tenser, joined again by our legal expert, Dan Recht. Let's start with your first impressions about the DA's performance here, and tell us what you think about his performance.
Well, George Brockler is a very good orator, and this was another example of that. He gets along well, he's good on his feet, he's articulate, and he did all of that here today. What he said, however, was nothing new. He emphasized the emotional stuff. The end of the opening was replaying an audio tape, talking about a mother carrying out, like in a pathetically, desperately sad way, her dead daughter. And that's the emotional stuff that he was stressing. And then he went through, spent a lot of his hour and a half or hour 35 minutes showing how Holmes planned this. Interestingly, though, the defense doesn't disagree with any of that. They know this is a terribly sad case. They'll admit it. They know that Holmes planned this meticulously. They'll admit it. And yet, their expert says those things can absolutely be true, and yet someone is insane and doesn't know the difference between right and wrong.
We heard Dan King, the public defender, stand up over and over again to say, objection. And he didn't leave it there. He said, objection, what does this have to do with insanity? Many of those cases, he was overruled. Do you think the judge was right in this? Was this a rhetorical practice for the defense?
Well, yes. Here's how those objections work. Even if King doesn't believe the judge will grant his objection, if he doesn't object sort of casually, I mean, he wasn't pounding on the table. If he doesn't say the words objection, he loses his right to raise that issue on appeal. So that's preserving appeal issues by softly saying objection without a strong argument. And I think generally that's what he was doing.
Okay. When the DA played that bit of evidence, that powerful 911 call, I believe it was Kevin Quinonez's 911 call, something that we've heard time and time again throughout this case, when he pulled up the pictures of the 12 who were killed in this shooting on July 20th, all of that was very strategic, aiming at, well, it feels like it was aiming at an emotional response.
Absolutely. He is looking for an emotional response. He has, the emotions on his side because it's terrible, and the jury, I'm sure, feels terrible for all of the victims and the victims' families. And so he wants to push that as hard as he can. But we know that doesn't go to the heart of the issue here. That doesn't go to whether Holmes was sane or insane. Right. And there might be jurors, or not, we don't know, sitting there in the box thinking, what does this have to do with sanity or insanity? Brockler, just like in his opening, used this rhetorical style where he would go back and forth from discussing the law to discussing how a victim got hurt or killed. Right. Without introduction, really. He would just jump to the next one and back and forth. But it was clear what he was doing, and as I said when I first started talking to you a few minutes ago, I mean, it's an effective style.
The other objection that we should talk about was Dan King's objection to arrows being placed on slides. Alterations of evidence is the word that he used, I believe. We heard discussion earlier that red underlines wouldn't be allowed on certain of the words that George Brockler displayed behind him, but pointing out with red arrows things that he wanted people to see in, say, photos of the crime scene, photos of the apartment. What's your take on why those were blocked, why those objections were sustained and those slides were removed?
Yeah, it's a good question. This is another area where the judge has total discretion. He has to make a judgment call. There's a notion that red evokes a heightened emotional response, blood-like, and so I think the judge was saying you shouldn't be using red, and if these arrows were in black, I'd be more inclined to let you do it.
So it's all about, in this case, the standard color scheme that he was using, this black, white, yellow color scheme?
I haven't seen, frankly, in other trials parsing out different colors like this. So it comes as a bit of a surprise to me, too.
Sure.
And I really can't inform you further than that.
Okay. So let's look ahead if we can.
Yeah.
Let's try to remind our viewers and everyone who's joined us now that this, now that the actual arguments themselves began after lunch, what are we going to expect once this recess is over in just a few minutes?
Right, good question. So here's what's coming with certainty. The defense will get up to give their closing argument, presumably Dan King. He has 2 hours to do that now, and this is his only argument. He doesn't get a second bite at the apple, whereas George Brockler does.
He has his rebuttal, 25 minutes to come.
And you'll see, as I predicted, that he would save a chunk of time for his rebuttal. So he has 25 minutes. That's
almost
a good deal
quarter
of
of his whole time.
Right, almost a quarter of his whole time to get up and get the last word in, and he will. So first the defense for 2 hours, then Brockler for 25 minutes. The defense will stress that this was a horrific thing, that everyone, you can't help but feel terrible for the victims and their families, but that Mr. Holmes was insane and that their well-regarded expert says so.
Do you think the defense will take direct, sort of a point-by-point approach to rebutting some of the things that George Brockler said? For example, he said something along the lines, and I don't have the direct quote in front of me, that Dr. Gurr, she may be a great academic, she may be very respected in her field, but her credentials are not right for this courtroom. Do you think that the defense will respond?
Yeah. He won't, Dan King, respond point by point to what Brockler said. For sure not, and that's a bad strategy. You have to give your own argument. But my guess is he will respond to the criticism of Dr. Gurr because she is their star witness, and he can't allow her credibility to be besmirched. Right. So he will comment on that, and he will summarize the defense perspective, which is that she's a world-renowned expert, and it's the jury should regard her even more highly because she's not a forensic psychiatrist. She doesn't do this regularly. She's an academic.
What you're saying is this isn't high school debate where the burden of proof is equal. The defense is going to be undermining the prosecution in a different way because the prosecution is the one with that burden, right?
Absolutely, and you will hear Dan King hammer on that for sure. That'll be a big part of their closing also. Definitions of the burden on the prosecution. So he'll talk about the burden on the prosecution, he'll talk about what reasonable doubt means, he'll talk about what it means to, for them to have to prove their case beyond reasonable doubt, and he will stress that one of the elements they have to prove, just like George Brockler said, and it's true, is that he wasn't insane. So, and they are going to stress that because it's not an even playing field. It's not who scores more points. It's all a question of whether the jury has doubts in their mind that are left.
Right. Not about proving he was sane, but about proving he wasn't insane. Right?
Yeah, absolutely.
And again, introducing all of these double negatives.
Well,
with the idea of affirmative.
The law does introduce these double negatives, so we have to work with them. But simply put, if the prosecution doesn't prove that beyond a reasonable doubt that he was sane, the jury is instructed they have to come back and say not guilty by reason of insanity.
And all of that we heard the instructions read earlier to us today. Andrew, if you would, I believe the computer screen still has that definition of insanity up. And so since that's going to be the core of their case, let's talk about that. It has these two prongs,
right,
and how they have to prove each one in their own order. Maybe you can give us some layman's definitions of these. But the first one is that the gunman was so diseased or defective in mind at the time of the commission of the act as to be incapable of distinguishing right from wrong with respect to that act. So would you break that down for us, and we'll do the next one in just a moment?
Yeah, that can be distilled down to the phrase about distinguishing right from wrong. You can sort of forget about that other language, not that you should. I mean, the jury's going to read that. But if you're thinking about what this means and what the prosecution has to prove, if you focus on was he capable of distinguishing right from wrong as society views right from wrong? If so, he was sane. If not, he was insane.
The next of these prongs, am I using the right word there? Prongs that they have to prove one or the other, not even necessarily both. The second one is that he suffered from a condition of mind caused by a mental disease or defect that prevented him from forming a culpable mental state that is an essential element of the crime charge. And I think there, it's all about that culpable mental state.
Yeah, I mean, for first-degree murder, it has to be that they intended. That's the key phrase. That's a term of art, really important. Did he intend to kill or not? And if the jury believes he did not, then that's not guilty also. But that's not what the defense is focusing on. They're focusing on the definition of right from wrong, and that's where this is going to go.
So they're focusing on that first prong, knowing that moral difference, right? Because
absolutely,
it is
and that's what Dr. Gurr focused on, and so.
And Dr. Gurr being their star witness from UPenn, who helped write the book, so to speak, on and quite literally on schizophrenia.
Absolutely. I mean, I think everyone agrees. George Brockler just agreed that she's a worldwide expert on schizophrenia, and the way he tried to discredit her is to say, but her expertise doesn't work well in this courtroom.
Right. Well,
I don't know that that's true, but that's his argument, and that's how he tried to diminish her prestigious background.
Right. We'll find that out whether the jury believes her, but his point being that whatever she diagnoses the gunman with today or a year after the crime or even 4 days after the crime in the case of Dr. Woodcock, it's not an assessment of where he was mentally on the 19th and 20th of July of 2012, right?
Sure, that's absolutely right. Although Dr. Gurr said, I'm assessing that he was insane when he was in the theater on July 19th and 20th. Right. So she was aware of that distinction and specifically said he was insane at that time. And of course, the experts for the prosecution, the same. I mean, they say he was sane when? At the time of the shooting, not a day or two or four or a year later.
Precisely. And let's talk about how the jury will be approached with all of these questions, including the two that we just discussed on the computer screen. The first thing they're faced with is the question of guilt. Then they get the question of lesser included offenses. Explain for us again what that all means.
Yeah, I will, although let me just say that those aren't as important in this case as in other cases. Okay. Because the defense is not arguing that he should be...
oh, forgive me, I'm going to interrupt you now because we're going back into the courtroom.
Let's do that.
Okay, back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. Are the parties ready for me to bring the jury in, Mr. Brockler? Mr. King?
Yes.
Okay, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, members of the jury. right before the break, the prosecution finished its closing argument, and so let me inquire at this time. Mr. King, is there a closing argument on behalf of Mr. Holmes?
Yes, Your Honor.
All right, you may proceed.
And do I need to wait for I think my first slide is blank, so. You know, as I sat here and listened, I had a quote pop into my mind. I think it's Aldous Huxley, who said, "Facts do not cease to exist because they are ignored." Facts do not cease to exist because someone wants to ignore them. Ladies and gentlemen, when you sit here for an hour and a half, and this guy talks to you as if Mr. Holmes isn't mentally ill at all, you need to ask yourself, what does the evidence show? Where's the proof that he's not mentally ill? When this guy stands in front of you and talks about statements that were made by Mr. Holmes and attributes logical meaning to those statements, you need to ask yourself, who said this is the case? When the very doctors that he's asking you to base your opinions on contradict what he is saying. When Dr. Reed told you on the videotape, we have to be very careful and understand that these are statements that were made years later when Mr. Holmes is in a medicated state, describing the way he was thinking in a very different frame of mind. Because, you know, there isn't a lot of logic to what Mr. Holmes said. That's because he's mentally ill. That's because the very same doctors that this guy is asking you to base your decision on say he's psychotic during the unfolding of these events. And yet, Mr. Brockler wants to talk about it as if there's nothing wrong with him. And he's just logically pursuing things. Well, where's the logic? He brings up the fact that apparently Mr. Holmes knows people are going to run away from him. And at the same time, he thinks that he's not doing anything that's wrong to them. Well, that's not logical. Well, no, it's not. It's psychotic. When he talks about the fact that he's deceitful with Dr. Fenton and Feinstein, because he's both wants to be treated and doesn't want to be stopped, and we attribute that to logic, you have to ask yourself, where's the evidence of that? Where's the proof? If it was logic, and Mr. Holmes wanted to be treated and get better, then he would go in logically to Drs. Fenton and Feinstein and tell them everything and let them lock him up and medicate him and treat him. If his thought process was logical and what he wanted to accomplish was the mission and not get treated, why go see a psychiatrist at all? And why in the world would you go see a psychiatrist and tell them that you were thinking of killing a lot of people? It's not logical. It defies logic. That's the psychotic process. And that's what this guy is asking you to pretend doesn't exist. At the beginning of this case, I stood before you several moons ago, and I said, we are in pursuit of the truth. And we remain in pursuit of the truth. And we have presented you with evidence so that you can decide what you think. And we have endeavored to not manipulate that evidence, but to present it to you whole cloth so that you could consider it for what purposes you see fit, rather than picking and choosing different portions and misconstruing their meanings. The fact of the matter is that when Mr. Holmes stepped into that theater on July 20th, 2012, he had lost touch with reality. He had been consumed by a psychotic process since at least March. He was suffering from a mental disease that he'd had for more than 10 years. And when he walked into that theater, the evidence is clear that he could not control his thoughts, that he could not control his actions, and he could not control his perceptions. The psychotic process had obscured his ability to think about things the way that we do, the way that Mr. Brockler wants to attribute to him. And the doctors have told you that that delusional process cannot be separated from him. It's part of his being. It's part of the way he perceives reality and thinks and makes decisions. And you cannot divorce the mental illness from this case or from Mr. Holmes, because the mental illness caused this to happen. Only the mental illness caused this to happen, and nothing else. So to stand here and pretend like Mr. Holmes is not mentally ill is misconstruing the evidence. And it's not fair to you or to Mr. Holmes. When I talked to you in opening statement, I talked about how this case was going to be hard for you. And I'm sure it has been. And it's about to get harder. Because you're going to be called on to making a very important decision. And you're going to be called on to make that decision based upon your reason and your common sense, and not a desire for retribution, not a desire to cast blame, and not a desire to try to fix the situation. In opening statement, I described a flood of emotion and passion such that no one can escape it. And I told you that in order to do the work you're going to have to do, you're going to have to go to a higher place, above the waterline of the flood, where the law is, and make your decisions there, rather than as a result of passion or emotion. This is not an act of free will. This is not a conscious choice made by a rational mind. That's not what was operating here. And that's not what the experts have said. In opening statement, I said to you that all I would ask you to do is accept reality. And at the time I said the prosecution may not choose to accept this reality because it's inconsistent with their purposes. And it appears from Mr. Brockler's argument that that's the case.
Overruled. Members of the jury, please remember that these are the arguments that counsel are making. Counsel's closing statements are not evidence, but they're entitled to make arguments. So the objection is overruled. Mr. King, you may proceed.
Here in the fortress of the law, here is the space that you will make this decision. This is the place, and the time is now. And it's going to take strength. Here in the fortress of the law, there's no room for hatred or vengeance or retaliation. That's not what this is about. Because much of the evidence that you've heard, as I predicted over the past weeks, is uncontested by us. We're not throwing stuff at the wall and seeing what sticks. We accept the case. We do not contest the evidence from the theater. We have not contested the evidence from Mr. Holmes' apartment, or his computers, or his car, or his iPhone, or his iPod, or anything else relating to the acts around the shooting, other than what his mental state was. So you need to ask yourself, why did we hear all of that then? What purpose was there in presenting all of that evidence? Maybe there's a legitimate purpose that I don't see. But for something that is not contested in any way, it appears like it may be to get at your emotions, to pull your heartstrings. And I hope that you can see that that's something that you need to guard against. Accept the fact that people get sick. We in this country seem to be in denial about mental illness, and that denial seems to persist. If things are going to change, that's going to have to change. And now is the time, and this is the place, and you are the people. This case is a contrast and contradiction. It doesn't make sense that a young man raised by a good family, in a good home, that did all the right things, that loved him, taught him right from wrong, that under those circumstances, this can happen. It makes no sense. There's no logical reason for it. In opening statement, I said you can run at this thing from any directions you want, and there's no reason why this happened other than the mental illness. So you have to analyze what happened in the context of that mental illness. And you have to try to understand what was going on in Mr. Holmes' brain on July 20th, 2012. You can't just ignore the fact that he was mentally ill. As it turns out, the scope of the issues that you have to decide is pretty narrow, considering the vast amount of information that you were presented with and that's available in this case. Because the only issue is whether or not Mr. Holmes was sane or not at the time. And we'll talk a little bit about what decisions you need to make to follow that path. But first, let's talk a little bit about the law. And I want to talk about reasonable doubt. Because reasonable doubt is the test, in this case, in every criminal case, by which you must judge all of the evidence. It's the crucible that you have to weigh it on. And Mr. Brockler pointed out that it's not a vague or a speculative or imaginary doubt, reasonable doubt. And that's true. And I'm never going to ask you to speculate or imagine something that isn't there. But reasonable doubt means a doubt based upon reason and common sense, which arises from a fair and rational consideration of the evidence in the case, all of the evidence or the lack of evidence in the case. Reason and common sense are the tools that you have to use. And then the definition continues, and you're told exactly what a reasonable doubt is. It's not a vague, a speculative, or imaginary doubt, but such a doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. So, you have to consider this as if it was a matter of importance to you. It's a matter of importance to the victims. It's a matter of importance to the parties. It's a matter of importance to the Holmes family. But you are required to consider it as if it's a matter of importance to you. What's important to you? The people that you love? The work that you do? Doing the right thing? The decision you make in here is different than the decisions we all make every day out there. Because here, in the fortress of the law, there's no room for mistake. Out there, if you take a job and you decide, I thought this was going to be a great job. I thought it was going to be wonderful, but I don't like it. You can quit the job. If you find someone that you think is great and you decide that you want to become involved in a relationship with them, but it doesn't turn out the way you thought, you can break up. You can get divorced. There are ways to fix mistakes in the real world. That's why we don't make decisions beyond a reasonable doubt in the real world. But here, Mr. Holmes gets one chance, one jury, one decision. And that's why you've got to be sure when you make that decision. Because there's no second guessing. such a doubt as would cause reasonable people to hesitate to act in a matter of importance to themselves. To hesitate. Not to not act, but to hesitate. If you were to buy a car, and you took the car on a test drive, a used car, for example, and you heard a funny sound, and you say, whoa, wait a minute, and it makes you hesitate. Out there, you can take it to the mechanic and say, is this a real problem or not? And you can either move forward or not based upon what you're told. But in here, no one tells you. And if you hear something or things, or you don't hear something or things that would cause you to hesitate in a matter of importance to yourself, then you have sworn an oath that you must render a verdict of not guilty. The hesitation is the reasonable doubt. And in this case, the burden of proof, as in every case, is on the prosecution. They have to prove what happened. And they have to prove to you, beyond a reasonable doubt, beyond that point of hesitation in a matter of importance to yourselves, that Mr. Holmes was not insane at the moment he walked into the theater. Not on March 26th, not in May, not in June, but on July 20th. They have to prove to you that his mental processes were such that that the psychosis that the doctors have all said he was suffering from did not obscure his ability to make a distinction between right or wrong. And that is a very, very difficult decision. Regardless of how simple this guy makes it seem. This is probably too small to read. But what this says is that in this case, a separate offense is charged in each count. And I want to be clear. Mr. Holmes was insane. That's the verdict that I am asking you to render. That's the right verdict, in my opinion. That's the verdict that the evidence points to.
Yes. Talked about at the bench.
Thank you, Judge. That's a valid objection. Because it's not what I think the verdict should be that matters. And it's not what Mr. Brockler thinks or says the verdict should be that matters. It's what the evidence shows that the verdict is and what's been proven to you beyond a reasonable doubt. Despite the fact that I will ask for verdicts of not guilty by reason of insanity, You have a duty to go through all of this evidence, and you have a duty to go through all of the separate charges in the case, and that's what this instruction says. And I say that because I want to talk very briefly about extreme indifference murder. Because while it's true that they're not mutually exclusive, after deliberation murder and extreme indifference murder, they're very different theories. And that's why they're both charged. After deliberation murder involves the specific intent to kill an individual. That individual doesn't have to be the same person that ends up being killed, but there must be specific intent and deliberation, meaning the exercise of reflection and judgment about the specific intent to kill an individual. That is very differently than extreme indifference murder. The classic example of which is shooting blindly into a crowd. They're not mutually exclusive, but they're very different things, and they require very different kinds of evidence, and you're required to analyze both for every count. You know, it's interesting because Mr. Brockler just talked to you about the different experts in the case. And surprisingly, or not so, the experts that the defense called are all criticized, not for their opinions, not for the work that they actually did on the case, not for the substance of their testimony, but for how they wrote their reports, or how they used grammar, or when they did what, or in what order. While at the same time, Dr. Metzner and Dr. Reed have some of the same issues, but they're not criticized. Dr. Reed testifies for the defense, but for him, that's apparently not an issue in this case. But it is for the other experts. You haven't heard any argument or any cross-examination of any of these experts to suggest that their opinions are wrong, that their diagnoses are wrong. We've heard about their reports, we've heard about their punctuation, we've heard about their grammar, we've heard about the order that they did things, but nothing to suggest that what they said was incorrect. And, interestingly enough, when the judge asked the prosecution if they wanted to call rebuttal experts, we heard no expert witnesses to contradict what their opinions were.
Sustained.
There's no evidence in this case from any expert witnesses to suggest that Mr. Holmes is not mentally ill. None. In fact, the evidence in this case is remarkably consistent when it comes to mental illness. Extraordinarily consistent. And that's what every one of these experts told you. Dr. Metzner, Dr. Reed, Dr. Woodcock, Dr. Gurr. All told you that, as well as Dr. Manguso and Dr. Hanlon. Dr. Woodcock is criticized for the methods that he used in his evaluation. But he reached the exact same diagnostic result as Dr. Metzner. They took different paths, but they got to exactly the same place. They have the same formulation about what's going on here. Dr. Reed actually bought my matching paint analogy. You remember his testimony where he said, I think you're right. We all think it's red. None of us think it's yellow. All of the doctors have diagnosed Mr. Holmes with a schizophrenia spectrum disorder. All 4 of them. All 4 of them have indicated that he began to show signs of mental illness years ago. All 4 of them have indicated that this is a very serious and chronic and long-standing mental illness. All 4 of them have pointed to the beginning and the emergence of delusions in 2012. And all 4 of them have indicated that there is no indication that Mr. Holmes is faking or malingering mental illness whatsoever. So when Mr. Brockler stands in front of you and talks about Mr. Holmes being deceptive, that flies in the face of every bit of evidence that you've been presented with. And he's asking you to conclude something that's supported by none of these experts at all. And you need to bear that in mind, because you have to base your evidence not on speculation, but on evidence that you've heard from this witness stand. We know that sanity in Colorado involves 2 prongs. The first is the existence of a mental disease or defect. That has been proven beyond any reasonable doubt. And the fact that Mr. Brockler wants to stand here and pretend that's not the case doesn't change anything. All of the experts have said that Mr. Holmes is very seriously mentally ill, and that mental illness affected his thoughts, his perceptions of reality, and his ability to control and understand his behavior. And they've all said that that must be taken into consideration in this analysis. Dr. Metzner, when asked about the different statements that Mr. Brockler makes a big deal about how there's some statements made to Dr. Gurr that are different from statements made to the other doctors. And there are some statements made to Dr. Reed that are not made to the other doctors, or vice versa. Dr. Metzner said, in my opinion, malingering has been ruled out based upon not the inconsistencies, but the consistency demonstrated in his presentation over time as documented in numerous records that have already been referenced. And he talks about the psychological testing. Dr. Reed, when asked by Mr. Brockler, can these tests be beaten? Are you saying that these are infallible tests? Dr. Reed says, there are not perfect tests, but there are a lot of them. The bulk of them, the quality of interpretation of them, the combining of them with corroborating information, and the overall impression that I have and other people have had with him
suggests there's a very, very low chance. Is it possible that we could be fooled by everything? I suppose that's possible. And Mr. Brockler says, have you heard of that before? And Dr. Reed says, no, not with this bulk of care given to it. Now, there are some inconsistent things that have been said. That's true of everybody. But I don't know any reasonable examination. I just can't think of any reason to believe that malingering is even a marginally significant part of this case. So when Mr. Brockler stands before you and tells you that Mr. Holmes is deceitful in the inconsistent statements that he makes, you have to ask yourself, where is the evidence to support that? Or is that just something that Mr. Brockler is making up? Because he can't have Mr. Holmes being that mentally ill. These experts were cross-examined ad nauseum as to form, but never to substance. And that should mean something to you. Because if there was anything wrong with their opinions, if there were contradictions to their opinions, you would have heard them. But you did not hear anything of the sort. Dr. Hanlon is a good example of this. There was an enormous amount of effort put into whether Dr. Hanlon interviewed Mr. and Mrs. Holmes. And there was some case brought up where he said he'd like to do that. And there's some insinuation that I told him not to do that or something. You know, I wish I had set up that interview immediately, had I known that would be the entire substance of the cross-examination. Had I known that would make a difference. Had I known that videotaping would make a difference. I wish I would have told Dr. Gert to videotape. But it never came up. That's what she said. She said, they didn't suggest it to me one way or the other, and neither did I. I told them that it was a good idea in some cases and a bad idea in others. And that was the end of it. I wish that she had videotaped it. I make mistakes. I am imperfect. I am probably not as good a lawyer as Mr. Brockler is. But I am not here trying to fool anybody. I'm here presenting you with the truth so that you can decide. When it turns out that the entire cross-examination about interviewing the parents doesn't mean anything, you have to ask yourself, what is the point of this cross-examination? What is this telling me? Yes, Dr. Gurr couldn't interview the parents until later in the case due to her schedule. There's nothing devious about that. She was able to give us questions to ask, and we asked them and delivered the answers to her. Answers that turned out to be 100% consistent, she said, with what she found out when she actually did interview them. And she said she found out that they knew nothing about what was going on with Mr. Holmes. So whether or not she interviewed them or not turns out to not matter at all to her opinions. So why all the time spent cross-examining her on that? Because when you can't cross-examine on substance, you cross-examine on form. It's smoke and mirrors. when it turns out, as is the case, that Dr. Hanlon does his neuropsychological examination the same way, regardless of whether he interviews the parents or not, and that the information learned from the parents did not and could not affect that testing in any way, and did not affect it in any way, you have to ask yourself, what's the point of this cross-examination? Because there's nothing wrong with the work that Dr. Hanlon did. That work was checked by Dr. Manguso. Dr. Manguso, who did the same things that Dr. Hanlon did, and yet somehow, because not appointed by the defense or hand-picked by the defense, that she passes all scrutiny. Well, they did the same thing, and the results came out consistently, and they shared data. And Dr. Manguso testified that all of Dr. Hanlon's results were valid. So what's the point? To mislead you? To obscure the truth? The importance of diagnosis. First, let's talk about this testing. Because this testing is significant. And this testing, all of the psychiatrists said was significant. And that it contributed to their opinions. And that it was entirely consistent with what their opinions were. That Mr. Holmes was not faking his mental illness. There's both performance validity testing done in the neurocognitive arena to show that Mr. Holmes gave full effort and tried in all of his cognitive tests, so that decline in IQ is not feigned or made up. That's what the validity testing shows. There's also symptom validity testing done, which he passed with flying colors, without any indication that he malingered at all. And yet, in spite of all of this overwhelming evidence from all these sources, that Mr. Holmes is consistent and not faking his mental illness, Mr. Brockler seems to be suggesting to you that he is. Based upon what evidence? Or is it just something he's making up? The notebook. Mr. Brockler cross-examined about whether Mr. Holmes wrote from left to right, about whether Mr. Holmes wrote in English words, about whether he wrote in sentences with punctuation, about whether he didn't write in the margins, about whether the writing was level along the lines. Form and not substance. What he doesn't question Dr. Gurr or others about is the content of the notebook. The content of the notebook that Dr. Metzner relied so heavily on in his examination that he did an entire appendix to his report about how important that notebook is. And do you remember what he said about that? He said, when I saw that notebook, I thought, wow, there's a lot of crazy in there. When we ignore the content for the form, that is a problem. And you should be asking yourself, does this make me hesitate? If this is a matter of importance to me, the fact that the delusional, psychotic content of these writings, Mr. Brockler is asking me to ignore? And there is part of the content that he does not want you to ignore the part that involves planning, because he likes that part. Well, you know what that part shows too? It shows the extent and the nature of the delusion that Mr. Holmes was laboring under. That it was so strong and so powerful that he felt compelled to do it, and compelled to do it in that manner. You've heard over and over and over from witness after witness after witness that psychotic people can plan, and that the ability to plan and carry on everyday activities is not an indication of whether someone is mentally ill or not, and it's not an indication of whether they're being consumed by delusion, or can differentiate right from wrong, or reality from unreality. Every single expert has told you that, unequivocally. The fact that he's able to ride his bicycle, the fact that he's able to go to class, the fact that he's able to feed himself and drive a car are not relevant considerations in this case. But when Mr. Brockler stands in front of you and says the fact that he is floridly psychotic in November of 2012, just a few months after this crime, to the extent that he's naked, smearing feces on himself, doing tricks with a cup balanced on his penis, speaking gibberish, and unable to communicate in any real way, Mr. Brockler says that's irrelevant. Well, it's not irrelevant, folks. That's the mental illness that he suffers from. And every one of the doctors has said that. This is a long-standing mental illness that began before the crime and continues to this day. So what were their conclusions based on that? What is the evidence of mental illness in this case that all of these experts have relied upon? You've heard that schizophrenia spectrum disorders are characterized by those following psychotic symptoms: delusions, hallucinations, disorganized thinking, speech, behavior, and negative symptoms. And these are all psychotic symptoms. These are all psychotic illnesses. That's why they're in the chapter of the DSM that Dr. Gurr helped write, called Schizophrenia Spectrum Disorders and Other Psychotic Illnesses. That's why diagnosis is important in this case. Because Mr. Brockler is right, in one regard, that what's important is how the mental illness affected Mr. Holmes' behavior and ability to think and understand reality. That's what's important. But in order to analyze how the mental illness affected his behavior and ability to think and distinguish right from wrong, we have to know what kind of a mental illness we're talking about and how that kind of a mental illness affects people's brains and thought processes. Because there are very different kinds of mental illness. PTSD is very different from schizophrenia. And when you have a psychotic illness, that is a significant impact on every aspect of your life and every aspect of your cognition. It cannot be divorced from the person. It cannot be separated out. And you cannot attribute logic to the thoughts and behaviors that come out of that kind of a delusional system. First of all, schizophrenia is a disease. And I include in schizophrenia schizoaffective disorder and schizotypal personality disorder. They're all part of the same family. As Dr. Reed says, they're all red. This isn't a disease that you get from having bad habits, or bad behavior, or bad thoughts, or from being selfish or narcissistic. This is a disease that you get because you inherit it, just like you get cancer. And we don't blame people for getting cancer. So you can't blame someone for coming down with schizophrenia. And people that get schizophrenia don't get to choose the type of delusions that they have. They don't choose the disease, they don't choose the symptoms, they don't choose how it onsets. It's not a voluntary process, and it's not a pleasant process. It's extremely painful and disturbing and difficult. And you can see that in the behaviors and the thoughts of Mr. Holmes, that he struggled with this for years, that he didn't enjoy any of it, that he derived no pleasure from what happened whatsoever, nor has he derived any positive benefit from it. He's in jail, facing the death penalty or life in prison. He inherited the disease from his family. Now, we know that you don't automatically inherit the disease just because people in your family have it, any more than you automatically have a heart attack just because people in your family have heart disease. But the susceptibility is inherited. And we know as a fact, and these are facts, this is not something that I'm making up. It's the truth that Mr. Holmes is genetically loaded for mental illness, for psychotic mental illness. He's got it on both sides of his family. Both of his grandfathers are perfect examples. They both were hospitalized multiple times for psychotic mental illnesses. His grandfather on his father's side got it first when he was in his early 20s, which is characteristic of when people have their first break with schizophrenia. We know for a fact that his aunt, who is the fraternal twin of his father, was diagnosed some 30 years ago with schizophrenia, with schizoaffective disorder. We know that she suffers from delusions. We know that she's been completely disabled by this mental illness for the past 30 years, and that she collects disability and is unable to work. We know that she's been hospitalized several times, consistent with the dynamic psychotic process discussed by Dr. Gurr, that people can get better, and then they get worse, and then they can get better, and it can change, but over time, the disease progresses and gets worse and worse chronically over time. We know that his aunt has been treated by antipsychotic medications. So she's got the same diagnosis that Mr. Holmes has. She's being treated by the same drugs. That's a fact. And it's a fact that's relevant to what diagnosis Mr. Holmes has. And the diagnosis that Mr. Holmes has is relevant to how his mind was working on July 20th, 2012. And you cannot understand that without understanding the disease process. We know from all of these experts that there's something called a prodromal period, which is an early onset of this disease. And we know that this can happen weeks, months, even years prior to the first psychotic break. The record is abundantly clear with the fact that Mr. Holmes has been struggling with this disease for years. From the time he was in 6th grade, he started feeling that he was different. We know that as an early child, in early childhood, that he was normal, that he met developmental markers, that he wasn't autistic at the time, is what the experts have said. That's how they ruled out autism. Because when you're autistic, even as a very small child, you have these kind of social problems. And he did not. He was socially interactive. You heard from Dr. Gurr that there are videotapes of him playing with his friends, that there's reports of him participating in sports from his coaches and his teachers, of having friends and being interactive. But something changed. Something changed, and his parents noticed something was off, and they took him to counseling. And then around the time he was in 6th grade, when they moved back to San Diego, he started to feel that he was different, that his brain was broken. And he wrote about this in the notebook before the shooting. We know it's true because it's corroborated by all of the other evidence in the case. And we also know it's true that it's because it's corroborated by those people that were around Mr. Holmes during that period of time, who observed a change in his behavior from his parents, that they noticed he withdrew socially, that he was no longer interactive. He began to have thoughts about suicide. And granted, the suicide attempt in the ride in the car with the piece of cardboard, realistically, was he going to die from that? No. But what's the psychiatric significance of it? The psychiatric significance is that children of that age don't think about killing themselves. It doesn't even cross their minds. That's alarming. That's a red flag. That's what these experts have told you. Dr. Metzner and Dr. Gurr both told you that. And then they take him to counseling again with Mel Lipsy. And we know he's telling the truth about this because he writes about Mel Lipsy in his notebook. And we know Mel Lipsy exists because we went out and found it. We went out and found those records. And they don't tell what the content of the treatment was, but we know that it went on for a good part of a year. So there was something going on there that was not right. The negative symptoms of schizophrenia: emotional withdrawal, social withdrawal, silence, paucity of speech, it's been called. Alogia, I think is the word for it. Low initiative, lack of motivation, blunted affect, disturbance of volition. These are all things that all of the experts saw evidence of as early as high school. And they said that, including Dr. Reed, who said he saw evidence of magical thinking and other aspects of the schizotypal personality disorder as early as high school. Here's Mel Lipsy. This is consistency. This is truth. Mr. Holmes wrote it in the notebook, and it turns out that it's true. He even got the name right. Mel, last name unknown. And what does he say in the notebook about it? Does he say anything that helps himself? Family therapy with Mel revealed nothing as to not appear weak amongst family. Was a kid at the time, parasuicide, mother noticed, asked what happened, replied, paper cut. No further investigation, clean bill of health. Decided to dedicate life to killing others so I could live. From middle school. Middle school. We know that not only Are all of the experts' opinions consistent with one another? We know that they're not only consistent with one another, but they're consistent with the psychological testing that was done, with the neuropsychological testing that was done, and with the imaging that was done. But it also fits the classic pattern that people with schizophrenia develop their first psychotic break when they're in their late teens or early 20s. That's how it goes. And that's what happened here. That's significant. And that's why Mr. Holmes changed in 2012. That's what happened. He had his first psychotic break. That's Dr. Metzner's opinion. That's Dr. Gurr's opinion. That's Dr. Woodcock's opinion. And that's when Dr. Reed says the delusions first appeared, the reason why he diagnosed a delusional disorder, which of necessity involves delusions, which are by definition psychotic. That's why delusional disorder is contained in the same chapter with schizophrenia spectrum disorder and other psychotic disorders, because it involves psychosis. So you have the prodromal period, and then you have the first break. And then people can get better somewhat. And then they may get worse again later, like in 2012. But that doesn't mean that the person wasn't psychotic before, because he could ride his bicycle. We've heard this series of questions from numerous people about, did you see him eating paint chips, Dr. Fenton? Did you tell him to put this shirt on? He said, no, that's a basset hound. Yeah. I can't even remember what the other ones were. There was one about a rainbow. If that's the measure of psychotic mental illness, then all of psychiatry apparently has it all wrong. If you have to be eating paint chips. It's been reduced to questions like, could he get up on his bed unassisted? Could he get on his bed unassisted? And that is apparently relevant to mental illness and psychotic delusion? This is misdirection, folks. This is an attempt to muddle the issues, because the psychotic illness is clear and evident, and the truth.
We talked also, and we have talked a fair amount about the thoughts or intrusive thoughts or impulses to kill other people that have occurred sometimes a long, long time ago, even when you were a child, right?
Right.
How far back does the human capital idea go? The idea that I will get some value for killing a person.
Since graduate school.
Just research.
Since graduate school. That's when it changed. That's what they all say. That's what Mr. Holmes says. And how do we know what happened and that there's validity to this change? Because he was being seen by psychiatrists throughout this period. Now, there's some contradictions in here. Why didn't he tell everything? Why did he even go? And I talked about that. How if logic were the consideration, what he did makes no sense at all. But he did it, nevertheless. And they are professionals, and they recorded what their observations were. And this was not a brief contact. This was over the period of 4 months. There are phone calls, there are numerous email messages, there are prescriptions written, and there are numerous appointments where these issues are discussed, both with Margaret Roth, the licensed clinical social worker, especially with Dr. Fenton, and then eventually the last 2 visits with Dr. Feinstein as well. And what did Dr. Feinstein tell you was the most important consideration? We really thought that he was on the verge of having a nervous breakdown, of having a first psychotic break of some kind. That's what these professionals thought. That's a fact. It's not something I'm making up. A lot of contact. When he goes to see Margaret Roth, this is the first time, and he doesn't need to do this. He doesn't need to go at all. But he does, for some reason. And she says, he's the most anxious guy I've seen. She's been doing this a long time. And that's what she says, the most anxious guy I've seen. And Dr. Gurr talked about anxiety and how anxiety is a profound symptom of schizophrenia. And how that anxiety manifests itself in these folks and takes over. By the time he goes to see Margaret Roth, he is so anxious that he's the most anxious guy she's ever seen. And he tells her that he has thoughts of killing people. That's significant. That's consistent with what he's told the other experts. It's consistent with what he wrote in the notebook. It's consistent with the psychological testing that's been done. It all fits together like a puzzle. And every piece goes in the right place. Dr. Fenton sees him for the first time. The first time he walks into that office, March 21st. And she identifies him as having a psychotic level of thinking. That's a fact. He's already psychotic on the 21st of March. He's saying things that don't make sense, and she identifies it as psychosis because that's what she's trained to do. She's a psychiatrist who's been in practice a long time. Even on that early date, she considers an antipsychotic medication. Now, there's a lot of talk about what the side effects of this medication may be and why someone might not want to take the medicine due to the side effects or what those possible side effects were. Dr. Reed talked about weight gain and restless legs and sleeping problems. Well, doctors don't prescribe medications for their side effects. They prescribe medication for the direct effects. And the direct effects of antipsychotic medication is that it helps to control psychosis. They wouldn't have considered an antipsychotic medication if he wasn't psychotic. That's the truth. That's a fact. What does he write in the notebook? Prevent building a false sense of rapport, speak truthfully, and deflect incriminating questions. Speak truthfully and deflect incriminating questions. Now, counsel made a big deal about this in his argument about how Mr. Holmes was deceitful and deceived people about these things. How he went out of his way because he knew that the people would know that what he was doing was wrong. The people in the theater and the police and the people that he's buying the equipment from would know. He knows. Well, he knows that it's illegal. Every one of those arguments that Mr. Brockler talks about how his planning was hidden and he tried to hide from other people what was going on, and he didn't tell his parents, That all relates to it being illegal. But illegal is not the standard in Colorado. That is misdirection, folks. That is misconstruing things. The standard is morally, what did he think? From a societal moral perspective. And the fact that he was trying to hide things from the police is abundantly clear. I concede that. He knew what he was doing was legally wrong, but that's not the test. When you're presented with these arguments, ask yourself two questions. First of all, what evidence is this being based on? And if there's no evidence behind it, then it's speculation. And you may not base your decisions on speculation here in this room. You must base your decisions only on evidence. And if you find there is some support in the evidence for that, ask yourself, what difference does this make to the determinations that I have to make? Or is this intended as a distraction? Look at the birdie over here. There's no doubt that he knew what he was doing was illegal, and there's no doubt that he made efforts to not divulge it so that he wouldn't be stopped, because he was psychotically ambivalent about it at that point. That's a symptom of the mental illness, that you want to be fixed, and at the same time you don't. That's it. Through all of these interviews with these experts, he talks about this struggle going on between these two parts of himself. And that's consistent with schizophrenia. That's how it works. And you can't just try to apply logic to that, because it's not logical. We know that Dr. Fenton put Mr. Holmes on medication, namely sertraline. That's the important one, because that's an SSRI, Zoloft. It's an antidepressant, anti-anxiety medication. And what did Dr. Metzner tell you about that in his testimony? He told you there's abundant literature out there that talks about a thing called the manic switch. That when you have somebody who has a mood disorder as part of their mental illness, that they're depressed, which is what he diagnosed Mr. Holmes with, and the others too, for the most part, some degree of depression. Schizoaffective disorder involves a major depressive disorder. When you give somebody like that an SSRI, it can make them worse. It can flip them into mania. That's what Dr. Metzner said. He's given the SSRI, and the dosage is increased over time. He writes in the notebook about the effects of this medication on him. Immediately prescribed antidepressants. He talks about the benzos and the long-lasting SSRIs of sertraline. Anxiety and depression, both, I'm having the same problem Mr. Barkler does. Serologenic system anyway, though. No effect when needed. First appearance of mania occurs. Not good mania. Fear of failure is gone. The things that were enabling him to control this mental illness for years have now been discarded by the onset of the psychosis, and perhaps by the prescribing of this medication. Because we know as a fact that this can happen. Not something I made up. It's a fact. He was given this medication, and it can have that effect. And he reported it having that effect. He reported driving really fast, like he never did before. He reported buying things that he never did before, engaging in activities that he never did before. Think about it. Signed up for a motorcycle class. Starts going to the gym at 3 o'clock in the morning. Signs up for dating websites, XXX dating websites. Never done that before in his life. Paints his hair red. All kinds of bizarre behaviors that he'd never engaged in before. And counsel can say to you over and over again that he never changed, he never changed, he never changed. But he did. He changed dramatically. And maybe the folks at his school didn't recognize that because they weren't paying attention. Or maybe they were in denial about mental illness. It's a very difficult thing to identify and accept. There's the sertraline on the right. There are 4 pills left in the bottle that's found in Mr. Holmes' apartment. You've got the pharmacy receipts when he picked that prescription up. You do the math and check my math. But if my math is correct, he took that last dose of sertraline on the 22nd of May. Not early in May, like Mr. Brockler said, but late in May, on the 22nd of May, right before he almost ran out. Over this period of time, he disintegrates. And the fact that he's going to class and riding his bicycle doesn't change that. These are the mental status examinations done by Margaret Roth on his first appointment and by Dr. Fenton on his last appointment. This is what happened to him between March and June. And bear in mind, this is just 5 days before Fenton sees him and identifies him as having a psychotic level of thinking. But nevertheless, even though he was psychotic at the time, he was able to hold it together really good at this point. He's been dealing with this mental illness for a long time. Attitude, cooperative. In June, contemptuous, devaluing, evasive, guarded, hostile, suspicious, uncooperative. And you heard how that manifested itself. He thought Fenton was hiding something from him in a package. He thought that Dr. Feinstein had something hidden in his cast. And it turns out when we check with Feinstein and Fenton, those things actually occurred. But they had nothing to do with Mr. Holmes. He was attributing a magical amount of significance to them. That's delusional thinking. Affect, appropriate. Affect, anxiety, hostility, inappropriate, odd, bizarre. Speech normal, taciturn, stilted. Thought content without delusion. Thought content, paranoid delusions, preoccupations. This is not the same guy. Mr. Brockler keeps talking about he was the same guy. Well, yeah, he's the same guy. He's James Holmes. He's just the same guy who's now in the throes of a psychotic breakdown that's happening to him over time. Violent thoughts, not present, homicidal thoughts. There's a dramatic change in him, and we'll talk more about that. By the time he leaves treatment, the conclusion of both Dr. Fenton and Dr. Feinstein is that he is intermittently functioning at a psychotic level. That's their opinion. And that he may be shifting insidiously into a frank psychotic disorder such as schizophrenia. Well, lo and behold, they were right. He was. They were spot on. Hallucinations.
I was seeing weird shadows.
Tell me about that.
Well, I'd be in lab and there'd be like a flickering in my peripheral vision, and then there'd be like shadows moving with nothing causing them.
People see things in their peripheral vision from time to time. It may or may not be abnormal. So can you describe to me a little bit more about it and why you believed it was abnormal at the time?
Just that nothing I saw that could have caused those shadows to move made them move. And that was in my frontal vision. After I turned to see what the flickering was, kind of thing. So I could actually see shadows in front of me that were kind of dancing.
Straight on rather than in the peripheral once you turned your head.
Right.
Tell me more about that. What did that look like?
Usually it looked like just the shape of a person, and maybe they were like jungling or doing something.
I'm sorry, like
juggling.
Any thought about what that might have meant?
No.
Or what the figure might have been or represented?
I don't think there's any rhyme or reason to it.
He writes in the notebook, quick fleeting movements in peripheral vision, kind of like a light flicker. Other times, dark splotchy movement in peripheral vision, like a crow or a beetle, began a year ago. When gaze shifted to identify movement, no source is present. He talked to Dr. Woodcock about hallucinations, visual movement without cause in undergraduate school. Flashes to the side. Never sought help for it. He talked to Dr. Gurr about seeing shadows in the lab, the same lab he talked to Dr. Reed about. He also talked to her about seeing flickerings in his peripheral vision earlier on. These are progressive symptoms, folks. They're different over time because they're different over time. They're not always exactly the same. But that doesn't mean they're not happening. He reports them consistently to numerous different experts. And he minimizes it. And the doctors have said that he minimizes his mental health symptoms. He doesn't exaggerate them. He doesn't make them up. He minimizes them because he doesn't want people to think that he's sick. And they've all said that that is a manifestation of psychotic illness. And that's very, very common. That it's something that people do not want to accept. Delusions. Every doctor talks about the delusions beginning in March. And they all talk about this Gmail chat. In this Gmail chat with Ms. Dada, Mr. Holmes talks about killing people for the first time with someone else. That's what he tells everyone. He tells everyone that this is the first time he brought this up. He tells Dr. Woodcock that. He tells Dr. Reed that. He tells Dr. Metzner that. And he tells Dr. Gurr that. And what does he write in this Gmail chat that no one is privy to? As Mr. Brockler said, this is unedited. This is his communication with the woman that he is in love with that's completely 100% private. And what does he say? Life is priceless. You take away life and your human capital is limitless. This is the beginning of the delusional construct. This is it coming to light for the first time. And this is a psychotic thought process because he tells all the experts, once I said it, it made it real and it had to be done. And Dr. Metzner and Dr. Woodcock and Dr. Gurr have all indicated that that is psychotic thinking and characteristic of a schizophrenia spectrum disorder. That once something is spoken, it becomes real. Nobody thinks like that. That's not reality. When I say something, it doesn't become real and inevitable and must happen. But that's the way Mr. Holmes was thinking way back in March of 2012. There's no doubt. That's evidence, not something I made up. That's evidence, according to every single one of these experts, of his psychotic mental illness beginning, the delusional construct beginning. He writes about the very same thing in the notebook, human capital. He talks about it with the experts. He writes about it in the galactic colonization writings. It's consistent throughout. And you know what, folks? It's not true. When you kill other people, you don't increase your self-worth. Nobody thinks that. That's not a philosophy. There's a lot of talk about philosophy. There's no philosophy that says when you kill other people, it increases your self-worth. It's in the galactic colonization writings. And the galactic colonization writings are also evidence of disorganized thinking, according to Dr. Metzner and Dr. Gurr and Dr. Woodcock, as well as the notebook. Not only delusion, but disorganized thinking. What about this? In November of 2012, Mr. Holmes jumps off his bed at 3 o'clock in the morning for no reason in the world. He tells Dr. Gurr that he thinks somebody is going to catch him, although he doesn't know who that is that's going to catch him in the trust fall, even though he's locked in his cell all by himself all day long. Folds his arms across his chest and kind of falls backwards there, and then it's acting like an insect kind of on the ground. He tells folks, I'm trying to keep it all together. The systems, all the systems. I do not know that you're real. That was Russell Martins from Classifications that testified to that for you. He rams his head into the wall. He's giving strange responses. The next day on the 12th, he is giving confused answers about I don't know where the water is. He's rolling around like a log in his cell. Nurse Pagan probably gave the best descriptions of him being frozen on the floor with his arms locked into a position. That's catatonia. That's a symptom of schizophrenia. Now, what he's describing happening earlier on, fitting it in over his lunch hour, is not catatonia. That's him misdiagnosing himself. The other experts said he was depressed then, and that's clear evidence of depression when you can't get out of bed and you're amotivated. But catatonia is not something you can fit in over your lunch hour. It happens to you when you're very, very ill with schizophrenia. And it happened to him. He's taken in for a CT scan. He repeats for an hour and a half. You can't teach an old dog new tricks. You can't teach an old dog new tricks. That's called perseveration. It's disorganized speech. It's a symptom of schizophrenia. He's given an IV. And let's be clear about this delirium thing, okay? First of all, the experts testified that somebody in Mr. Holmes' condition, a 24-year-old physically well young man otherwise, given the blood work he had, would not be likely to develop a delirium. And you heard one of the experts talk about people that go on hunger strikes for much longer periods of time, and they don't develop delirium. He's given IVs when he goes to the hospital this time. He's given an IV before he goes in the jail. He's given an IV in the jail the next day before he goes to the hospital. He's given another IV in the ambulance, and he's given a third IV when he shows up at the hospital. Dr. Caldwell, who sees him first, who says he's talking gibberish, says that he's responsive to him, but not talking in a way that makes any sense. Not consistent with delirium. Delirium waxes and wanes, and it involves disorientation. Delirium doesn't make you smear your poop on yourself. Delirium doesn't make you hear voices from all kinds of different people. Delirium doesn't give you catatonia. Okay? There's no doubt that if there was any delirium at all, which the doctors from Denver Health Medical Center say is unlikely in their opinion, it cleared up very, very quickly. The behavior that you saw in the jail is psychosis. The psychosis preceded any metabolic disturbance. He's taken to Denver Health. He's experiencing, he says, 8 different voices are talking to him. He's able to identify the gender of the voices. By the time he gets to the 19th, after he's been there for 4 days on antipsychotic medication, that's when he tells Dr. Weintraub that the shadows were still bothering him last night, and that they wouldn't leave him alone, and they kept pestering him. And when we looked at that surveillance video, you can see him doing exactly what he told Dr. Weintraub he was doing. That's hiding under the sheets from these shadow people. This is after he's been on antipsychotic medication for 4 days, and he's doing significantly better. When he first arrives there, he's just repeating shadow point over and over and over again. He's given Haldol, and that improves him somewhat. He's able to respond to Dr. Dr. Caldwell, but does it in not in English, in gibberish. But I'm sorry? Thank you. Disorganized thinking.
You're referring on the next page, and I'm a little confused about it. Let me go to the transcript of it. You're talking a little bit about beliefs of reincarnation. In practice, however, this is yet to be possible. And the complexity of such a venture in immortalizing a matter arrangement that is amenable to changes on matter around it is daunting. That's a bit confusing to me. Does that ring a bell with you at all?
I thought if a person was reincarnated, they'd have to be into a conscious state.
It makes no sense. And this is when he's in jail writing in those writings. Makes no sense at all. It's psychotic. It's disorganized. His behavior around the crime is disorganized too. After his arrest, he appears disoriented. He overloads the magazines. This construct in his apartment, it's very dangerous and very frightening, this setup that he makes. But there's some disorganized nature to it. There are 3 different activation devices. One is this tripwire, which doesn't activate when you open the door. It's not in the way of the door. It's placed at this bizarre angle away from the door and up so that you can see it when you shine a light on it. And when they send the bomb robot in, it contacts the filament and it doesn't work. It doesn't do anything. What are the 2 other activation devices? Well, they're both done by remote control, right? And so the one that's in the kitchen is activated by the remote control that he puts in the box of the radio-controlled car, right? To replace the remote control from the car. And he puts the boom box in the dumpster with the car, and the boom box is supposed to come on at 12:30 in the morning, playing loud music, and somebody's going to go through the dumpster and find the box with the toy in it, open it up, take out the remote control, and manipulate the remote control, which is supposedly going to set off what's going on in the apartment. Well, the remote control is line of sight, like the remote control on your television, right? Where's the dumpster? It's totally around the corner on the opposite side of the building. Can't work. Doesn't work. Where's the other remote control? It's right there on the table in the apartment. In order to activate this, you have to point it and push the button. But it's left right there. So he constructs this elaborate, frightening construction, but instead of using a timer or a fuse or just throwing a match in there, he comes up with these initiation devices that can't possibly work and are bizarre. It's disorganized thinking, folks. Dr. Gurr told you, this is not the behavior of a 24-year-old graduate student with almost 130 IQ. Picking staples out of under the table, picking up pieces of paper and playing games with them, playing hacky sack with your sock. It's childlike behavior. It's disorganized behavior.
Well, I became more disorganized. And, I guess my mind was kind of falling apart.
I became more disorganized and my mind was falling apart. The neuropsychological testing, all kinds of domains by both of the experts. We talked about this. And what does it show? Dr. Manguso's testing is a few months after Dr. Hanlon's first testing, and she notices a slight deficit, a slight neurocognitive deficit. And Dr. Hanlon thinks maybe we should do a follow-up examination. So he goes back and he does one. And what do they find? A dramatic, significant, otherwise unexplained drop in his IQ. From the 94th percentile to the 86th percentile. He goes from having a superior intelligence to having high average intelligence, or even average in some areas. This is a frightening change over a close period of time. And what do we know? We know that those domains that he suffered this neurocognitive deficits in are exactly the same domains that Dr. Gurr has identified in her research on schizophrenia. It's the same areas of the brain that are affected. It's all consistent. And then we do an MRI. And an MRI is not diagnostic. Dr. Gurr told you that. It only can identify 80 out of 100 schizophrenics if it's used alone. But we didn't use it alone here. We had a tremendous amount of information by the time we'd gotten there. We had a vast amount of information, and we knew from this neurocognitive testing that there had been a change, according to the testing, in Mr. Holmes's brain. So because of that, she recommends an MRI. And we know that in schizophrenia, your brain shrinks, commensurate with these cognitive deficits. And what did we find out from Mr. Holmes? That happened. Is that in and of itself diagnostic? No, it's not. Is it 100% consistent with all of the other evidence? Yes, it is.
Yes. All right, Mr. King, you may proceed.
And as you recall, this is a picture of Mr. Holmes' brain. This is an example Dr. Gurr gave. But she did the same kind of volumetric analysis on it, and it showed the deficits.
Mr. King, your mic.
It's not on.
I don't think it's on. There you go.
This is not Mr. Holmes' brain. This was an example. But she did the same volumetric analysis on Mr. Holmes' MRI, and it showed that there was a slight decrease in the volume. 100% consistent with the other findings. So there's no doubt that there's a mental disease or defect. The question is, did it affect his ability to be able to distinguish between right or wrong, or to deliberate, to act with reflection and judgment? Again, the prosecution has the burden of proof in this regard, and the test, as we all know, is that it comes from a moral perspective. And you can recall that both, what's interesting is that there's a couple of problems, despite the fact that Dr. Metzner and Dr. Reed are entirely consistent with Gurr and Woodcock in everything other than their sanity finding. There's a split of opinion on sanity. So let's look at what those issues are, because it's even more narrow than the other issues. They make their decision based on a very few factual issues, a handful of issues, each one of them. And if you recall, both of them, when initially questioned, said that they evaluated Mr. Holmes based upon a moral and legal standard. And if you recall, I objected when Dr. Reed said that and went to the bench, and the judge instructed you on the proper standard. So guess what? These forensic experts that are so knowledgeable about the interaction of the law and mental illness got the standard wrong. Dr. Metzner lists 7 things. The chat session with Gargi Dada means he knows what he's doing is wrong. Well, he says it's evil back in March, but that doesn't tell us anything about what happened after he's seriously decompensated a great deal in July. His ambivalence regarding the statements he made to Drs. Fenton and Feinstein, we've talked about that. It shows that he legally knew what he was doing were wrong, but it says nothing about morality at all. Sending the notebook, I don't know what that bears on anything, or how that shows that what he's doing is morally wrong. He knows there's something wrong with his brain. He's known that since he was like 10. The Hillary Allen text message, the floodgates are open. The floodgates are open. He's describing his psychotic state. Does not mean that what he knows, what he's doing is morally wrong. He doesn't want her to be hurt. But that doesn't mean, there's no indication that Mr. Holmes gets any pleasure from this at all. This is not something he desires to do. And Dr. Gurr told you that it's entirely possible that he might find it something that he needed to do, that he must do, that was right to do, and it may still be unpleasant for him, which is why he has to make it impersonal. And he spray paints the gas mask so he can't see. And he puts in the earbuds so he can't hear. Because despite the fact that he thinks he must do it and it's the right thing to do, it's not something he gets any pleasure or joy out of. Concern whether any children had been hurt. Well, he asked if a child was killed. He tells Dr. Metzner and Dr. Gurr that children are worth more. Now he tells Dr. Reed years later that he now thinks killing a child is wrong. But he never says that to Dr. Woodcock or Dr. Gurr early on in the proceeding. And there's no indication that that's why he asked that question.
You can speculate. Speculate a little for me, would you? Can you speculate on it? Speculate. What is it logical to speculate? Speculate for me. You're a smart guy. Speculate for me. What do you speculate? And it would be pure speculation. What do you speculate? Speculate for me. As you speculate, do you speculate? Can you speculate about what you think? To speculate about the future.
One thing you need to bear in mind is not only did they apply the wrong legal standard, but they're interviewing Mr. Holmes years later when he's in a medicated state and asking him to analyze what he was thinking when he was psychotic. And you can't do that. It doesn't work. You're going to get bad information. And so what do they do to try to develop these few handful of facts that they entirely base their sanity decisions on? They try to drill down on these facts. And the perfect example is in Dr. Reed's examination, where he over and over and over again pursues and suggests answers to Mr. Holmes. That's where this information comes from. Look at these factual points that they're relying on and look at where the information comes from. They ask him, do you know why you colored your hair? No, I don't. Well, speculate for me. And then he gives an answer to the speculation, and they base their decisions on his speculation about what he was thinking 2 years ago when he was psychotic. There's a fundamental flaw there, and that's what Dr. Woodcock's point was in why this is not as reliable, and why you have to evaluate what's going on in Mr. Holmes' brain on July 20th, 2012, and not what he thinks about it 2 years later, 3 years later in a medicated state. He not only asks him to speculate, he repeatedly suggests things over and over and over again. Repeatedly suggests logical
And again, it's my thought, not necessarily yours. And again, just my thought. And again, I'm not trying to put words in your mouth. And again, I don't want to put words in your mouth. My thoughts don't have to be your thoughts. Again, I don't want to put words in your mouth. Tell me in your words. My thought is maybe that's not your thought. Again, I don't want to put words in your mouth. Again, maybe kind of putting words in your mouth. I don't want to put words in your mouth. I don't want it to be my thoughts and words. Again, I don't want to put words in your mouth. I don't mean to put words in your mouth. I'm trying not to put words in your mouth. My thought, not yours. Exactly. That was exactly my thought. Again, I don't want to put words in your mouth. My thoughts go, and once again, my thought's not necessarily yours. My thought is, so my thought is, I don't want to put words in your mouth. Is that more Reed's mind and not Holmes' mind? And I don't want to put my...
No, I didn't feel that way.
Here's what I'm thinking. That's taking my thoughts. Again, as I said before, I don't want to put words in your mouth. Sometimes I talk too much.
Over and over and over again, we suggest the answers to Mr. Holmes, even though he doesn't remember what he was thinking about it when he was psychotic. And then we attribute meaning to those answers and base our sanity decision on it. It's flawed. He knew the shootings would be illegal. Yes, you're applying the wrong standard. His planning and practice were surreptitious. They were hidden. Yes, he knew it was legally wrong. You're applying the wrong standard. He planned methods of distraction and escape. Yes, he knew it was legally wrong. You're applying the wrong standard. And what about those methods of escape? Did they work out well? The cow trips are on the seat of his car. His passport's left at home. He's got a couple $100 in his pocket, but he doesn't do anything. Choose a method that would result in maximum deaths. Does that show he knows it's morally wrong? Quite the contrary. That shows he's so consumed by this delusion that he doesn't know that he's trying to maximize the number of deaths. Carried out the shootings methodically. He was on autopilot. He was following his plan, the mission. Doesn't say anything about whether he knew what he was doing was wrong from a moral societal perspective. He knew the victims would suffer and not want to be killed. He also thought he was doing them a favor, apparently. It's not logical. It's not a logical process. We can't attribute logic to it when it's psychotic. And moral relativism, the idea that somehow this only applies to him, that this delusion only applies to him, and that he thinks that only he is the person that this construct applies to. Well, we know that's not true. Because when Dr. Reed talks to him about this, he tells Dr. Reed, no, I think it's an objective standard. Objective, not subjective. He tells Dr. Reed asks him, is it out there for other people to discover? Yes, it is, he says. And then he talks about how if he's executed, people are going to gain points. He says maybe the person that makes the lethal injection concoction or pushes the button, or maybe even the jury. The construct applies to everyone It's just not everyone figured it out yet. But if they knew what I know, then they would agree, because it's the truth that when you kill people, it increases your human capital. It's a universal truth out there to be discovered. That's what he thinks. And that's what he thinks to this day. That's the strength and the persistence of this psychotic delusion. Despite the fact that he's sat here through the course of this entire proceeding and listened to all these doctors talk, he still thinks that. As opposed to Reed and Metzner, who focus only on 5 or 6 or 7 individual facts to base their entire decision about sanity on, Dr. Gurr and Dr. Woodcock, to some extent, talk about the psychosis being a fluid and dynamic process that changes over time. And you have to analyze what was going on July 20th. In order to figure out whether he was able to distinguish between right or wrong on that date, or whether the psychosis had obscured his ability to do so, whether the psychosis had obscured his ability to deliberate, to act after reflection and judgment. After reflection and judgment. Read that notebook. Tell me what reflection and judgment is shown there. Read that galactic colonization. Tell me about the reflection and judgment shown there. We know that he's been fighting this since he was a kid. Struggling, he says, I have struggled for years and years. I have fought and fought, always defending against predetermination and the fallibility of man. And you know what? Until the psychosis happened to him and overwhelmed him, he won that fight. He was able to suppress these thoughts that came into his mind as unwanted thoughts. Can you imagine being in middle school and having thoughts come into your mind several times a week? Go kill people. You have to kill people. And that continues for year after year after year.
Sustained.
Think about it. Think about how strong and long-standing this mental illness is. The beginning of the delusion, there's no doubt. All of the experts agree. He does poorly in his classes. He continues to go to class. He continues to get okay grades. He continues to turn in his papers. But the fact is, he doesn't succeed in graduate school. The thing that he's wanted to do his entire life and spent his entire life dedicated to, all of a sudden just doesn't matter to him anymore. And what? His classmates come in and say, you know what? Doesn't seem like he cares anymore. He's just not motivated. Well, he's not motivated because he rocked it in high school and rocked it in college, and now he can't rock it in graduate school anymore because it's different. No, he's not rocking it in graduate school because he's mentally ill. And these are symptoms of his mental illness. The social withdrawal, the lack of motivation, the lack of interest in subjects that used to interest you. He's no longer interested because he's overwhelmed by the need to complete his mission. He must complete the mission. The mission has overwhelmed everything else. We could see between the labs that he does well the first semester. The second semester, he does poorly. He writes in the notebook, I attempt to see if I can pass the exams by myself and not by fear. Failure. He fails his prelims. This all happens in the same period of time. You can see that the red is the Gargidata chat, and the Hillary Allen floodgates text message on the end. The red are the appointments with Dr. Fenton. The blue are the purchases of the weapons. And the green is him withdrawing from school and failing his prelims. This is all taking place at the same time. It's all interrelated. You can't separate it out. You can't separate him from the situation. You can't separate the mental illness from him. And you can't separate the psychosis from this case in this shooting. Thank you. He changes his hairdo. He hangs the symbols up all over. He does this in his apartment.
As you were thinking about these things, buying a Glock, ordering a tear gas, are you angry, or what's the thought inside you at that time?
Kind of that I have a mission to complete.
He doesn't do this because he wants to gain notoriety, because he wants to be remembered. He denies that to all the experts. He doesn't do it because he's angry, because he's upset about losing his girlfriend or failing out of school. Dr. Reed says those were not important considerations. This is the last communication where he indicates that he's lost the ability to control himself. That's what he says. Calls it dysphoric mania, means it doesn't feel good, but it's mania. And she asks him, Hillary asks him, can you control it? Is it manageable? And he says, it was. But the floodgates are open now. Now that he's on the sertraline, now that the psychosis has taken over. Love gone, motivation directed to hate, and obsessions which didn't disappear for some reason with the drugs. No consequence, no fear, alone, isolated, no work for distractions. He cuts off all of his contact with his friends. He changes the lights in his apartment to colored lights. He withdraws into his apartment. He sees nobody, virtually nobody, for weeks.
You stopped seeing them at some point, and I'm trying to think of the order of the appointments. You kept every appointment that was made, as I recall.
Yeah.
Okay. But at the last appointment, you communicated in some way that this was going to be the last appointment.
This was the last one.
Okay.
Yeah.
And as I recall, even left a little early. This is it. Is that accurate?
Yeah, that's
okay.
accurate.
Why did you make that your last appointment?
I don't know why.
Doesn't know why. Because the mission had overcome the need for treatment. That's what he said. The mission had overcome. Ladies and gentlemen, at the beginning of this case, I told you that at the end, I was going to ask you to do one thing, and that's what I'm going to ask you to do. Accept the mental illness. Acknowledge the fact that the overwhelming evidence is that Mr. Holmes was in the throes of a psychotic episode when this took place, and that we can't evaluate it based on statements that he made while medicated years later. We can't separate the mental illness from him or from this crime, because the mental illness is the reason, the sole reason, that this crime took place. In your careful consideration of the evidence and Mr. Holmes' future, I would ask you to do good, to be strong, and do the right thing. He's not guilty by reason of insanity. Thank you.
Members of the jury, let's go ahead and take our last break for the day. We might, it looks like we're going to go past 6 a little bit. Thank you for hanging in there and for your flexibility. I gave you notice last week because you never know. And so I thank you for your patience. Please make sure that you comply with all my admonishments during the break. They all apply. Let's take about a 15 or 20-minute break, okay? Thank you. The record should reflect that the jury has exited the courtroom. I'll see everyone after the break. The court will be in recess. We'll be on break for about 15 or 20. Thank you.
Please rise.
Dan King, public defender for the defense, concluding with the quote, "Do good, be strong, do the right thing. He is not guilty by reason of insanity." I'm Phil Tenser, joined again by our legal expert, Dan Recht. Dan, how do you feel? I asked you the same question when George Brockler finished his first appearance here in closing arguments. Now, how do you feel about how Dan King has performed?
I think Dan King gave a strong closing argument. It was much better than his opening argument several months ago. I mean, one of the strong points he tried to make, and who knows, but one of the strong points he tried to make is say to the jury, do not view this from an emotional perspective. Everyone agrees it was horrific what happened. Everyone feels bad for the family of the victim and the victims themselves. But you have to rise above it. That's a term he used. Rise above it. The law is above that. You have to take into consideration, you have to decide only whether he was sane or insane, or whether the prosecution proved their case beyond a reasonable doubt that he was sane. And he went on for 2 hours about why the prosecution hasn't done that, and continually said, don't view this emotionally, and why did the prosecution spend so much time putting on emotional testimony and emotional argument to you, as if saying it's a ruse, because that's not the issue.
Now, please correct me if I'm wrong, but didn't the DA have to prove the elements of the crime charged, right? Isn't that essential elements? So, I mean, if George Brockler had the opportunity to stand up and defend himself right there, isn't that what he would have said?
Yes, but you'll recall both in the evidence that was presented during the several months of testimony and in George Brockler's closing argument, he put on emotionally laden argument and clips of people being very upset, of course. But the point is, it was never contested by the defense, so he would not have had to have argued that emotional stuff to make the elements, to show that they have proven the elements. And whether the jury buys that or not, I don't know, but Dan King's argument made logical sense.
Both sides have used a lot of analogies. Dan King with this comparison of paint chips, and at the same time, just minutes later, criticizing George Brockler for the analogy about eating paint chips as a sign of being just wacko, right? Saying that that didn't have to happen in order to be crazy, and that was something that George Brockler used in questioning these doctors. At this point, are the analogies clouding the issues, or are they keeping the jury focused?
Don't know. I mean, it's true that they both did it, but keep in mind, again, they were trying to condense months of testimony into a summary fashion for 2 hours, and that's the way they each felt it best that they could do that. You have to say to a jury what you think is important. You have to pick out, in essence, the nuggets of what happened for several months and condense it into what they should be focusing on. And they each asked the jury to focus on different things, but that is the point of their closing arguments, to tell the jury, this is what you should focus on.
So I'll pause for just a second to say again that during this recess, if you'd like to send in questions for Dan and I, we are here and ready to answer them as best we can. There's one other thing I want to do before we get to your questions, though. I can already see a few of them are coming in. I want to go back to the very beginning of Dan King's argument here and the rhetorical device he used, the phrase, this guy. George Brockler used this guy or that guy talking about the defendant. And then Dan King comes out and uses it to talk about George Brockler in the same sort of tone of voice. I know a lot of people in our chat rooms, were immediately on alert saying, why isn't he being respectful? But to me, it appeared more like a rhetorical choice, trying to point out ways that maybe King felt Brockler was disrespectful. What do you think about that?
Yeah, that wasn't lost on the jury, I don't think, and it certainly wasn't lost on you and me. And what Dan King did was, I suppose there's some risk in it because some might view it as disrespectful. Mm-hmm. On the other hand, Dan King made it clear he was unhappy with George Brockler's argument. He didn't think it was, he thought it was deceptive, frankly, he said. And he kept criticizing this guy as if this guy, he said it, is trying to deceive you. And so that was a difficult choice and an interesting choice and a strategic choice. Those words were chosen, though. It isn't like he stood up and thought, maybe I'll call him this guy.
And it seemed like they were chosen directly because of the way that George Brockler spoke.
Right, I think so, which is interesting because if that's true, and I think you're right, then that was a decision that got made just a few hours ago, which is much later than those kind of strategic decisions normally would get made.
Right. Well, let's see what these questions on the chat room have to say for us. The first one here is asking if you feel Mr. King gave good arguments as to why the gunman was insane on the night of the shooting, and if so, what do you think was the standout successful point in King's argument?
Well, it's sort of threefold in my mind. One, he urged the jury not to be emotional about this. And he said, if you're not emotional, if you rise above it, if you look at the law, if you look at the standard of insanity, you'll see that he was insane. Now that begs the question a little bit, but that was the start. Secondly, he said in general, if it wasn't for the mental illness that everyone agrees on, this wouldn't have happened, and everyone agrees on that. So that brings us to insanity. And I think his strongest point on that was this. He said the experts and Brockler had the standard wrong when they were talking about if Holmes knew what was legally right or not. He said that's not the question. He knew that this was against the law, but did he know the difference between what was morally right and wrong? And there, his experts said, no, he did not. He was morally confused, and he did not understand the societal views of morally right and morally wrong, and that leaves him insane.
Another question for you. Is it contradictory that Dan King came out and said the defense and the prosecution experts were all in the same area when it comes to the diagnosis, somewhere in the area of schizophrenia, but then later he's playing these clips of Dr. Reed saying, I don't want to suggest for you, or please speculate, and then discrediting Dr. Reed's style? Is that at all contradictory to say, well, they were all in the same area, but this doctor did it wrong?
I don't think so, but I understand the question. In the first instance, Dan King is saying, look, everyone agrees on certain base things here, that he was mentally ill and that mental illness had something to do with schizophrenia. So where they differ is on whether he was sane or not, and on the doctors that decided or have the opinion that he was sane, here's where they had it wrong. And so it doesn't seem inconsistent to me, at least.
Got it. Let's see what else we can find for you from the chat rooms here. So folks, if you do have the opportunity, please do send that in for us.
At this
While you're looking, let
Sure,
me just say,
please.
you know, George Brockler, whether he was furiously taking notes or just furiously thinking, he could not have been more focused in that 2 hours, I'm sure.
That's an
because
interesting-
he has to respond, if he chooses to what Dan King said, and you can be pretty sure that he's going to.
Earlier
Now-
you said 100%. You're still
Yeah.
thinking 100%?
Oh, absolutely. Absolutely. But I'm saying, in addition, well, he for sure will get up there, but in addition, he's going to make arguments, at least for part of that 25 minutes. You heard Mr. King say this, well, here's why he was wrong. You heard Mr. King say this, well, here's why he was wrong. And then keep in mind, interestingly, King doesn't have a chance to get up and defend himself or his argument. Now, the rationale or the philosophy in the law, whether you buy into it or not, is the prosecution has this huge burden of proving their case, if they can, beyond a reasonable doubt. So therefore, because they have such a huge burden, they get to have the first argument and the last argument.
We have a question asking to clarify, again, culpable mental state. Since that is at the core of this, would you indulge us and explain that one more time?
Yeah, and that's an interesting question. Every crime, not just murder, but almost every crime, has two basic factors to it. Let's take a simple assault. You have to have done the act, you have to have punched somebody, and you have to have intended to punch somebody. So there's the act that has to happen, or it's not a crime, and you have to have intended the act, or it's not a crime. So, and that's true with everything from, you know, drug distribution to assault to domestic violence. Everything needs both the culpable mental state, that's what's being asked, and the act itself. And without one or the other, it's not a crime.
Right. And that appears on the checklist that the jury is getting for each of these crimes, that he was in the state of Colorado, that it was on July 20th of 2012. That's this culpable mental state. The idea of forming intent is one of those items on those checklists,
Absolutely
right?
it is.
And that's going to be on all of the 600 some odd pages of verdict forms.
That's right. Now, and Dan King referred to it, and of course, George Brockler referred to it. On that list of elements that the prosecution has to prove beyond a reasonable doubt, it's just as you say, and it's the culpable mental state as one. And then on each of them, it also is that they've proven that Holmes wasn't insane. That's where the double negative comes in. But that literally is as important for them to try to prove as the shooting itself.
Right. And culpable mental state, forming it or not forming it, is one of the possible ways to prove insanity, or disprove insanity.
Right.
But the other is that knowing right from wrong that we talked about earlier, and that again is the societal standard.
Right. The moral societal standard. Exactly right. Not his moral standard.
Right.
But the societal moral standard, which the defense says he did not understand.
Sure. We have a question from Nikki for you, Dan, asking how the jury could possibly find the defendant guilty of one thing and not another, and what the sentencing impact of that might be.
Well, that's another really good question. I don't see how they can find him guilty of one homicide and not the other either. I mean, in my mind, and it's seemingly Brockler and King don't disagree with this, it's all or nothing.
The jury's not going to divide their verdict.
I don't think so. I mean, you're going to see either not guilty on all of the murder counts or not guilty by reason of insanity on all of the murder counts. It's not going to be, they're not going to break it down.
Right.
And then what's the impact on...
if it were to be divided.
Oh, if it were to be divided.
What would the impact be?
Well, we can talk about that briefly because it ain't going to happen.
Right.
But all they have to do is get one first-degree murder conviction, and then the penalty can be the death penalty because, of course, a jury can give the death penalty for one homicide.
At this point, and I do want to respond to a question that I can actually answer, this break is only supposed to be 15 or 20 minutes long,
Exactly.
so we're probably most of the way through that now. On the tail end of it, we are expecting George Brockler to stand up for his rebuttal, which Dan here has said is 100% certain.
It is.
And then we are going to go, at this point it's 5:37, if they're back around 5:40, we're going to go past 6 o'clock, which he asked the jury to stay for, but the judge has been intent on getting this all done in one day. He doesn't want to divide it up. Is there any reasoning behind that?
Yeah, that is really standard. It seems unfair to one party or the other to divide it up. I mean, Brockler would be way upset if he had to leave, with the jury go home for the night thinking about Dan King's argument. He wants them thinking about his second argument, and he has a right to think that. So rarely does it get broken up. I have tried, I don't know, way over 100 jury trials, and I've never seen it broken up in my career. Right. And so the judge is going to finish up and then send them home, bring them back first thing in the morning, and they'll begin to deliberate.
Okay. And that's an interesting thing. There is no court on Friday. It's one of the pre-selected days off, and the court spokesman, Rob McCallum, did tweet a little while ago in response to one of our colleagues that there is not going to be court on Friday. That's a pre-selected day off. One of the jurors had a commitment on the 17th. So they'll have 2 days. And I've already seen people on the chat room speculating about how fast they might reach a verdict in a case with 165 counts, 600 some odd pages of verdict forms, all of this evidence, 48 days of testimony and hearings and such. What do you think is the likelihood they'll be done before next week?
Not great, but 2 full days, it's possible. And here's what every trial lawyer knows. We actually talk about, we have a term for it, and that is Friday evening verdicts. So at the end of the week, and the jury just wants to reach a verdict and go home and not have to come back on Monday. So statistically, there's a whole lot of verdicts that come back late Friday afternoons. I don't know what the statistics are, and I'm sure it's still small, but more than any other particular time. So if you apply that to this case, that would be late Thursday afternoon, because there is no court Friday. But I don't think it'll happen. I think they'll have to come back next week.
You think it's going to last into the week of the 20th?
I do, but as I said earlier, this is like
No way,
reading
yeah.
tea leaves.
Yeah.
There is no way you can know. There's no guidelines on this. The jury can go as long or short as they want to.
All right. Well, we're going to interrupt your tarot card reading here because court has resumed, and we do expect George Brockler to deliver his rebuttal now.
Yes.
All right.
We want to see it.
Back on the record, this is the people of the state of Colorado versus James Eagan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Are the parties ready for the jury? Yes. Okay, let's bring the jury in, please. Mr. Brockler, by my calculations, you have 25 minutes and 30 seconds for rebuttal. Oh, and for the record, the question that was submitted by the juror earlier, we will mark it as Court Trial Exhibit 87. The envelope related to D-TR-84, we will mark as Court Trial Exhibit 86. Right?
Yeah.
That's the envelope that we spoke about at the bench.
I believe you said 84, isn't it 94?
Oh, excuse, did I say nine? Okay, if I said 84, yes, that was wrong. It was D-TR-94. Thank you for correcting that. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Mr. Brockler, do you have a rebuttal closing argument?
I do, Your Honor. Thank you.
All right, you may proceed.
Thank you, Your Honor. About 45 minutes, I think that, oh my God, I'm not going for 45 minutes. It was about 45 minutes that I think I lost count of how many times my name was referenced as the reason why something had gone wrong in this case. We heard for another 45 minutes about why the defendant should be considered mentally ill. There was some other time discussing things that took place in November, an example of an MRI presentation that was never admitted that was published to you on up, and then in the last 5 minutes we heard how all of this means that the defendant did not know right from wrong when he walked into that theater to massacre all those people. It's hard to know where to begin. There's a lot of different moving pieces there. But what I want to start with is this. Every single thing that you were just asked to consider, every piece of it was considered by Drs. Metzner and Dr. Reed. There's no information that they did not have or make themselves aware of or make available to themselves before they rendered their opinion. And what's interesting is there are times when Dr. Reed's opinion is to be held out for you, when the defendant says something on video that is supportive. But when it's hurtful, or it's painful, or it supports the idea that he knew right from wrong, then we criticize him for when he did the interview and how he did the interview. And I guess what I'd like to do is to take the video of Dr. Reed and his interview style and compare it to that of Dr. Gurr. But we can't do that because she didn't do a video. All we know is that the doctor they rely upon for insanity is the one who misquoted, who mistranscribed, who didn't do much at all before that first opinion, and did it in such a way that on the stand here was able to say repeatedly, well, I just didn't document it. Of course, I passed it, and I did it, and I considered it, but I didn't document it. We never, ever had that issue with Dr. Metzner or Dr. Reed. And despite what's been presented on the screen to you as their bases for sanity, and they both say he is sane. You rely on your notes, and that's true for what I say too. Absolutely do not take what I tell you to the bank. Don't rely upon what I say. I'm just a guy up here making an argument about what I think the evidence is. You're the ones that took the notes. And either what I'm telling you rings true or it rings hollow, but that's up to you to make that decision. The first thing is, all this stuff, it isn't a surprise to Drs. Reed and Dr. Metzner. And they came back and said, this guy was sane when he pulled the trigger over 70 times into human beings. One of the things that was argued to you was this idea that things were illogical or they were irrational. Well, I want you to think about all the evidence in this case. Every decision, every plot, every plan that this guy hatched. But for wanting to murder human beings, but for that, where's the irrational decision? Where's the illogical decision? Every single decision he made was to move forward towards this horrendous, horrific, as he put it, evil goal. That's not disorganized. That's not disorganized in speech or in thought. None of it. The question was raised, well, it's so illogical that he went and saw Dr. Fenton. Why would he do that? He told you through the video of Dr. Reed, through Dr. Metzner, through all of his statements, why did he go see Dr. Fenton? You know it. He wanted to rid himself of the anxiety, that social anxiety that had not only plagued him throughout his life, but has now manifested itself in his failures at presentations, his failures at lab work. And that's why when he tells Dr. Woodcock 4 days after the mass murder, you know what, the homicidal ideas, they didn't really bother me. He went to Margaret Roth looking for a fix. He went to see Dr. Fenton looking for a fix. And inside that notebook, he tells you it didn't work. But then he keeps going, and now we know why. Because when he talks to the other doctors, Dr. Metzner, he says, I couldn't just quit. It'd be too conspicuous. I'd already set my mind on killing these people. That's why he keeps going. And you know what that is? That's rational. Evil, but rational. What was the evidence that the defendant thought what he was doing was morally okay? I spent a good chunk of that opening, closing statement talking to you about every person in his life that he deceived to keep them from finding out what he was doing. And it wasn't because he knew it was illegal. Where is that singular act other than doing it that shows that he thought it was right? You know, we talked about a couple hypotheticals in here with some of these experts. Had this guy, after breaking up with his girlfriend or failure at the prelims, if he goes to a sporting goods store and he goes and he buys that AR-15 and he buys the magazines right there, doesn't try to spread out the purchases to avoid suspicion, buys the ammo right there, locks and loads, walks right across the street to the Century 16 Theater, walks right in, open and notorious to everyone around him, and opened fire, we would all think that's not normal. Clearly that there's something wrong. And that guy would argue, well, I thought it was morally right for me to do this. Dr. Metzner, in fact, gave us the best example. He said, how is it that someone could think something was illegal and yet at the same time think it was morally okay? And he talked about a delusion where a guy believes that his neighbor is plotting to kill his family. Clearly not true. Clearly, factually, provably false. But he goes ahead and kills his neighbor because of that delusion, even though he knows it's illegal. There is nothing like that here. This guy's delusion, and it's been described by Dr. Gurr in so many different ways. I don't know how we can argue that it's consistent. I mean, is it because the end of the world, she's doing someone a favor? It's the inevitable catastrophe, increase his value. Here's what we know. This idea of this delusion having to be fixed and false, it is neither. How can you say that this guy doesn't value himself more today after murdering people? He does. That's what he said. That's not false. This isn't a guy who says, I think I get a gold bar in my bank account every time I shoot someone in the head in a theater. That's the kind of delusion that we could say, okay, that is provably false. This guy says what makes me like me more is homicide, is killing people. And we're told then, well, that's a value nobody agrees with, therefore it's delusional. But what it doesn't change is the fact that he knows, despite his wanting to do it, it is morally wrong. Mom and dad don't get to know the truth. In fact, they sense nothing. Even after the call from Dr. Fenton, they're going to wait 2 months to come out because this doesn't seem so out of the ordinary. His girlfriend, the woman he loves, when she rebuffs him on this philosophy, he leaves. His friend leaves. What is the singular action other than him doing this horrible crime that says he thought it was morally okay? There's nothing. Every single thing we talked about in that opening close makes it clear. He knew everybody. Everybody. Mom and dad, Gargi and Ben, neighbors, shop owners, the people in the theater. Everybody would view what he was doing as wrong, and not just because there's a statute about it, because it's morally wrong. Quick thing about malingering here. There's a ton of tests that they did, a ton of validity tests that they did, and they all told you the same thing, those people that did them. They measure his testing right then and there. The symptomology that he puts out right then and there. And that's fine. But you know what none of these tests were able to do for us? They're not able to explain to us this burgeoning memory of shadows, of these hallucinations. They start as a flicker, as fleeting, and you see them change with each mental health person he talks to. With Woodcock, it started in undergrad. Then we hear, no, actually, it never happened before until my third rotation in graduate school. And it goes from flickering and then some beetle-like description all the way to, if you remember, from I think the third or fourth time Dr. Reed asked him, it became shadows that looked like people, and they were dancing. And then they were juggling. What were they juggling? They were juggling sword axes and sword guns. And all along, Dr. Reed keeps asking him, doesn't this concern you? And he seems to get the message from the question and then says, oh yeah, and yes, it did bother me, and they were juggling heads. And by the time Dr. Gurr comes back to interview him, and this is remarkable too, we're told that Dr. Reed's videotaped interview of August of 2014 is suspect because of how much time has gone by. And yet Dr. Gurr, the bulk of her interviews, the bulk of her notes came after that. And she relied upon that to bolster her earlier June 2013 opinion. But by the time they get done, he's got all these differing shadow things going on. Now, I don't know if that's made up, but what I know is none of these malingering tests seem to be able to prevent it. A call for action. In June of 2013, he says it repeatedly to Dr. Gurr. In August of 2013, he denies saying it at all. Malingering tests don't seem to be able to catch that either. There is an image I want to show you from the notebook, and the notebook is interesting because what you have to ask yourself is, who is this really for? We know what Dr. Fenton, we know Dr. Fenton's role, right? He says, I sent it to her because I wanted her to know how to fix people like me in the future. If that were true, that would be an acknowledgement that what he was going to do was wrong, and he wanted to have her help stop someone from being wrong again in the future. Not legally, morally. But it's interesting that inside the notebook, he actually addresses it to Mom and Dad and his sister. And when he sends it, it's after he's posted, "Will you visit me in prison?" Now this notebook, is this the kind of thing that he thinks is going to stop with Dr. Fenton? He could have mailed it to Mom and Dad, but he doesn't. He could have left it in the apartment that he really didn't think was going to go up in flames, but he didn't. He mails it to Dr. Fenton. Any chance that there's some impression management going on in this thing? If you read this, this is far from disorganized. In fact, Dr. Gurr, and remember, these are the negative symptoms, disorganization, and she described them. Sentences that just end. Made up words. Gibberish. Hard to move from one thing to the next. And yet in this, as with every other email and text and paper that he wrote from start to stop that year, there's not a whiff of it. Not a whiff. We're told too that catatonia is a sign of this advanced mental illness. And yet there's not a whiff of it. None of it. Anywhere. And then that's dismissed. And we're told, sometimes this stuff, one of the notable things is people will stop taking care of themselves. Poor personal hygiene. Not any of it. Anywhere. But when you look at this, the way he lays this out on the second to the last page, not the penultimate page, but whatever that is called, that is the one before that. Can we make that show up there? Long after he has calculated the best way to kill people, long after he's gone through the theaters and talked about which is the best one, and he's waxed philosophical about things from the blind can see and the butterfly effect. And by the way, it's all philosophy in there. There's nothing disorganized about that. Right towards the end, he writes this: research firearms laws and mental illness. Why in the world, at the end of this notebook, would he make a note about researching firearms laws and mental illness? I don't know. Thank you. You can take that down. The difference between the experts here is a matter of expertise, effort, and corroboration. Dr. Woodcock made no effort to corroborate anything. That's why he only watched 30 minutes of the Dr. Reed video and reviewed very few records, because remember, he's very busy. Dr. Gurr, same thing. By the time she opined in 2013, she had documented reviewing nothing. But by the time she testified here, she'd reviewed everything. She just hadn't documented it. The issue with cross-examining Dr. Gurr is when someone doesn't document what they've done or they misdocument quotes or what's been said, it's hard to cross-examine them on that substance. It's like being in quicksand. So we end up having to talk about all the other issues related to why she didn't do a better job. You can see him zipping through here. One of the things that was said right at the end here by right at the end by defense was that this guy had no interest in doing this for any other reason. It had nothing to do with being remembered, and that there was no evidence of that. You will recall from Dr. Reed's interview of the defendant that being remembered was huge for him. In fact, in the notebook, Dr. Reed asks him, "You made a notebook that has to do with how you'd be remembered." And he wrote, "Right." He also, here we go, PowerPoint. Can I get that up there? Everything about this guy is self-centered and self-focused. It has nothing at all to do with any sort of mental illness. Gargi told you that. She said the most important person in the world to the defendant is the defendant. And you know where that sort of subtly showed up? Was in an interview with Dr. Reed where they talked about that Valentine's Day dinner. Do you remember that? And he made the chicken with the crunchy stuff on it and all that, because he liked it. And then he asked him, "Did you do candles?" And he goes, "I did candles." And he said, "Did you do candles because Gargi likes them?" And he said, "No, I did candles because I like them." That theme recurs everywhere. Read the texts. Read the notebook. This guy is absorbed with himself. He's desperate to be remembered, and he's desperate to be wanted. If it can't be by Gargi, he'll try Hillary. If it doesn't work with Hillary, he's flirting with her. No matter what Dr. Gurr says, come on. You don't go twice after the same girl about shorts and talk about how hot she is and not have interest in her. That's not social withdrawal. The selfies. Remember what he tells Dr. Reed? The black contact lenses, they just happened to arrive the day of the shooting. And he starts to take these pictures. Dr. Gurr told us the pictures were to show how easy it was for him to accumulate weaponry. Well, we know that's not true. He says they'd look good to whoever viewed them, to Dr. Metzner. Reed asks him, "You took selfies that had to do pretty specifically with how you'd be remembered." "Right. I don't think people are going to remember me for any other reason." It's unusual to have dyed hair like that and contact lenses like that. More likely to remember something unusual than something mundane. I tested it first, wearing it all, put the slings off and on, and I looked at myself in the mirror, and there's the picture he took. It's important to me to be remembered. Is it important for me to be remembered? I'd say yes. And thus the New York Times, from his phone. Never ends up doing it, but this is where his head is. Someone needs to see what I've been able to pull off. I put it in the notebook and mailed that, but they got to see these pictures. The last page of the notebook, way down at the bottom, he references the reader, and could this possibly be for Dr. Fenton? classicjimbo.squarespace.com. Now, he never ends up uploading these pictures to it, but this is where his head was when he was thinking about being remembered. And for a guy that wants to be wanted, for a guy that wants to be remembered, for a guy who is willing to kill to increase how he feels about himself, it's paid off for him. Because all that attention that he sought before the murders, it's all coming to him now. This is success. This is his payoff for murdering people. And he knew it was wrong on every single level except the one he cared about the most, and that was himself. But I'm not asking you to remember this. I'm asking you to remember this. On July 19th and 20th, 2012, this guy right here, with hatred in his heart, and it is in everything that he has written before he goes to jail. In fact, he tells Woodcock, I hate everybody. With hatred in his heart and the belief that he would value himself more based on how many people he killed, knowing full well not another person on the planet Earth would buy into this abstract, theoretical, the words he used with Dr. Reed, theory. He armed himself to the teeth over 2.5 months, thought of every contingency, even plotted potentially getting away, went in there and just killed people, left and right, and kept pulling the trigger and only stopped when the gun stopped. Thank you. Go back and talk about the things that were raised here. Do it. But when you consider this guy's capacity to know right from wrong, it's not the diagnosis. It's not November 2012. It's not a non-diagnostic MRI from a couple months ago. It's not the expert opinions of two people who are neither forensically trained, nor did they invest the time and effort into getting this thing right. At the end of the day, even without the mental health experts, you know that he knew what he was doing was right and wrong. Not guilty by reason of insanity is saved for people that don't know they're around people, let alone killing people. They're reserved.
Actually, that's a misstatement of the law, Your Honor.
Why don't you rephrase, Mr. Brooklyn? I'll sustain the objection. Rephrase.
Thank you. This is argument, right? When you read those instructions on not guilty by reason of insanity, it's not intended for some nuanced viewing of, is it possible that he only thought it was illegal but really believed? That's not what that instruction's about. We know what insanity is based on the words in those instructions. This ain't it. He knew what he was doing when he killed those people. He intended to kill them. That was his specific goal. And when he went in there, and by the way, he didn't have to intend a specific individual. He intended to kill each of them. And when he went in there, didn't care how many he killed, didn't care who he killed. It was just about killing. Grave danger, extreme indifference to the value of human life. This guy gets held accountable. That's what the evidence says. Not because I say it, because that's what the evidence says. And so do two court-appointed, state mental hospital-picked doctors who this is what they do. And they both say the exact same thing. Sane. 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 Guilty. Thank you.
All right, members of the jury, this is the time in the proceedings when I have to announce to you who the deliberating jurors are and who the alternate jurors are. I want to remind you that this is not based on trial performance and that the attorneys and I had selected some seat numbers way in advance of the trial, and that's how we decided who the alternate jurors are and who the deliberating jurors are. Just to make sure we're all on the same page, and because we're not using names, I'm going to ask you to stand up when I mention your seat number and juror number, all right? And first I'm going to read the deliberating jurors. So the 12 deliberating jurors are as follows. Seat number 1, juror 640. Seat number 2, juror 17. Seat number 3, juror 329. Seat number 5, juror 535. Seat number 6, juror 87. Seat number 11, juror 118. Seat number 13, juror 378. Seat number 14, juror 155. Seat number 15, juror 527. Seat number 17, but temporarily sitting in seat number 18, juror 737. Seat 21, juror 557. And seat 23, juror 311. All right. Everybody who stood up are the folks who are the deliberating jurors, and that matches my list. All right, I'll have everyone sit. Thank you. The alternate jurors are the juror sitting in seat number 4, that's juror 661. You don't have to stand as long as you're acknowledging that you know that's you, and juror 661 has acknowledged that. The juror sitting in seat number 10, juror 1009, and she's acknowledging me as well. The juror in seat number 12, that's juror 983, he's acknowledging me. The juror in seat number 16, juror 673, she's acknowledging me. The juror sitting in seat number 18, but temporarily sitting in seat number 17, that's juror 706, she's acknowledging me. Seat number 22, that's juror number 307, and she's acknowledging me. And finally, seat 24, juror number 313, and he's acknowledging me. All right. Now, I just have a few more remarks before I let you go home for the evening. First of all, alternates should not feel like this has been a waste of time for you. We could not have done this without you. That's number one. Number two, we may still need you, so you need to continue to follow my admonishments. For example, if one of the deliberating jurors becomes unavailable during deliberations, it's possible that that we would need you. So you need to continue to abide by all my admonishments, please. As far as each alternate knows, he or she may be next in line. You don't know who's next in line, but one of you is next in line, and I can tell you that we've already used more than one alternate juror. So for those of you who are alternates, you need to continue to comply with all my admonishments and all my instructions. The alternates must leave their notebooks and copies of their instructions either in your locker or in one of the two smaller jury rooms that you've been using. Because those two are not going to be used by the deliberating jurors. So as long as you don't leave your notebook and the copy of the jury instructions in the 201 jury room, then that should be okay, and my staff will assist you. Please do not take your notebooks or your copies of the instructions with you either home or anywhere outside the courthouse. Certainly do not take them to the room where you're going to be staying while the deliberating jurors are deliberating. To make it easy on everyone, let's just plan to have everyone here at 9 tomorrow. Is that okay with everyone? That it's late tonight, this gives you a chance to sleep in a little bit. So let's have the deliberating jurors show up. You will show up the same as usual, and you will be using the 201 jury room. That's the jury room behind me. The alternates will show up in a different place, and my staff will give you instructions about that tonight, and they'll tell you where to park. You'll park in a different place, and then you'll be staying in a different room. You may want to bring appropriate books and games, puzzles to keep yourself busy while you wait for the deliberating jurors. As I indicated to you the other day, this is not my doing. The law requires me to keep you here, you alternates, while the deliberating jurors are deliberating. We will have lunch brought in for you, just as we will do with the deliberating jurors. For tomorrow, let's have everyone here at 9, as I said. And then from there on out, if the deliberating jurors come back to deliberate the next day, then you can select the time when you want to come back. And it's up to you as to what time you select, as long as you all agree upon it, and as long as you communicate that to my staff so that we can coordinate with the alternates and let the alternates know what time to be here the next day. All right? Does that make sense to everyone? In terms of how late you can stay here every day, the courthouse closes at 5:30, as I said. So, and you all have to agree, when I say all of you, I'm talking about the deliberating jurors, as to the time of day when you want to go home, and then communicate that to us so that we can coordinate it with the alternate jurors. Please keep in mind what I've mentioned before, that once you reach your verdicts, I will need to have you wait 3 hours before I can announce the verdicts here in the courtroom, to allow everyone a chance to get here. So keep that in mind. That's for the deliberating jurors. But again, we'll have to coordinate. My staff will coordinate with the alternate jurors. All of the admitted exhibits, with the exception of live ammunition, will be sent back to the jury room back here for courtroom 201 for deliberations. You've seen most of the admitted exhibits, but I've been telling you throughout that you would have an opportunity to see anything again that you wanted to. And so we will have all of the admitted exhibits sent back to you for deliberations in case you want to see anything else, or see something that you haven't seen yet, or see something again that you've already seen. That's entirely up to you. We will provide gloves for you in case you want to use gloves. Keep in mind that the exhibits that were marked and rejected by the court are not part of the evidence and will not be sent back to the jury room. The exhibits that go back to the jury room are only the exhibits that were actually admitted into evidence. And there were some, by the way, that were marked as exhibits with exhibit numbers or letters, but they were not offered into evidence. And so the same ruling or the same thing applies to those. If they were not offered, even if I did not reject them, they just weren't offered into evidence, and those do not go back to the jury room for deliberations. I want to remind you that there are a couple of you who are unavailable on Friday, July 17th. That's Friday of this week. So we have to take Friday of this week off. So if there's no verdict at the end of Thursday, we'll just plan to have everyone return on Monday, July 20. When you go home, this is for the deliberating jurors, when you go home at the end of the day, all the admonishments that are contained in instruction number 1 that I read to you today, those all apply to you. When you go home at the end of the day, after a day of deliberations, I'm not going to bring you in here to remind you about those admonishments. I am trusting that you will comply with all those admonishments. And they're a little different than what the admonishments were before, because before you were not permitted to deliberate. Now you are permitted to deliberate, but I remind you that you can only deliberate when you're all together, all 12 of you, and only when you're in the jury room. So you can't go home and deliberate on your own individually. And if someone steps away, say to go for a smoke, you can't continue to deliberate. You have to wait till all 12 of you are present, and you have to wait till you are in the jury room. Now, you can deliberate during lunch if you wish, because we're going to have lunch brought to you. So that's not a problem. Again, as long as you're in the jury room and as long as all 12 of you are present. But it's a good idea to review my admonitions in that instruction number 1 that I gave you earlier today for all deliberating jurors, because those are the admonitions that will apply to you as long as you're deliberating. In terms of the alternates, with respect to you, the admonishments are a little bit different because you're not allowed to deliberate. And so let me go through them, and we will also have them in the room where you're going to be staying. There's going to be a blow-up containing all these advisements, but let me just run through them real quick just to make sure the alternates understand that these are the advisements that apply. Number 1, please do not discuss any aspect of the case with each other through any means. You're free to talk with each other, but not about the case. You're not allowed to deliberate in any way or discuss any aspect of the case. Number 2, in addition to not being able to discuss any aspect of the case with each other, you may not communicate about the case with anyone else through any means. All you can tell people is that you're a juror in a trial in Arapahoe County that is expected to end at the latest in August. Number 3, you may not have any contact or communications with any jurors who have been dismissed or with jurors who are deliberating. Number 4, please do not talk with any witnesses, parties, or attorneys about anything, whether related to the case or not. Number 5, to make sure that witnesses, parties, and attorneys do not talk to you, it is imperative that you wear your juror badge whenever you're on the courthouse premises and that it is visible to everyone around you. Your juror badge will also reduce the risk that people will talk about the case in your presence. If you hear anyone talking about the case, please remove yourself from that location. In the event that, despite your best efforts, you hear something about the case, please let my staff know that you want to talk to me. Number 6, please do not talk to any members of the media about anything until these proceedings are completed. Number 7, you must not read, view, or listen to any news or media reports that may refer to this case. Because there's media coverage of this trial, please be particularly vigilant while listening to the radio, watching TV, reading the newspaper, and using the internet or any electronic device. Number 8, you cannot visit any locations mentioned in the case, nor are you allowed to conduct your own investigation outside the courtroom. This includes consulting outside references in relation to the case. Number 9, all decisions in this trial must be based solely on the evidence presented in the courtroom and the instructions of law that I provide. And number 10, you cannot form any opinions about the case or deliberate internally, privately, about the case. You must resist any temptation to deliberate. One more thing for the deliberating jurors. In terms of deliberations, jurors sometimes want to know about time limitations. There are none. There's no minimum, there's no maximum. It's entirely up to you how long your deliberations take. Does everyone understand that? Everyone's saying yes and not in their head yes. At least the deliberating jurors are. Okay, in a moment, I'm going to give an oath to my bailiffs. And then after that, what we're going to do is we're going to have the alternates exit the courtroom first so that you can retrieve your things that you may have in the jury room here in 201. You should take out anything that you have in there, and my staff will escort you in there, and then also give you an opportunity to put your notebook and your copy of the instructions in a locker or in one of the other two in one of the other two jury rooms. You're not deliberating, all right? And then my staff will have further instructions for you, and will take you to the room where you're gonna, to the place where you're gonna show up tomorrow, and tell you about the room where you're gonna be staying while the deliberating jurors are deliberating, okay? All right, if I could have all the bailiffs, please, so that I can administer an oath. And Ms. Zagel's not here. When she's here tomorrow, I will administer the same oath to her tomorrow in private. All right, if I could have everyone raise your right hand for me, please. And there are two oaths. The first one is, do you solemnly swear or affirm under penalty of law that you will keep the deliberating jurors together as order, that you will not permit any person to speak to them, that you will not speak to them yourself unless by order of the court, or to ask them if they have agreed upon a verdict, and that when they have agreed upon their verdicts, that you will return with them into court? Please say, I do. All right. The second oath is, do you solemnly swear or affirm under penalty of law that you will keep the alternate jurors together as order, that you will not permit any person to speak to them, and that you will separate them from the deliberating jurors and will keep them apart from the deliberating jurors until the deliberating jurors have reached their verdicts, and that when the deliberating jurors have agreed upon their verdicts, you will return with the alternate jurors into court? Please say, I do. All right, thank you. All right. All right, folks, at this time, I'm going to ask the alternate jurors to step out of the courtroom, please, and then you can retrieve your things from the jury room that's behind the courtroom, the 201 jury room. Please be seated, everyone. We'll just wait a couple of minutes and give the alternate jurors a chance to get their things and to do the things that I mentioned. So if you want to just relax for a couple of minutes. One other thing that I want to remind you about is, in addition to the exhibits, we're going to send the original instructions, jury instructions to the jury room, to the deliberations room. So they'll be there tomorrow. And same thing with the original verdict forms. They'll be there by the time you're in that room tomorrow at 9, okay? And Ms. Robinson, if you could let me know, please, when it's okay to release the deliberating jurors, I will do that. Once I release you folks, this is for the deliberating jurors, my staff will have further instructions for you, but you'll be using the jury room for courtroom 201, which is behind the courtroom. But generally speaking, you will follow the same sorts of procedures that you've been following all along, even including your parking area and that kind of thing, okay? And like I said, for tomorrow, let's plan on having you here at about 9 o'clock in the morning. And then at some point, my staff will distribute some kind of menu so that you can select what you want for lunch and we'll do the same thing with the alternate jurors separately. Would counsel please approach for just a moment? Ms. Robinson, not yet? Okay. All right, folks, thank you for your patience. Hang in there. It's, I know it's late, but I appreciate how patient you've been. It should just be another minute or so. Okay. Yes. Here another hour or so. All right, at this time, I'm going to go ahead and release you for the evening. Get some rest tonight. It's been a long day. It's almost 6:30. You got here before 9 this morning. You've been very patient throughout. Please make sure that you follow my advisements overnight, and the advisements are the ones that are in instruction number 1 that I gave you earlier today. Leave your things here, your notebooks and the instructions. You can't take them home, and that applies throughout. You have to leave your notebook and the copy of the instructions here. Certainly, you can't take the original instructions or the original verdict forms out of the jury room. They have to stay in the jury room, but the same thing applies with respect to your notebooks and your copies of the instructions, all right? So you may be tempted when you get home to want to start deliberating about the case internally. You have to resist that temptation. You cannot do that. You can only deliberate when you're all 12 together and you're in the jury room, okay? Have a great evening, folks. I'll see you tomorrow. Well, I may not see you tomorrow. Have a great evening. Thank you. Please be seated, everyone. The record should reflect that all of the jurors have now exited the courtroom, and so we're outside the presence of both the deliberating jurors and the alternate jurors. In terms of counsel, what I would like is, number 1, for you to leave good contact information with my staff in case we need to get a hold of you. And number 2, I would like you to be available, if at all possible, within 15 minutes or so. I don't want to have to wait a long period of time in case, for example, there may be a question or something comes up with the jury. So if you can be available within about 15 minutes or so, I would appreciate that. Is that a problem for the people?
Do you need all of us available within 15 minutes or just one of us?
Just one of you. As long as you're comfortable proceeding with whoever's here, that I'm comfortable, so.
We can do that. I have one request, Your Honor.
Yes.
Different judges do this differently. I think it works better this way. When and if there are juror questions that need to be assessed and answered, my request would be that when we get the phone call, that the court staff tell us what the jury question is. Some judges like to make us wait and not let us know until we get here, but it gives us time to think about it and maybe do some research and consider what our position's going to be.
My practice is not to tell you over the phone and to make you wait, and so that's what I'm going to do. And I'll tell you also that my practice is to have a proposed response by the time you get here. So that tends to, I find that if I can focus counsel, it helps. And I find that if we just start with an open discussion, then we can go in all kinds of different directions. So that's my practice, and that's the way I'll handle it, okay? So when you get here, and when we're ready to go, then we'll have a copy of the question for each of you. If you need time to think about it, I will give you that time. So I don't think it's fair to just surprise you and say, give me an answer now. If you get the question when I'm here and you say, Judge, we'd like some time to think about it and think about the proposed response, then I'll give you that time. I'll give you as much time as you need, okay? So.
Okay, Your Honor, it's your courtroom.
It is. Mr. King, does it work for the defense to be available within about a 15-minute time frame?
May I show up in my pajamas?
You can show up however you want, as long as you show up.
Yeah.
Or somebody shows up. It doesn't have to be all of you, but somebody that you're comfortable having here. Of course, your client has to be here as well, but the sheriffs will take care of that.
That's fine, Judge.
Okay. All right. Is there anything else at this time on behalf of the people?
Your Honor, at the, when the jurors leave for the end of the day, would the court let us know so that we know we're free to leave too?
So you know you're free to breathe? Yes. I will have my staff contact you and let you know when the deliberating jurors have gone home for the day. And that will be for both sides, obviously. Is there anything on behalf of the defense that we need to talk about at this time?
I just have one request for the court regarding the PowerPoint presentations that were used actually during closing arguments as well as opening statements, because I don't think that we did this for the openings, although I could I may not be remembering, but I would ask the court to order both parties to put the PowerPoint presentations that they used on CDs and submit them as court exhibits so that they've been made a part of the record for appellate purposes. I don't recall whether there were any objections that resulted in any alterations of the PowerPoints used during opening. Today, of course, there were, and so my request would be that the prosecution submit at least the thumbnail of the original, a copy of the thumbnails that the court used to make its rulings earlier, as well as the actual PowerPoint presentation that was used during closing. And my request would be that it be placed on CD so that we actually have the video and all of the moving parts of the PowerPoint properly in the record.
Do the people have any objection to that?
We were changing things on the fly. I'm pretty sure we can do that. If we can't, we'll let you know, Your Honor.
Okay, great. All right, that request is granted. Anything else? No? All right, get some rest. Thank you. The court will be in recess.
Please rise.
This is it. Yeah. You took the chairs out, this actually goes on top of the chairs, the black thing goes. So that has to be. Evening, and thank you all for staying with us through this very long day. We do want to do a brief wrap-up since we still have our expert Dan Recht here with us in our 7 News newsroom. And Dan, let's start with the thing that we ended with. Let's start with the selection of the deliberating or the voting jurors. And Andrew, if you could, would you please pull up our jury box, our digital jury box, which is available for all of you on the denverchannel.com or inside your 7 News app. And let's look through, if you will, and Dan, stop me at any point if you want to make a comment that any of these jurors' backgrounds could be or could not be valuable. But let's start with the fact that there are 9 females and 3 males deliberating on the jury. Does that have any significance to you?
It has some statistical significance. It's generally true that women are more willing to consider mental health defenses than men. So there's a slight advantage, I think, to the defense that it's loaded with women, 9 women and only 3 men.
So juror in seat number 1, it's juror number 640, a Caucasian woman, a plumber, member of a union, age 40s, kids in the military. The next seat that's involved, and stop me at any time if there's anything significant, seat number 2, juror number 17, again a Caucasian, middle-aged. She is an attorney. Is that significant to you?
Absolutely.
Okay, in what way?
Well, remember King's argument is don't let emotion sway you, focus on the law. The law is above emotion and you have to apply the law, and presumably the lawyer will be more prone to do that than a layperson.
Okay. The next seat here, number 3, a woman, from looks of things, our reporters in the court said possibly Hispanic, which would make her one of the rare minorities in this group, if that's accurate. Approximately in the 30s, believes in the right to a fair trial, a former victims advocate. I don't know if that's of interest.
It is. That bodes well for the prosecution. I mean, there were a lot of victims in this case, and there's a mindset that victims advocates can have, and at least for some of them, it's sort of a wooden sort of mindset where they are always on the side of victims and their families, which would mean being pro-prosecution.
Right.
So again, that's just sort of a statistical analysis, but it helps the prosecution, I would say.
The next seat is seat number 5, a Caucasian woman whose niece survived Columbine. So someone who has experience with gun violence in her family. Certainly, we spent a lot of time talking about there were 2 Columbine-related jurors, one who survived himself and this number 535 who had a niece involved in that mass shooting. What do you think that bears and which side does it help?
Yeah, you know, I'd need to know more about this person. I mean, that one fact alone, probably better for the prosecution than the defense, it seems to me. Very sensitized to victims and how much they suffer.
All right. Our next seat, Dan, is number 6. That's juror number 87, who made this interesting statement that Marshall and Mark and our other court reporters wrote down in their notes, that she believes in an eye for an eye. Our next seat, then...
Well, that's terrible for the defense. I mean, an eye for an eye is to execute him, of course.
Right. Our next seat, and I will point out, so far no men in the list that we've gone through so far. Juror number 118, seat number 11, age somewhere 40s or 50s, a physicist who specializes in explosives, a competitive marksman. Certainly firearms and explosives are central to this case and her expertise there. I guess, is it possible? I mean, I know that they're not supposed to weigh someone's expertise over another juror's expertise over the evidence that they heard, their notes that they took, but with an attorney on the jury so far, with an explosives expert, a competitive marksman, is there possibility for jurors to be relying on each other as experts?
Yeah, I think you can bring your life experiences into the jury room. The court says that. You don't have to leave those by the door. And if he has insights into firearms that seems interesting to the jurors, that's not inappropriate. But again, at least the defense's perspective is none of that's relevant. We admit he did all of this. And so the question is just sanity or insanity.
Sure. Next seat on our list here is number 13. Another woman, a 20-year paramedic who says she has experience treating the mentally ill. Any thoughts there?
Yeah, sure. That helps the defense. The defense needs people that are sensitive to mental health issues and don't think that, like some people do, that mental health issues is just a bunch of gobbledygook. So she's probably helpful to the defense.
Next, we're on to seat number 14, juror 155, the first gentleman on this deliberating panel. Was not even in Colorado at the time of the shooting, a recent transplant, so to speak. Does that help or hurt either side?
Well, I would guess that he hasn't been as inundated with all of the news and therefore a little less subject to predetermining how he feels about things. And that might help the defense, I suppose, because anyone that has predetermined their view of this before they hear both sides and before they hear about sanity, thinks of James Holmes just as someone that did a mass killing, which of course he did.
All right. In seat number 15, we get to our second male, a store manager, mid-30s, Caucasian male. I remember in building this chart, we did not have a lot of information. We did not get many insights into his background during the process that our reporters had attended. So I'm not sure I have a great question to ask you on that one.
I have no insights.
Okay. Then let's scoot over to number 17, the third and last male on this jury, who is, and this was confusing, the judge said temporarily sitting in seat 18, but actually we're concerned with juror who is in seat 17 assigned. I remember there was a juror who was uncomfortable under the vent, and that's why they allowed them to switch places. This is the Columbine survivor, juror number 737. And let's go back to that conversation. He was in the building at the time of that mass shooting. Who does that potentially benefit in this case?
You know, I would say if I was the defense, I'd rather not have him on my jury, because one would guess that he's very sensitive to victims and victims' families and not wanting anything to further victimize them, including maybe having a subconscious view that guilty is better.
All right, just two more before we wrap this up and get ready to conclude our day. We have seat number 21, juror 557, who said during the selection process, mental illness is not an excuse. That's a significant statement, certainly.
Way significant, and certainly bodes ill for the defense, because that is their defense. They're not saying it's an excuse, but it's an explanation, and it's a defense. Right. And if she's not going to buy that, then that's trouble for the defense.
All right. And our last seat, our last deliberating juror, number 311 in seat number 23, a juror who says she's been on a jury before, will be respectful of her peers, but again, another Caucasian woman. That seems to be the majority of the makeup of this jury.
No particular insight into her.
Okay. Well, with that, I want to, we're going so long in our day. The judge thanked the jurors for being patient with him. I want to thank all of our viewers for being patient with us. I want to give you the opportunity to have the last word here. You've been with us all day. Do you have any final thoughts to share with our viewers about how this day of closing arguments went? What should we be thinking about as we wait for the verdict?
Yeah, I think both of the attorneys, George Brockler and Dan King, did very good jobs of presenting their arguments. They're both skilled, experienced lawyers. I think they did well with what they could from their positions. And it's an interesting case because there is no litmus test for who's sane and who isn't sane. And that's what this comes down to. I mean, they said it over and over, and it's true. It has nothing to do with who pulled the trigger. It's not a whodunit. James Holmes did this. Everyone agrees he did this. It comes down to whether he was sane or insane at the time, and whether the prosecution, importantly, proved that he was sane beyond a reasonable doubt.
Right. Well, with that, everyone, we're going to wrap up for the day. Thank you to you, Dan, to your partners, David and Rick, who've been helping us understand this trial since day one, providing insights that no one else is getting anywhere else. You guys have helped to make this coverage very important, very special, and very educational for all of us. Thank you. I'll try my best to rattle off a quick list here right now of other people who've helped us, because I think this is the right time to do some credits, but certainly Erica, Anika, Brian, Andrew, Amanda, Mitch, Kelly, my boss, Kim, our news director, Lindsay, our general manager, Brad, Carl, who helped us to plan this in the first place, John Stone, who helped us with switching and planning and booking you guys to work with us, Tyler, who was with us this morning, Mark and Marshall, who have been in the courtroom literally for years covering this case and been out on the scene on the days it happened. Dozens more names that I can't possibly recall at this point. Russell, I know, helped us. Lindsay helped us at times. I'm sure I'm blanking, and I should write them all a much more appropriate thank you note, but I want to make sure I memorialize them here. So thank you, and thank you to all of you for watching us since day one on this trial. Our plan is to put everything in standby mode. We'll be ready to start the moment the jury announces they have a verdict, and we will be ready with you waiting for that at that point in time. We are all on call and all on standby. So with that, we'll wish you a great night, a great evening, and do be on the lookout on the denverchannel.com, the 7 News app, and on our YouTube page /7 News Denver for that announcement when the verdict is in. Thank you. Have a great night.